ಅಷ್ಟೇ.
ಅಂದ್ರೆ ಅವ್ರು ಹೇಳಿದ್ರು ಇಲ್ಲಿ ಪರ್ಮಿಷನ್ ತಗೊಂಡ್ರೆ ಅಲ್ಲಿ ಕೊಡ್ಬೋದು ಅಂತ ಹೇಳಿದ್ರು. ಪೆಂಡಿಂಗ್
ಇವರ ನೀವು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಹೇಳ್ಬೇಕು, ಅದನ್ನ ಹೇಳಿ ನಿಮ್ಮ ಅರ್ಜೆನ್ಸಿ ಏನಂತ ಹೇಳಿ ಸರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಮೆಮೊ ಕಂಪ್ಲೈಂಟ್ಸ್ ಎಲ್ಲ ಆದ್ರೆ ಬರುತ್ತೆ. ಇವ್ರೆ ನೀವು ಸೆಕ್ಷನ್ ಆಫೀಸರ್ ಕೊಡಿ, ಕಂಪ್ಲೈ ಮಾಡಿನೂ ಅವ್ರು ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ಬಂದು ನನಗೆ
all memos to the court officer, only 230 matters will be mentioned.
Lots in the
What is urgency? When was the order passed? When was the order passed? Huh? Yes, no urgency. Yes. I said, is it? It has to be taken at 2:30.
The reason is this.
When did you file the writ petition? When did you file the writ petition?
This court has stayed the matter, but trial court is proceeding with the matter. It's quite a fresh suit. But operation of that order is stayed. But the trial court is telling, no. There's no stay of this particular original suit. Only the operation of that previous order was stayed. So therefore, I'll proceed with the matter.
What will happen if it proceeds one day?
It is posted for evidence.
It will give it to the court officer. It will come. Yes.
Lots in the FDP.
We'll see. You write the urgency. I will see. Yes.
In the FDP proceedings, my lords.
230 matters.
Yes,
I
my
said
lords.
specifically.
In the FDP proceedings, respondents have been placed ex parte and properties ordered for
When was
sale
the
auction.
petition filed?
Today, my lords. My lords, it is ordered for sale auction on 17th.
When was the order passed?
The order was passed in the 5/3/2026.
What were you doing? till
Yesterday, I have filed an application that we are ready to effect the share of the petitioner by purchasing his share.
now? No,
But
it is not. The urgency is not whenever you feel like.
we were placed ex
filing
parte,
the
my
writ
lords. We
petition.
were placed ex parte and sale auction was ordered, my lords. I have filed an affidavit.
Today. Give it
My
to
lords,
the
I have
court
filed an affidavit stating that we will buy the share of the petitioner, my lords.
Come, you have to file the writ petition, office objections are
My
to
lords,
be
17th,
complied
the
with.
auction is there, my lords. Kindly.
17th.
17th, the day after tomorrow, my lords. Kindly, my lords.
File it, you file it, it will come. It will come before 17th. If you comply with the office objections, it will come tomorrow itself.
My lords, today, 2:30, I will
Will not
come.
take up, yes.
My lordship, serial number 26, list number 2, my lordship. We have asked for police implementation of the order of police protection, my lordship. But yesterday also there was a galata in media and all, it is coming, Your Honor. They are assaulting and there is a lot of damages to the petitioners and the persons there, my lordship. Therefore, the matter today it is listed, may be taken today afternoon, my lordship. It's very emergency, my lordship. Today afternoon it may be taken, my lordship.
Today's, what is urgency?
Because galata is going on in the premises, my lordship.
When did you file the writ petition?
Property. We have filed in the last month, my lordship. And it was posted, today it is posted, my lordship.
2:30, yes.
Yes, my lordship.
Lordship, this matter was disposed of last week, 7th of last week. This was section 3 partition act preemption. This honorable court has passed an order saying the trial court, the executing court shall conclude the inquiry within a period of 1 month from 9/7/2026. My humble submission is the order has not been uploaded till date.
It is already, they'll do it today. It's already done, signed long back, yes.
Your Honor, in this court, my case is listed for 6 times, Your Honor, in this honorable court, but not
The
which.
cases which are
Your
listed
Honor,
100 times.
Please, no, Your Honor, I'm kindly permit for submit the written arguments, Your Honor, please, Your Honor. Written arguments,
Why?
because it is not reached, Your Honor.
So what the court will do, looking at your written arguments, court will pass order.
No, Your Honor, I'm kindly request, Your Honor.
No request, yes.
ಮೇಡಮ್ ನಮ್ದು ಹೊಲ ಬಿತ್ತನೆ
Are
ಮಾಡಿದ್ವಿ
you a part in person?
ಪಾರ್ಟಿನ್ ಪರ್ಸನ್ ಲಾಯರ್ ಇದ್ದಾರೆ ನಾವು
Then you can't speak if there is a lawyer for you. Yes, call the list.
May I, my lord? May I, my lord?
Seniors, no mentionings.
I understand, my lord.
Yes.
I'm sorry.
The
my lord.
advocates on record,
My
yes.
lord, may I
submit?
submit?
My lord, suit is okay. My lord, suit.
I said, I don't want to repeat it. If tomorrow, if this is what, if none of you are understanding, I will not listen to any of the mentions. I said 2:30 only to be mentioned, all memos to be given to the court officer.
ballots.
Why? Yes.
22/6 and 27/6 the repetition was filed, my lord. Today it is set down for arguments. My evidence has not been taken, my lord. My
From 27/6, what is happening? Fresh matters will always come in the next day before this court. If you tell the court that your fresh matter has not come till today, then I have to call for a report from the Registrar Judicial, what happened to your case. Shall I ask him? Shall I ask him? Then please don't blame the court. I will not take up. Yes, I know, no urgency.
Well, it's one
You
matter
filed
for
it a month
230.
back, you don't take, you don't comply with the office objections. When did you comply?
There's certain small objections that are left, my lord.
Then small objection is objection, small or big. Whenever you comply, then only it will come. Yes.
Well, it's one matter for 230, my lord.
Why?
One matter for 230,
Why?
my lord. My lord, the execution proceedings, my lord, I filed an application. Till date, my lord, though the court has passed an order, there is no detailed order, my lord, till date. Neither, my lord, I'm able to challenge the order, my lord. The court is not even passing
Order
the written.
passed.
My lord, order was passed on 1/7/2026, my lord, saying my application is dismissed. There is no detailed order, my lord, till date. Tomorrow, my lord, the execution.
My lord.
Yes.
File a receiving application.
Give it to the court officer, all vacated, no, don't mention, except 230 matters.
My lords,
On submission.
Call the list.
my lords, I'm for respondent number 2, my lord.
For pronouncement of order, serial number 1, CP was
Tomorrow,
Call the list.
The respondent.
The order passed 9 number in OS number so and so is set aside, and the compromise decree passed in OS number 1633 or 2006 dated 16/4/2010 is restored. The order will not preclude the respondents from executing the decree in accordance with law. Accordingly, the CRP is allowed.
serial number 2, Vipanath Kanani.
Writ petition is dismissed.
Serial number 3, serial number 3, Bhargav G.
Argument to
Appearing for petition.
Writ petition is dismissed.
For hearing on interlocutory application, serial number 4, RP Somshekaraya for petitioner, hearing Narasimhan,
First respond.
respondent.
Yes.
In this case, my lord, petitioner is the owner of the property, my lord, constructed building about 40 years back, my lord. Since the
What is the suit for?
suit for, my lord, suit for injunction, my lord.
You're
Suit-
the,
I am the owner of the building.
You're the
neighboring
plaintiff or
owner,
the
my lord-
defendant?
Please, my lord.
you're the plaintiff.
Yes, my lord, I am
Yeah.
the plaintiff, my lord. The neighboring owner, my lord, started putting up construction by encroaching upon my property, my lord. In this regard, my lord, I have lodged complaint to the corporation, my lord. Corporation, instead of taking action against them, my lord, they have issued notice, you have violated the building violations, constructed the building about 40 years back, my lord. In that view of the matter, my lord, I have filed writ petition before the Assam Court, my lord. The Assam Court, my lord, directed the respondent corporation and the respondent not to proceed with the construction activities, my lord. Despite, my lord, they have proceeded with the construction, and the Assam Court, my lord, directed them to submit report. They have submitted report only in respect of the petitioner, but not in respect of the respondent, my lord. Since I have made allegation against the corporation authorities before the Lokaayukta with regard to the illegal activities and other things, my lord. With the vengeance, my lord, they have notice issued, and some matter is pending before the Assam Court. Injunction order is granted. Despite now, they have proceeded with the construction activities. Therefore, my lord, I have approached the civil court and brought to the knowledge of the civil court with regard to the interim order granted by the Assam Court, with the trial court granted injunction.
How can you pursue two parallel remedies?
No, my lord, you can return to the. But in the writ, my lord, you can return to writ petition, my lord.
So how many courts have to decide your only request?
My lord, here, my lord, if there is encroachment and the other things, my
Impugned
lord,
order will understand from the order.
Please, ma'am.
Where is the impugned order?
please, my lord, you can return to the order passed by the Assam Court, my lord,
Yes.
in WP.
Page number. Where is the impugned order?
My lord, Annexure B, page number
Annexure B,
51.
page
Notice, my lord, is ordered to me. That is the order that is impugned. Suit summons, my lord, is issued. Page number 51, Annexure B.
In this interim order is granted.
Yes, my lord.
Yes, where is the order?
Annexure B is the order, my lord. Annexure B is the order passed by the trial court.
Page
Page
number
number
you can,
51.
you can give the page number. 20, you said?
51, my lord, page number
51.
51.
An order issuing summons, an interim order when?
Twenty-seven, 4,
29/4.
29.
I'll ask the court to decide the IA number 1.
Let that be done, but let this be vacated for the simple reason, my lord, that a report was, my lord, summoned by the coordinate bench of this honorable court and the writ
No,
petition
what we
that
do
read.
is, because right or wrong, he is having the benefit
My
of
lord,
an
he
interim order.
suppressed the facts before this.
That's what
honorable
I'm saying.
Please.
No, he is having the benefit of an interim order in the month of April. What I'll do is, because without expressing anything on the merits of the matter, let this matter be decided within 1 week from today. Till such time, let this continue.
My lord, for 1 week, I'll undertake.
happen is-
I'll undertake that for 1 week, I'll not put up construction. Let there not be an order from this honorable court,
Yes.
because this is the thing that will be, I am submitted there,
Yes.
please.
Please come. The present writ petition is filed. Questioning an order dated 27/6, not 27/6, what is the date?
21/4, 2026.
21/4/2026, wherein the petitioner herein has filed an IA, wherein the court has issued summons to the defendants. The petitioner herein is a plaintiff who has filed the suit for bare injunction. In that, he has filed an IA seeking ad interim injunction. And as the court has issued the suit summons without considering the IA, he has come before this court by filing the instant writ petition. A coordinate bench of this court, by order dated 29/4/2025, has passed an interim order directing the respondents not to put up any further construction in the B scheduled property till the next date of hearing. Now, the defendant has come up before the court by filing the vacate petition. Both the petitioner as well as the defendant have submitted their arguments on the merits of the matter. This court is not inclined to go into the merits and deems it appropriate to direct the court to hear this matter expeditiously. When counsel for the defendant submits that a time frame may be fixed for the trial court to decide the IA, and till such time, within a reasonable time, till such time, they will not go ahead with the construction. Next paragraph. Considering the same, this court is passing the following order. The writ petition is disposed of, directing the trial court to consider and dispose of IA number 1 within a period of 1 week from the date of receipt of the copy of the order. And the that's it. I'll not, you're undertaking.
From today, if my lord sees, I'll seek advancement, because 27th is.
Order copy should be ready. I'll see that it comes tomorrow. If an order copy is tomorrow, then it'll be 1 week. The petitioner is, the parties are at liberty to advance the matter. This order copy in priority.
But for 1 week, my lord, I'll not put up. Could that be the understanding?
No, till it disposes of.
For some reason, it
No,
doesn't
no,
happen.
I am asking the court to do it within 1 week.
Very
So obviously it will be done within a week.
Right.
Yes.
Then number 5. Connect Uday Kumar for petitioner.
I am before this court challenging the order of 7 Rule 11A. In this matter, the suit is a partition suit filed on 2008. Here, the suit is came to be decreed only in favor of the petitioner and defendant number 3. So subsequently, the FTP proceedings was initiated by the plaintiff respondent number 2, and same came to be during the FTP proceedings. there was a release date made by all the members of the family, male members of the family. Pursuant to that, the FDP was settled and it was disposed. My lord. Subsequently, after 10 years, my lord, they have, after the respondent one being the filed the second FDP, after filing the wakalat in first FDP, and he has come up with the second FDP. My lord. Sir, here, my lord, there is no locus standi, there is no cause of action, there is no
Who are you?
order.
Who are you?
Ma'am, my lord, I am the legal heir of the family, my lord.
No, legal heir of which party?
I am of the um, plaintiff number 5, my lord.
Please come to your IA
Please, my lord.
application. Where is it?
My lord, it is at page number 146, my lord.
Under which provision this IA is filed?
My lord, under 7 rule 11A,
Come to the
read with
order.
section 151.
Come to the order.
Please, my lord.
Where is the order?
Order is at page number 23, my lord.
Hmm.
Operative portion at page number reasoning at 32, my lord. 32 and 34 is the order of rejection.
Let's read.
My lord.
Let's read.
My lord.
Para six.
From para 6. This petition is filed by the petitioner, respondent number 9, seeking the final decree to be drawn in respect of the share as per the judgment and decree passed in OS number 259 of 2008. The petitioner has produced a certified copy of judgment passed by this court in OS number 259 of 2008, and as rightly pointed out by the learned counsel for the petitioner. This court in paragraph 21 of the judgment has observed that the petitioner respondent is entitled to share in 1/6 share of the mother, namely main BB. It is further observed that the court did not specifically mention the share in which the petitioner was entitled.
Notice to the respondent's petition is permitted to take out hand summons.
There is an requirement of stay, my lord. Here, my lord, there is no locus standi. He is not entitled. He is not, my lord.
Court has
One-
given a reason for that.
My lord,
Court has given a,
my lord. My lord, one submission. My lord.
yes, heard reserved.
My lord, one submission, my lord.
I'll pass orders, heard reserved. All parties are served.
Please, my lord.
Yes.
Say number 6, Vinay N. Yes, Kartikeyan.
This is a matter
For
wherein
one and two, Millard, I undertake to file wakalat.
Hmm.
I'll file objections in the next one.
but the issue
No,
is.
now we are on the interim order. If you submit on your instructions, then we'll proceed with the matter.
Millard, we have just been given instruction to appear in the matter. Millard, we are going to receive the wakalat. If it can be taken tomorrow itself, Millard, I will file. Panel
Tomorrow,
advocate.
tomorrow in the first list, get instructions.
Much obliged.
Yes.
Madam, you write your name again. Respondent.
Yes.
Serial number 7,
Would it be in preliminary hearing, not it is coming,
Srinivas V.
should come in petition first, this preliminary hearing.
A list in the preliminary hearing tomorrow. Then your B group is also on the top of the list.
Right, all matters will reach, not, but
No, it's already, it's 6 today. Anyhow, let's sit in preliminary hearing.
please.
Yes, Mr. Srinivas.
My lord, I appear for petitioner in this case, my lord. My lord, yesterday's matter, my lord, where
Yes.
my electricity connection have been disconnected. I have served upon Vinayak, my lord, yesterday itself. My lord, but on 13/7, in fact, my action has taken place, my lord. Notice is
Where
dated
is he?
27/5.
Vinayaka,
My
yes.
lord,
I'll take up this matter at 2:30, tell him.
Please.
Cell number 8, same 8, 9.
8,
Yes.
9, all three are same, my lord.
Yes, yes.
Cell number 10.
For the petition, madam, kindly pass out the madam. Senior is head up in the quota number 16, madam.
Vignesh Shetty.
Passovers, whether I'll call or not, I don't know.
They are also getting the
Tell
DD,
your,
madam.
and if I don't call the passover, then the interim order will not be extended.
No, man, they are getting the DD, madam.
So they are doing it at their risk. Yes, 11.
Cell number 11.
For the petitioner. My lord, suit is for partition. There are two applications, my lord. The two applications, my lord. The suit is one for partition. It was decreed in 2022, my lord. Subsequently, an FTP proceeding is still pending. And while that was pending, my lord, a total stranger to the proceeding has filed an impleading application, and to stay the FTP proceeding is filed an application. And that has been allowed, my lord. Agreed by the same, I've come before this honorable court.
No, there are two writ petitions.
Yes,
First writ petition is against which IA?
Against the 33885 is against the impleading and
34169?
it is against the stay, my lord. Stay of the.
No, please come to the, which writ petition to be taken up first?
Impleading, my lord. Impleading, my lord.
Give the next matter.
Sir.
Yes.
My lord,
You're the?
I'm for the petitioner, my lord, in the partition suit.
Petitioner who? You're the judgment, you're in execution.
In execution.
You're
I'm
the
for-
respondent or the petitioner?
I'm
therein?
for the petitioner, my lord, in the execution
Ah.
as well. My lord, he's filed an application which is at
The application is filed seeking permission to implead the applicant as necessary party.
My lord, he is a permissive occupier. He is stating that he is the owner of the property. A subsequent proceeding was filed into another court, my lord. And what he's done is.
Let's see the
Yes.
affidavit. Please come to the affidavit. Page number?
My lord, the IA is at 74, my lord.
Yes.
He sought for an IA.
No, this is not 70?
74, my lord.
No, 74 is not, it's a petition under Order 20, Rule 18.
My lord, may
It is
may
next-
kindly
it's
have a
on
look at the
85.
order, my lord.
It's on 83.
Yes, my lord.
Affidavit is on 83.
Yes. My lord, he says that.
Let me read it. No, according to him, he is not a tenant. He filed a suit for partition wherein you are the defendant in those suits, in that suit.
Yes, my lord. I'm a defendant, my lord. I filed my WS as well, my lord, before that court, saying that it is not a partitionable property. Order may kindly be seen, my lord, in at page number 22.
Page number?
22.
Order in this IA. on
Order in this
IA.
IA, my lord. Page 24 onwards.
Come to the reasoning part.
Reasons, my lord. This petition filed by the plaintiff in OS 100 of 2020 to draw the final decree in terms of preliminary decree passed in OS 2020. The applicant of the present applications stated that his father and two others have filed partition suit numbered OS 228 pending before this on the second additional.
No, in
order.
your written statement, have you stated about this suit and the execution petition, that is the FTP that is pending in your written statement?
In my written statement, I've not mentioned about it, my lord, but I've mentioned that in fact, my lord, he is not even filed any genealogy with the application.
No, whatever it is, when already in respect of the very same properties, another suit is filed, where that person is not a party to this.
Yes, ma'am.
FDP proceedings are pending.
Yes, ma'am.
Unless you want to suppress that, there is no reason not to state it before the court.
Yes, my lord. I have not filed my written statement along with the petition, my lord. I'll seek instructions on that, my lord.
No, court has recorded that.
My lord, court has recorded that, my lord, but.
Your written statement was also placed on record in the next suit.
Yes, my lord. But it is mentioned that we don't know if he was a permissive occupier or here the suit is already 18 finality, my lord. He is supposed to go on appeal and implement.
No, for that you will state in the written statement if that is so. You have not said. You have not stated in the written statement. Read it.
Peruse materials on record. Admittedly, the suit property in the present case and in OS 228 is one and the same. The parties to the petition are also parties to 228 along with others. Such being the case, if the application is not allowed, my lord, end of that, my lord, it is averred that the father of the applicant was a permissive occupant and permitted to occupy the property in the year 1990 itself. Such being the case, it is clear that from 1990, the applicant and the family are residing in the suit schedule property. However, whether they are the permissive occupants or joint family members of late Appu Gowda are yet to be decided in 228. And he was well aware, my lord, of this suit. While he was filing the 228, he was well aware of the OS 100, my lord. This is only to delay the proceedings. He's done this, my lord.
Order of the court is right.
My lord, on the written statement, I have not produced this before this court. I will seek instructions on that.
Not required. These facts are sufficient to decide this application. Please come.
My lord, it's only to delay, my lord, the FTB proceedings. It's already attained finality.
The suit that is filed by is one fact saying that it is the self-acquired property of your father. And all family members, a comprehensive suit is the next suit.
Yes, my lord. He is not a family member also, my lord.
No, he said so. He is son of so and so. One of the that is
my lord,
recorded
he's
by the
not produced any genealogy, my lord.
That will be decided in the other suit.
My lord, in that can be decided in another suit, but here the OS 100 is already 18 finality, and he
As
is
far
only
as
to
order
delay,
one,
my lord.
as far as order 1 rule 10 is concerned, I'm allowing it. And as far as other section 10, we will hear. I'm this order 1 rule 10, the court has rightly allowed. Please come. The petitioner, this is WP number 33885 of 2025. The agreed with the orders passed 9 number 1 in FDP number 18 of 2022 dated 12/11 to the 2024. We are questioning a 24 order in 2026.
My lord.
What is the date of order?
Date of order, my lord, is 2025, my lord.
12/11/2024.
I filed it in 2025, my lord.
It is coming up for preliminary hearing now.
Yes, ma'am.
The dated 12/11/2024 by the Principal Senior Civil Judge and CJM. The respondent herein has filed an application under Order 1 Rule 10 to implead him in the FDB proceedings. It is a specific case of the applicant that his father and two others have filed partition suit that is numbered as OS number 228 or 228 of 2020, pending before the first additional senior civil judge, Mangalore, for partition of the scheduled property, which are the same property involved in this case. The petitioner number 1 to 4 or the defendants number 10 to 12. The respondent herein or defendant number 1 to 9 in OS number 228 or 2020, and they are participating in the proceedings without mentioning about the suit filed by them or the final decree proceedings. The applicant and other family members are residing in the suit scheduled property, and recently when commissioner appointed in the proceedings issued notice and visited the property for division. The applicant and others came to know about the suit and the final decree proceedings for the first time. If the division is affected as directed on the basis of the commissioner's report, the applicant and other members, other joint family members will be put to hardship, and accordingly, so rate the court to allow the application. According to the petitioner here, the petitioners herein file their objections. It is stated that the implead applicant is very much aware of the decree that is passed, and he has no right over the scheduled property, and he has no relationship with the family, and so is not a proper and necessary party to the proceedings. The court, by order impugned, had allowed the application. While allowing the application, the court observed that the applicant claims that he is the son of late Pandu Gowda, who is the son of late Annu Gowda, son of Appu Gowda. The suit properties belong to Sri Appu Gowda, which is a joint Chalakeni properties. Being the elder son of late Appu Gowda, Sri Veerappa Gowda filed form number 7 on behalf of the family of late Appu Gowda. Hence, some of the legal heads of Appu Gowda filed the suit for partition in OS number 228 of 2020 against other legal heads of Appu Gowda. From the genealogy furnished by the applicant herein, it is seen that the plaintiffs in OS number 228 of 2020 are the children of late Annu Gowda, late Chennamma Bai, late Dammu Gowda, and late Ammu Bai, who are the children of late Appu Gowda, against the children of Sri Veerappa Gowda and other children, and grandchildren of late Appu Gowda. Therefore, OS number 228 of 2020 is a comprehensive suit where the issue regarding whether the property involved in the petition, as well as in the suit in OS number 228 of 2020, is a joint family property or the separate self-acquired property of Sri Veerappa Gowda are not yet to be decided. It is also observed that it is not proved that it's a joint family property and all the self-acquired property of Veerappa Gowda. The court has held that they have the undivided share and interest in the petition scheduled property. It is the case that they have undivided share and interest in the petition scheduled properties. Therefore, they are the proper and necessary parties to the FDP proceedings. The next part, land counsel appearing for the petitioners submits that they are in permissive occupation. They have no nexus with the joint family. They are not the proper and necessary parties. Without considering all these aspects, the court had allowed the application. It is a case that the implead applicants are very much aware of the judgment and decree that is passed, and also the final decree proceedings that are pending. Without questioning the same, they have come before this court, come before the executing court by filing the incident application. The court, without considering all this, has allowed the application expire. Having heard the land counsel for the petitioner, there is a material on record. The implead applicant is a plaintiff in OS number 228 of 2020. This this petitioners and others and other family members are the parties to the suit filed seeking partition. They have given a genealogy. The parties in the execution proceedings in the FDP are family members of, according as per the implead applicant, the parties in the FDP proceedings belong to one sect, and all the family, making all the family members as parties, a comprehensive suit is filed. And in respect of the suits scheduled properties in the FDP, in the earlier suit, they allow the other, along the complete applicant, along with the other family members are residing in the said premises. In those circumstances, the court has rightly held that they're proper and necessary parties to the FDP proceedings and rightly allowed the application. And this court finds no reasons to interfere. Accordingly dismissed in WP 34169 of 2025, notice to the respondents, petition is permitted to take out handsomens. Yes.
My lord, my lord, the staying of the property of the FTP, my lord, right now, that is only to.
That's why in that I have not dismissed, I've issued notice. I'll not grant any interim.
Cell number 12.
Seal number 10, my lord, all the parties are here.
Yes, before matter.
Cell number 10.
Serial number 10, my lords. I have received papers today. I appear for R3. Lords, can I request, my lords, 2 days time to go through the papers and make my submissions? I'm yet to be impleted. My name may be shown, my lords.
The I number.
My lord, may I make only one submission? In view of the last date order, my lord, they are supposed to hand over the DD of rupees 12 crores.
I have taken the demand draft of 4.5 crores, my lords. I am filing an affidavit. Lords, because I am subjecting this, there are further loans which they are required to recover from this. If I fail, this will go to their loan
Other
account.
day I made it very clear. I will not show any kind of indulgence in this matter unless the DD is on record. If the DD is on record,
Lords,
not
if I have this matter day after tomorrow, my lords, anyway they are seeking time, within which time.
But day after
if they
tomorrow, no, I'm
If
making
they can
very
arrange
clear.
it, they will arrange it, my lords. Otherwise, I'll have the wrath of the court's order. I understand.
Yes.
On
List is
Monday, my
marked.
lords.
What is your name?
Lords, P. Prasanna Kumar's name.
The council, Mr. Prasanna Kumar submits that he has instructions to file wakalat on behalf of the
R3, my lords.
on
Proposed
behalf of
respondent.
R3 proposed respondent. List this matter day after tomorrow.
It's Monday, my lords.
Same.
He's also requesting for Monday.
Monday.
Please.
Monday finally.
Finally, please.
Same on the top of the list.
Please.
My lord directed me to place this judgment on before this honorable court. Last occasion, my lord directed me to place the judgment in this case.
Take it. Yes. No, he was referring on one judgment and says that this is not permissible.
No,
So I just
I'm
said-
not, my lord, I'm not on that. My
No,
lord
no, no.
directed me, I'm producing.
No, when you're
Actually, I'm
saying it, like I can't take a different view from what I have taken in the earlier one.
I'm not-
So how these facts are different from that, I just wanted to see.
Great.
Yes,
Please, my lords.
allowed.
Grateful.
Sir, amendment.
And the petition shall carry out necessary amendments. List this matter on Monday. Interim order earlier granted is extended on the top of the list. Yes.
Grateful, my lords.
Cell number 12.
petition.
Sri
This petition, there was a common order passed in the miscellaneous appeal in respect of two applications. One writ petition has been listed today. The other petition bearing number 39.
We knew this 2025 has finally seen the light of the day. You argue on this. I actually, it can come the other
Common
matter.
order, my lord, I think so, both the petitions.
What are the applications? What are the two
39
applications?
rule 1 and 2.
Huh?
39 order, 39 rule 1 and 2. One application filed by me and the other application was filed by the defendants.
List this matter.
Trial court.
Give that, list this matter along with the other writ petition on 23rd of July. Yes.
Cell number 13. Divakar Kane for petitioner.
My lord, I appear for the petitioner.
Yes.
Both the trial court as well as the appellate court dismiss my injunction application, my lord.
Yes.
Plaintiff writ petitioner actually is the absolute owner of the property and respondent is the Grama Panchayat, my lord.
Come to the order of the appellate court, we'll see that.
I would like to draw your lordship's attention to para 17 and 18 may kindly be seen, sir. Two decisions were cited by the appellate court that is not applicable to the facts of the case at all.
Please read from para 14.
Para 14, I'll read, my lord. Before dwelling to analyze the facts, it is appropriate to ascertain what are the requirements of essentials of temporary injunction. Etc. etc. Those criteria are prima facie case, etc. etc. Generally speaking, the prima facie case is not a term of art and is simply signifies that at first sight the plaintiff has a strong case. According to Webster's internally, the learned appellate court has not discussed about merits therein, sir, my lord. I may be permitted to read para 15, 16 and 17, my lord.
Yes.
The assertion of the plaintiff is that she is the owner of a scheduled property and defendant is trying to form road, etc., etc. Then para 16, my property survey number is mentioned and there is reference to OS 236 of 2020 filed by the writ petitioner against her son, wherein the learned trial court has issued an order of injunction. Then the representation that is referred to R 31/10/2023 and resolution. These are all documents which was prepared in and around the date of filing of the suit, my lord. My suit is filed on 15/11/2023. Then para 17 is important. Before the appellate court, the appellant filed IA number order 39 rule
Yes.
1 and 2.
Please take notice to the respondent's petition is
My
permitted.
lord, till then both
File a
parties
memo.
may be directed to maintain status quo, my lord.
File a memo to
Till-
that effect. If the memo is filed, list this matter on 6th of August. Yes, next.
Cell number 14,
Yes.
Superready Kane,
This matter, my lords, I'll accept notice for respondent number 3.
Respondent number?
3, my lords.
Ours is 15.
First, we'll hear the matter. You have not filed any KV.
No, 15.
Yes.
14. Yes. Sorry. 15 is that.
Yes. Yes, Mr. Devraj.
Devaraj.
The orders allowing the application for impleading in the proceedings where that I have filed challenging the 321 proceedings before the lands district judge. That applicant claiming to be the neighbor owner.
What is the suit for?
So it is not a suit, but proceedings which has been issued by the corporation.
You have filed, yes.
Appeal before the land district judge. That appeal is pending. During pendency, that application was filed for come on record as a third respondent.
Come on record as a?
Third respondent. That application was allowed. That she is a complainant before the corporation where that.
I think there is a
alleged
judgment of
deviation.
there is a judgment of the division bench.
Please.
Of Justice B.V. Ragratna. Saying that they are not necessary parties to this.
My
lords, in this, my lords, I would give a complaint to the Mysore Corporation.
That's true, but in that appeal, there is a straight judgment on that. If in that appeal, the complainant is not a necessary party.
Your lordships may give me 1 day, my lords.
Yes. You don't have the judgment?
That don't have. I'll get.
There is a division bench judgment.
I'll get. Please.
Huh?
So the name.
Tomorrow. Land counsel so and so submits that he has instructions to file wakalat on behalf of
R3, my lords.
R3.
Respondent number 3.
Yes.
Cell number 15, Kane Superready for petitioner.
The new law is with regard to this 120 days in limitation in filing the
Commercial
amendment.
suit or a normal suit?
Suit was prior to that law.
No, it's a commercial suit or a
Not a commercial.
regular suit.
Regular. suit.
When was the?
They institute, we are for the defendant blood. The suit was instituted on 5/7/24. 27/24.
27/24.
Written statement.
Amendment is in the month of June 25.
June 25. Court applied the new law.
Then what was the delay in filing it?
Delay was about 28/7/25 we filed it.
No, how much, above 120, how much was the delay?
Above 120, we entered appearance on about 250 days.
250 days above 120.
No, totally 250 days. Above 120, 250 days above.
But then the land senior counsel, representing the counsel for the petitioner submits that the court has dismissed Court has failed to take the written statement on record on the ground that, in the light of the amendment to the CPC, which is is in the month of June 2025, whereas the suit is filed in the year of 2024. And retrospectively, the amendment cannot be applied considering the same. There shall be stay of all further proceedings.
Please.
Notice to the respondents, in addition, hand summons, memo shall be filed by 29, or else the stay granted by this court stands.
Please, oblige.
16, Gurudat BS.
Paper,
Yes.
For the petitioner in this case, I'm challenging order I on 4 and 5. Arrest, show cause notice and also arrest warrant. Both have been passed on the same day.
Come to that order, page number.
Order, only 2 pages, reason has been given. Page number 70, my lord,
Page number 70.
70, reasons. No reasons have been cited, my lord.
No, what happened? Have you appeared before the court or not?
No, I appeared and also I filed an appeal. I filed my objection to this both the years. And also I filed an appeal challenging the judgment and decree which is pending.
Because the judgment and decree passed.
Judgment and decree passed, 1 second, madam. Judgment and passed in 2013. I filed an appeal. No, not 2013, I'm sorry. 1 second. 2018. And I filed an appeal, RFS 1612/2018. That is pending. There,
No interim order in the appeal.
interim order was granted, but he has not complied the order to pay the deposit.
So how many days you will not comply with the?
No, now I am ready to.
When?
Now I'm ready to comply, madam. Can give me a conditional stay that I can do it because arrest warrant has been issued.
What is the decretal amount?
Decretal amount is 14 lakhs and
How much you're going to pay?
30% I'll pay, madam.
No, money decree can't be stayed like this. Now, what
50%.
still you're seeking stay of that?
50%.
The petitioner is agreed with order. Passed in
Decretal amount.
execution number, in I number 4 and 5. In execution number 181 of 2019, date 11 January, February 2026, whereby on both the A's, that is I number 4, which is filed to show cause notice to arrest. The issue a show cause notice to arrest to detain the JDR in a civil prison, and I number 5 to arrest and detain the JDR. On both the application, the court has passed the order. It is submitted that the court has failed to consider the contention that are put forth on behalf of the JDR. Considering the submission of the Land Council of the petitioner, there shall be stay of all further proceedings pursuant to the order dated so and so, so and so, and so and so, on the condition that the petitioner shall deposit an amount of rupees. Now, what is the EP amount?
EP amount is 30 lakhs. Interest and everything he has put.
30.
30.
Then pay 15 lakhs.
No, madam, he's not able to pay.
We are
10 lakhs,
concerned with the EP
10
amount.
lakhs may be, sorry, madam. Request, madam. It's a humble request.
12 lakhs on the condition of petitioner depositing 12 lakhs within a period of 4 weeks from the date of receipt of the copy of the order. If the petitioner fails to pay the amount by, today is, what is the date today?
Today is 15th.
15th. By 13th of August, if the amount of 12 lakhs is not paid, this writ petition would be dismissed with exemplary costs.
Date, madam? Within
14th. So today is 15th, that is 14th of August. Yes, notice to the respondents. In addition, petition is permitted to take out hand summons.
And summons, the advocate is
The
from
council.
Mysore it is.
Mysore. Notice to the respondents.
Still number 17, P. N. Harish for petitioner.
memo seeking permission to withdraw the writ petition because I have to file a comprehensive writ petition.
You want to file a?
Comprehensive writ petition along with my brothers who are all respondents. They have also intended.
Petition, the writ petition is filed. You could have given a memo.
Filed a memo, my lord.
What is there?
Yesterday I filed a memo. Memo is filed.
A memo is filed stating that petitioner wants to file a comprehensive writ petition along with his brothers. So the respondent number 3 and 4. And he wants to withdraw the writ petition. Writ petition is accordingly, the memo is taken on record and the writ petition is dismissed as withdrawn with the liberty to file a comprehensive writ petition within a period of 2 weeks from the
Please,
date of receipt of the copy of the order. Registry is directed to return the entire record by keeping the xerox of the same. Yes.
Please.
Number 18, Syed Zulfikar Ahmad, petitioner.
The petitioners are the plaintiff before the court below, my lord, and the suit is for partition pending since, my lord, 2011. My lord, evidence has been completed from both the sides, and when the matter was posted for argument, an application was filed for appointment of court commissioner. That was on the instance of the defendants. That was also allowed, my lord, and court commissioner has given a report that, my lord, the documents on which the defendants are relying upon about the oral gift deed is, my lord, a created document, fake document. And at the time of cross-examination, my lord, the defendant took the time and filed, my lord, 4 applications to drag on the proceedings to examine some of the notaries who has notarized the document and some witnesses. Those applications were pending since nearly 10 months before the court below. Therefore, my lord, because of that reason, my lord, I had to file this petition. What happened, my lord, during pendency of this writ petition, on 1/7, those applications are.
I'll pass on.
Those applications disposed of.
Which application is disposed of?
All the applications have been disposed of now.
So now it has become instructions.
Not my second prayer may kindly proceed, my lord.
To direct the judge.
Yes, my lord.
So-
Because
so
2011, these are the sisters.
The writ petition is filed, seeing the following prayer. When counsel for the petitioner submits that the suit is of the year 2009 and on one pretext or the other, the defendant by filing consecutive applications is dragging on the matter. And in fact, I number 22 and 24 were pending for a long time. Hence, the petitioner has come up before the court seeking the relief to dispose of the IAs as well as the suit. It is submitted that during after filing of this writ petition, the court has disposed of I number 22 and 24. It is submitted now, the second prayer, this court may consider the second prayer, and there may be a direction to the court to expeditiously dispose of the matter. Next prayer. Considering the submission of the learned counsel for the petitioner and the fact that the writ petition is pending, the suit is pending, suit is of the year 2009, 2011, this court deems it appropriate to pass the following order. How much time?
2 months, my lord.
2 months, is it possible?
Everything is over, my lord. Only court commissioner has partly examined and another part examination.
It says 6 months.
Much.
Considering accordingly, this court is passing the following order. The writ petition is disposed of, requesting the so-and-so court to dispose of OS number 4143 of 2011 as expeditiously as possible, but not later than 6 months.
Sir, number 19, V. Vinod Reddy.
There is 1 day delay in filing written statement.
1 day. Suit is of which year?
25. 25.
25 when?
2020, my lord.
Which month?
23/5/2025.
23?
5/2025.
Amendment is?
Amendment.
When is the date of the amendment? It is on, I think.
5/6/2025.
Learned counsel appearing for the petitioner that the court has refused to take the written statement on record as it is filed beyond 120 days. It is submitted that the suit is in the month of May 2025 and the amendment is in the month of June 2026, and the court cannot retrospectively apply the amendment considering the submission stay notice to the respondents. Petition shall take out hand summons and file a memo to that effect by 29th of July. Or else the
And
state-
this is Mulbagal's Kolar district's case. take the notice, emergent notice.
Emergent notice. Instead of hand summon, emergent notice. Yes.
20.
For the petitioner,
Petitioner.
my lords, against non-grant of ad interim ex parte injunction. My lords, without looking at papers, I'll just take only 30 seconds. The matter is pretty simple, my lords. I'm the owner of the property. I had given the property for development in fair.
No, without you arguing, I can do it within 5 seconds. So,
I'll show the records.
where is the order?
Kindly, my lords. Order is at page number 31.
When is the matter coming up? On
18/7,
2020. I'll ask the court to decide it on that day. 18 Saturdays, next week it's coming.
18.
Exactly, it will fit in within that 1 week time.
15 days time may be fixed for the trial court to consider both the submissions and pass a reason. That would suffice.
Land Council, the writ petitioner is before this court, questioning an order dated 19/6/2026, whereby the court, without passing any orders on I number 1 and 2, has issued the suit summons to the respondents, returnable by 8/7/2026. 18/7/2026. And counsel appearing for the petitioner submits that when an application is filed seeking ad interim injunction, the court has to pass orders on the merits of it and cannot and ought not to have granted the suit summons. He has relied on a judgment of the coordinate bench of this court that to take from, there is a judgment, coordinate bench of this court, so and so. Next, but in the light of the above referred judgment, this court is passing the following order. The writ petition is disposed of directing the trial court to consider IA number 1 and 2 as IA number 1 and 2 within a period of 15 days from the date of receipt of the copy of the order.
Only one small request. Until such time, all that I'm seeking is not to alienate the property, my lords.
1 week if you want, I can, but I will not grant any interest.
Only until such time, my lords. Only until such time.
I
Because
will not grant, if it is until such time, then I have to wait for the respondent to come. So if you want 15 days, 15, otherwise 1 week, I'll say 1 week, within 1 week to dispose of.
1 week, my lords.
Say 1 week.
I'm grateful.
Bill number 21. Shivaprakash M for petitioner.
Yes.
My lord, this is dependence petition, my lord. Suit of the plaintiff is for a bare injunction. Now the parties have laid evidence. They have concluded evidence also. Voluminous of evidence, voluminous of documents. Still the ambiguity continues about measurement and about the boundaries. My lord, in the written statement, I have taken a specific plea.
What is IA? IA for advocate?
IA for appointment of commissioner, only to take measurement, that's all.
Come to the order.
My lord, before that, in my written statement, my lord,
So before that, let us just see the order. What did the court say?
the reasoning given by the learned trial judge is that I have not filed any
Page number.
counterclaim. My lord, may I kindly take my lord to page, page number is 74, internal page number is 12. Impugned order. My lord, fourth or fifth line. There is no plaint or argument reflecting regarding the dispute between the plaintiff and defendant pertaining to the measurement of the property or boundaries of the property or identification of the property. In the absence of counterclaim in the written statement and no denial of the plaint regarding the
So
position.
why do you want the advocate commissioner to be appointed?
My lord, only to take measurement, that's all.
For what? What purpose?
Now, this person is claiming under my sale, it is north to east to west is 34 feet. It's a admitted fact. And north to south is 18 feet. In this measurement, I built about 5 into 10 a small shop where I'm a tailor. Now I made about 85 years. Now, as it is with this my age, I am not fully actively doing work there, taking advantage of my age and also not functioning in that shop. Now, this fellow and the neighbor, he want to encroach upon my property about 4 feet.
Will the court decide it in his suit for bare injunction?
My lord, when there is such ambiguity.
No. You are saying that he is encroaching your property. Will that be decided by the court?
My lord, what happens is now it again leads to multiplicity of litigations.
Because it leads to multiplicity of proceedings without a counterclaim, court will not
My
decide
lord,
about his encroachment
now
in your
my
property.
lord can also look into the plight of this person, 85 years. Now,
Unfortunately, we are dealing
now
with a civil matter governed by procedural law,
to put a quietus to it. Quietus to it.
not for. It
Let
can't be
there
done.
not be. This is the one reason given by the learned trial judge. And now as it is, My lord,
That's no, that reason is sufficient. You don't have to look for other reasons. Please.
that's the only point, my lord, because with my lord's robust experience, the only thing, my humble submission is, humble
Unfortunately,
submission
court
is,
cannot do it.
let the litigation quietest be put. Otherwise, these persons are taking advantage, let them not do all these
The
things.
order, agreed with the order passed in I number 21 invoice number 6280/2019, dated 1st June 2026 by the 12th Additional City Civil and Session Judge Bangalore. The defendant is before this court. The respondent herein, who is the plaintiff in the suit, has filed a suit for bare injunction. In that, the present IA number 21 is filed by the defendant petitioner herein seeking appointment of a court commissioner, that is the executive officer oblique assistant revenue officer, with a direction to make local investigation and also to measure the plain scheduled property as well as the defendant's property and the actual construction in his property, to report the factual aspect along with sketch for the reasons stated in the applicable in the application. The court has dismissed the application by order impugned. The court, while dismissing the application, observed that burden lies on the plaintiff to prove his possession and enjoyment of the suit scheduled property and also interference by the defendant. When such being the case, to measure the property belonging to the plaintiff and to measure the property belonging to the defendant in a suit for bare injunction does not arise. Apart from that, when the plaintiff approaches this court, it is a bounden duty of the plaintiff to prove his possession and enjoyment of the suit scheduled property as well as interference by the defendant with respect to his peaceful possession and enjoyment. Even in the written statement also, defendant has not narrated regarding the interference by the plaintiff with respect to his property. When such being the case, the nature of the suit itself speaks that the burden cast upon the plaintiff to prove his possession or the suit scheduled property. In that case, measuring the property of the plaintiff and the defendant is no way necessary to adjudicate the dispute between the parties with respect to the scheduled property. Then the court has discussed about the scope of an application under Order 26, Rule 9, and observed that when the court deems that a local investigation is required or proper for the purpose of elucidating any matter in dispute, and such circumstances only, the commissioner can be appointed. But in a case on hand, the suit filed by the plaintiff against the defendant on the basis of his fiscal possession and enjoyment over the property and interference by the defendant. In those circumstances, the court has held that it is not feasible, it is not appropriate to allow the application, and accordingly rejected the same. Learned counsel appearing for the petitioner submits that, in fact, the plaintiff has encroached the property belonging to the defendant. So unless until the advocate commissioner is appointed and both the properties are measured and the report is placed before the court, the true facts will not come to light. And further, if this exercise is not done, it would unnecessarily lead to multiplicity of proceedings. It is submitted that the defendant is aged about 80 years, is a senior citizen. In considering all these facts, the court ought to have allowed the application. Anything else?
The counterclaim. I should have filed counterclaim is the reasoning given by the learned trial judge.
It is submitted that the court has observed that the petitioner, the defendant ought to have filed a counterclaim. It is a submission that without the counterclaim also, petitioner can come up with such an application. The defendant can come up with such an application, and in the interest of justice and to come to a just and reasonable conclusion, court ought to have appointed the advocate commissioner. Next, further, having heard the learned counsel for the petitioner, peruse the material on record. In this case, the trial is completed.
Evidence is completed. Now it is posted for arguments.
Now the matter is coming up for arguments. At that stage, the defendant has filed the present application. According to the defendant, in fact, there is an encroachment by the plaintiff.
Attempt to encroachment.
Attempt to encroach the the defendant's property. And the property of the plaintiff and property of the defendant has to be measured by appointing the advocate commissioner. The court has rightly held that the suit is for partition, suit is for bare injunction, and the burden lies on the plaintiff that he is in possession of the property and the defendant is interfering with his possession. The court also has rightly held that the defendants, there is no question of measuring the defendant's property to find out about the alleged or efforts made by the plaintiff to encroach the property. The considered opinion of the court, and the court has rightly discussed about the scope of order 6, order 20, or order 26, rule 9. Rightly held that in the facts and circumstances, appointment of an advocate commissioner is not required, and this court finds no reasons to interfere accordingly.
Cell number 22, Ranganath TR for petitioner.
One small request, my lords, the order may be uploaded online.
It will be tomorrow.
Great.
All these orders will be uploaded immediately second day.
I'm ready.
Cell number 22, Ranganath TR.
Wherever 1 week disposal, I said, bring priority to that. End of the day. Yes.
Ranganath TR.
No representation list in the month of September is 23.
23, K. Chandranath Ariga for petitioner.
Yes.
May I? Lord, petitioner is the first defendant in a suit for bare injunction. The trial court has allowed the application number 2 and granted an order of injunction. Injunction restraining the first defendant and others from entering upon the suit schedule property. My lord, main contention of the defendant is that
No, appeal is also confirmed.
appeal it is confirmed.
We'll just see the order of the appellate court.
Yes, that my lord finds it at annexure G, page 86, my lord.
Please come to the reasoning part.
Yes.
Yes.
The reasoning starts at paragraph 12, page 93. My lord, the details of the description of the property is given, that can be skipped, my lord. The even paragraph up to 16 can be skipped. 17 may kindly be seen at page 99.
Yes.
By looking to the pleading, page 99, by looking to the pleadings of the parties, it is not in dispute that so and so was the common ancestors of plaintiffs and defendants having.
Reading paragraph number?
Paragraph 17, my lord. Page 99.
Yes. Yes.
My lord, the family genealogy is discussed. Then the kindly come to paragraph 20 at page 101. My lord, family genealogy I will not read, but paragraph 20, the court says the copy of the.
No, both defendant and plaintiff are related.
Relatives, my lord. All of them.
What is the relationship of plaintiff with the defendants?
They are the cousins. My lord, it is a family called, the particular name of the family called Mudukuru Garadimane Aliya Santana family. There are about 90 persons in the joint family of this particular family. All of them, my lord, there was a division way back in 1936. Subsequently, there were divisions. That is the division in the Kutumba. The Kavaru division has not taken place. The suit filed by us is pending. The court.
What is that? What did you say? Kavaru, what is that?
My lord, in the amongst the Aliya Santana family, that part of the district of South Kendra or now Mangalore and Udupi, they are governed by Aliya Santana Act, Madras Aliya Santana Act. Under that, succession is through female line. and the female becomes the yajamanti of the family. Wherever if she is the eldest, she becomes the yajamanti. My lord, there are several, that is, entire family is called as kutumba, and several divisions. If there is the daughter and daughter's children, they become one kavaru. And the daughter's sister, another sister, all of them become a kutumba. Now, this kavaru.
Sons will not have any share.
My lord,
Sons will not have any share.
sons will get, daughter's son, they will get. But that son becomes a family member of his mother, not of the father. Unlike Hindu Succession Act, there is some distinction. Here, these persons, defendants have filed a suit. Court has done is, court has passed an order of injunction. The main effect is, my lord, there is a family deity and family temple. These people, by a mere order of injunction, these people, all the people are restrained even from going to the temple.
Let's read from para 20.
Please, my lord.
Para 20.
Para 12, my lord.
20.
Yes, ma'am. The copy of the registered partition deed bearing document number so and so prima facie shows that all the 4 children of Srimati so and the members of their kavaru have partitioned the Alyasantana joint family properties. It also prima facie shows that the kavaru of Srimati so consisting of herself, her 6 children, and also their children, totally 18 persons, are parties to the said partition. It also prima facie shows that 10 properties of A schedule have been allotted to the kavaru of Machi Hingsu. Similarly, it also prima facie shows that the kavaru of Srimati so, her children and grandchildren are also the parties to the said partition. It also prima facie shows that the 8 properties have been allotted to the kavaru of so. My lord, it goes on and on like this. My lord, prima facie, my lord, main submission of the defendant is there is a M schedule property to the written statement, which gives the details of entire family properties. And by virtue of this suit, the plaintiff cannot seek an injunction against the co-sharer. My lord, the proposition is one co-sharer cannot restrain the other co-sharer from enjoying the property. Now, by this order of mere injunction.
Come to 103 last paragraph.
Please.
103 last, that
Yes.
21 paragraph, about 4 lines from the bottom.
Yes.
The documents such as.
So, by looking to the recitals of this document, it can be presumed at this stage that a legal partition is already taken place in the year 1936. My lord, this is what I submitted. There was partition way back in the year 1936. That is Kavaru partition. Among the 4 children of Panju Hingsu, joint family is severed and family properties are no more the joint family properties. Thus, at this stage, the assertion of the defendant that Alyasantana joint family consisting of plaintiff and defendant exists. M schedule properties which are inclusive of suit schedule properties are the joint family properties.
So you're reading where? I said para 21.
Para 21.
Para 21 from the bottom, about 5 lines.
Oh, sorry.
The documents such as
documents such as partition deed dated 12/5/36, grant certificate, partition deed dated 4/2/1995, and copies of the registered sale deeds clearly falsified the defense of the defendants at this stage, and they support the case of the plaintiff. My lord, 1936, my ancestors were parties to that partition deed. 1995, we are not parties. We are not parties.
How many times the partition will take place?
My lord, partition will take place any number of time between the Kavaru. My lord, Kutumba gets a partition. If there are 7 the Kavarus, one Kavaru can seek a partition, and each member of the Kavaru is entitled for his share per capita under section 37A of the Alyasantana Act. Suppose the daughter has 4 children, those 4 children can also seek partition subsequently because per capita and per capita share under 37A. This has not been taken into consideration is my respectful submission.
The revenue records placed on record.
The
Plaintiff said
revenue
prima facie showed
records
that
placed on record, plaintiffs prima facie show that plaintiff and her children are in joint possession and enjoyment of suit properties as on the date of filing suit. Correct, my lord. Because partition takes place, in that partition, we are not parties. Based on the said partition, revenue records are changed. That is not the prima facie case when it comes to the question of the Aliasantana family is concerned. My lord, by this what happens? They don't deny the fact that there are temples. I have stated so. That's a Garadi temple. All that family members cannot be restrained. At least this court may clarify that this order of injunction restraining the other members of the family will not come in the way of the other members visiting the temple. Now we cannot visit the temple also unless, my lord, unless a comprehensive suit is.
let's see the order of the trial court. What is
Yes,
the
ma'am.
injunction?
Yes, that my lord will get it at page 46, annexure E, my lord. It begins at page 46. The reasons is at page 49. This particular aspect.
So we'll
Paragraph-
clarify this order till the other side appears that you can visit the temple and other whatever the.
My lord, yes, my lord, because
The-
God, it said that God is to everyone.
The petitioner, you are the defendant number?
I am defendant number 1, my lord, and petitioner.
Petitioner is the defendant number 1 in the suit. Respondent herein as filed a suit for injunction. In that I number 2 is filed seeking injunction. The court has passed an order dated 25th February 2025, whereby the defendants, their men, people, servants, supporters, heirs, or any other person claiming under them are restrained from trespassing or interfering with the plaintiff's peaceful possession and enjoyment of the A scheduled property, and also from plucking the coconuts from the coconut trees situated over suit A scheduled property, and also forcibly encroaching any portion of suit A scheduled property. This order is confirmed by the appellate court in MA number
Now, MA number 11, my lord.
of
11 of 25 at page
10 of
86.
2025. Land counsel for the petitioner has submitted has argued on the merits of the matter, and it's also submitted that a scheduled property is a temple. By virtue of this order, the court has granted an injunction restraining the other co-sharers from entering into the temple. It is submitted that pending the writ petition, the petitioners, defendants may be permitted to visit the temple for praying for the prayers, for offering their prayers, considering the submission and the fact that these are all the co-sharers and they're all belongs to family, and balancing the interests of the parties. This court is passing the following order. The pending disposal of this writ petition, the defendants are permitted to visit the temple to offer their prayers, full stop. It is made clear that the other conditions that are imposed in the order passed in IA shall remain to be the same. Yes, notice to the respondents and summons. Memo shall be filed by 30th of July, or else the stay granted by this court stands vacated.
Obliged.
Number 24,
Please,
No, Prabhakar Kulkarni for petitioner.
please. This is the plaintiff's writ petition. I filed an application before the honorable court in a suit for ejectment and mean profits. I filed an application seeking immediate possession. The honorable court was pleased to adjourn my application. I am before your lordships. The peculiar fact is,
Where is that order?
please, that order your lordship will please find at page 30.
Return 25/7/2026.
The peculiar fact is, my tenant has been thrown out of the country. He is not an Indian citizen. He is an American.
Yes, sir.
Lords, your lordship may only kindly see the order. He files a writ petition before this honorable court.
No,
So,
whatever it is without considering your, what is this application?
Lords, I filed an application under 151 and also under 12 rule 6 seeking immediate possession because he is thrown out of the country, the defendant.
No. Court said call on 25/7. Why should you come before this court?
Lords, my respectful
If
submission.
every order, whenever the matter is adjourned and you come to the court, then
Only in these peculiar circumstances that my tenant is thrown out of the country. He
the
cannot
court
enter
decide that.
India.
The court decide that. That's not for this court to decide all this. Please come. The
Lords.
present writ petition.
May I then request this?
Even not tell the court to do anything, to no expeditious, nothing. It is coming up on 25, it will do it.
Lords, let the court decide my applications on 25.
Oh, where is the delay in this? And
Lords.
court can't issue notice?
No, certainly, my lords.
Issue notice?
The order was passed on 29/6
Yes.
by a month. Lords, my
Every order, every case,
Lords.
next day, 1 week, the court can't. It
Lords,
has its
I
own
bow down.
work.
I bow down, Lords. In normal circumstances, yes. But if my tenant is through, I can understand, my lords, if he is residing.
If your tenant is thrown out of the country
Of
or
the
whatever
country.
it is, after one month, they'll put you in possession of the property if you are entitled. So this is not an exceptional case where the court will
Lords.
direct the trial court to do
Lords,
something.
and there is some water leakage. I brought that also to the notice of the court.
But I'm not, because this should not become a
And
precedent.
my lords, he is not paying rent. He
I'm
is thrown
only
out.
interfering in those matters where order 1 rule, order 39 rule 1, when an IA is not decided, not every case. And that too, if I can understand, an IA that's filed long back is not considered. You have filed it in the month of June, court has listed, going to list hear the matter in
Then
July.
may I request for an adjournment post 25th? Lords, on 25th, if I am heard, I have no difficulty. Your lordship may please call this matter.
Even on 25th, the court doesn't hear this matter. Also, I will not interfere. I'm making it very clear.
Lords, I understand, lords. Your lordship may just see the order.
Matter in the month of September.
At least,
Number 25.
lords, first week of August, my lordship, your
PG
lordship
one.
pleases. Lords, the only
The best course would be, like I said, the court has posted it on 25/7. It would hear it in accordance with law, and I do not feel any reasons to interfere. That would be the order. If not, September.
may I only request first week of August. Any date, your lordship may please grant.
How is it going to make a difference? That's what I'm asking.
Lords, my only thing is,
Unnecessarily, I'm burdening my list with another case.
the only circumstance is, I can understand if he is residing. This court has said you cannot enter the country to the tenant. Then, my lords, it's under lock and key. What is the point of waiting? That's the only submission, lords. May I show this honorable court's order, my lords? Your lordship,
No. Everything what trial court should do, this court will not
first
do
week
it.
of August, if your lordship can kindly consider.
Just list the matter on 17th of August.
Grateful, so grateful.
Case number 25, VG Bhanuprakash for petitioner.
Yes.
A suit for partition came to be, a suit for recovery of money came to be filed by the brother of the petitioner, my lords, for a sum of rupees 2 lakhs. They had a dispute between themselves, 2 lakh rupees was sought for. The suit came to be allowed, my lords, as against which an appeal is filed. During the pendency of the appeal, the brother passes away, my lords. By inadvertence, my lords, they have not filed the IA for recalling the, to bring the LRs and record. There is abatement as well as there is delay. In the meanwhile, my lords, sorry, my lords, he expired, my lords, on 12th of March 21.
How can it be inadvertent?
Yes, my lords, there was some dispute, my lords. They thought they will compromise.
Brother, not like some.
Yeah, I understand. Own brother, my lords, only 2 siblings. There was some understanding with respect to certain other properties which they were having a dispute. They were sitting and solving the whole issue. In the meanwhile, my lords, this was not taken really care of to file an application. Nonetheless, what the appeal court do is, at page number 87, at the time when the appeal was pending, my lords, page number 87 for a moment. the last numbered para, my lords, after hearing the submissions on both sides and terms of decree, I am of the view that the appellant is directed to deposit a sum of rupees 1 lakh within 10 days.
And you don't even have a interim order in the appeal.
It's there. That's what I want to read, my lords. 1 lakh rupees to be deposited in the executing court, subject to the deposit of said amount. Operation and execution of the impelled judgment is stayed till further orders. 1 lakh rupees we have deposited.
During the submission from both sides, I am of the view that the appellant be directed to deposit a sum of rupees 1 lakh within 10 days from today, subject to the deposit and the operation execution of the so and so.
1 lakh rupees is deposited, my lords.
5/11/2019.
Yes, my lords. I am ready to deposit the other 1 lakh also. The difficulty for me is this, my lords. The impugned order now says at page number 21, my lords.
No, 5/11/2019 order was complied with by you when?
Immediately within 10 days, we have deposited the 1 lakh. There is no dispute on that aspect. Order was stayed. In the meanwhile, he expires. They don't bring the LRs on record. Subsequently, now that an application is filed, it is pending adjudication. In the meanwhile, the execution court has passed this order, page number 21, where they have issued an attachment warrant of movables returnable by 19th of August. The question is, my lords, out of 2 lakh rupees, 1 lakh rupees by virtue of the order of this honorable court is deposited.
When you have a stay, how come the executing
No,
court?
because the matter was dismissed for not bringing the LRs on record. My lords. I produced that order. My lords. I produced that order. 80, page number 88, my lords.
Page number?
88, 13th of July 23.
Until now, you have not done anything.
They have already filed an application. The application is pending adjudication is my instructions. But there are certain other family properties which were under dispute and suit was filed for partition that the petitioner herein was the younger brother succeeded. In the meanwhile,
If you are ready to deposit, no, what, when was the decree? Decrees of the year 19. What is the decretal amount now? Executing.
4 lakh and odd, my lords, 4 lakh 80,000 and odd. The check amount was 2 lakhs, 1 lakh we have deposited. I am ready to deposit another lakh of rupees.
And why should the court come to?
My lords, my only, since my appeal is under consideration, my lords.
You are very casually when you are.
Careless also, my lords. I would use the word.
2023, when an order is passed, till 2026, you say that your application is pending.
Yes, my lords. It is pending, my lords. It's not, I'm not shying
That
away.
means you are not pursued it.
Yeah, my lords, the reason I'm stating, my lords, since there are certain other properties which were in dispute, now they have come to a stage where.
No order in your favor, so why should they?
No, this order, which I pointed out at page number 87, was until further orders. But for the fact remains that the appeal has. My only thing is, my lords, I can convince my honorable court to say that the 1 lakh, other 1 lakh rupees, I'm ready to pay, my lords. Movable properties are attached. Yeah, of course, my lord. My own brother. He's no more.
You should pay it.
No, there are other 2 lakh rupees and other check which was in was presented, which dishonored, as against which the younger brother has filed. I have brought them to a table of negotiation to see if at all if anything can be settlement can be brought about.
To pay 2 lakhs, then we will grant stay.
Please, lords.
Then counsel appearing for the petitioner submits that the court has issued a warrant of attachment of movables. It is submitted that the plaintiff is none other than the petitioner, brother of the petitioner. And after his death, as I could not bring the LRs on record, though there was a stay in the regular first appeal that came to be dismissed. It is submitted that in fact they're trying to settle the dispute. And if this order is not stayed, and it would cause lot of hardship to the plaintiff, to the petitioner, considering the same, there shall be stay of all for the proceedings on the condition that the petitioner shall deposit an amount of rupees 2 lakhs within 4 weeks, that is by 14th of August, or else the writ petition shall be dismissed with exemplary cause. List this matter on 17th of August.
Notice matter.
Notice to the respondents.
Grateful.
Handsomans.
Grateful. Handsomans I'll take.
Handsomans and memo shall be filed. Yes.
Great.
So number 26, Pradeep, direct for petitioner.
Yes, no representation. This is one. She's unmute her.
We see.
She's not able to unmute. You're not audible. You have to unmute.
My lords, I appear for the petitioner in this case, my lords. I appear for the petitioners number 1 to 3 in this case, my lords, were defendant number 1 to 3 before the trial court, before the learned trial court, my lords. I have been aggrieved by the order passed by the learned trial court, wherein my interim application filed under order 8 has been rejected, and the learned trial court has refused to take my written statement on record without considering the fact that I have not been served with the documents which were annexed to the plaint, my lords.
What is the delay?
My lords, trial court records indicate that the RPED was served on the petitioner number 2 and 3 in this case in the month of July 2025, my lords. However, I was not being served served the copy of the documents which were annexed along with the plate, my lords.
Is it a commercial suit or a?
No, my lord.
It is not a commercial suit, my lords. It's a regular suit.
As per the court,
As per the court, they say it is more than 120 days, but the contention of petitioner, it was from the date of filing of
suit filed.
suit was filed, my lord, in
Suit was filed in the year June 2025, my lords.
November, my lord, after the amendment.
My lords, however, my humble submission in this case is, my lords, because I was not served with a copy of the documents.
On the ground that it is filed beyond 120 days, then council has relied on a judgment order passed by a coordinate bench of this court, where the operation of the amended provision is stayed by the court. In that view of the matter, there shall be stay of all further proceedings.
I'll take notice for 7 to 12, my lord. I'll take notice for 7 to
He
12.
takes notice for respondent 7 to
12, my lord.
12,
1 and 13 notice has to come.
notice to 1 to 7 and 13. Petitioner is permitted to take out hand summons on the council appearing for the respondent, and a memo shall be filed by 29th of July, or else the stay granted by this court. Stands vacated.
Bill number 27. Swami MM for petitioner.
I appeal the petition.
Yes.
No, this is in fact the plaintiffs and the respondents' petition. No, the petition herein in fact filed a suit seeking declaration of a title and also the possession against this respondent. The suit came to be decreed. Against that, my lord, this respondent filed an appeal in RA 34 of 2024. Not that in fact there was a delay of 8 and 15 days, which was contested by me, and it was the said appeal came to be dismissed by virtue of the delay. Now later, that order in fact was challenged before this on court by filing a second appeal in RSA 1228 of 2024. During the arguments, my lord, the respondent filed an undertaking stating that he would in fact vacate and hand over the possession in favor of the petitioner within 1 year's time, and also, my lord, he may be permitted to urge all his grounds in the other pending appeal RA. Lord, this on court.
When he is ready to deliver position, what else will be decided in RA?
Lord, RA in fact, no, there not this RA. That came to be.
Let us see this order.
That became final.
RSA order will.
RSA. Annexure A.
Para 5.
Para 5. May I read? After arguing the matter for some time, the learned counsel for the appellant filed an affidavit wherein the appellant had prayed to grant 1 year time for handing over the premises with liberty to prosecute regular appeal in 162 of 2024, which is pending on the file of.
That is what I'm asking.
No, this was an appeal in fact, my lord, filed seeking a partition by his aunts and cousins against the same petitioner. This was another in fact, and that suit came to be dismissed.
No. Regular second appeal is arising out of a partition suit.
Out of a declaratory suit, declaration suit which I had filed. No, apart from that, my lord, his aunt and others had filed a partition suit.
How can there be in a different suit, in a different proceedings?
That's what.
A liberty to
should not have been granted, but
other civil proceedings.
Yes, my lord, but unfortunately, in fact, he sought that it was granted, but later, my lord, in fact, he filed an application seeking condemnation of 1069 days of delay in filing that appeal. My lord, we contested, and in fact, the court, the first appellate court, only on the sole reason ground that there was a liberty reserved, it has allowed. Kindly, in fact, my lord, look at page 42 of the impugned order.
How can any liberty be granted in a
Yes,
different? suit?
liberty was not even in fact granted, or neither the,
Had prayed to grant 1 year time for handing over the premises
Yes,
with liberty to prosecute regular appeal. Prosecution, to prosecute a regular appeal, that doesn't
Yes.
mean that he will be, every order will be granted.
Correct.
Yes, where is that order? Come to the order.
my lord, kindly, in fact, my lords. Page 42, the reason,
42.
page 42. May I just say? May I read this, my lords? The last paragraph. The Honorable High Court of Karnataka has observed that liberty be reserved in favor of the
Please
appellant.
come. Petitioner is agreed by an order passed in I number 1 under section 5 of the Limitation Act, whereby the court has condoned the delay, how much delay?
1069 days.
1069 days, on the ground that in a different proceedings, in a regular second appeal arising out of a different suit, the court has granted the liberty. And counsel for the petitioner submits that when the delay is inordinate, and the inordinate, the court ought to have given reasons for condoning the delay, and the order passed in a different proceedings in RSA cannot be a ground for the court to condone the delay. Considering the same, there shall be stay of all further proceedings in so and so, and summons by 30th memo shall be filed, or else a stay granted by this court stands vacated. Yes.
Till number 28, Yamala for petitioner.
No representation in the month of September.
Till number 29,
Page 24, there is a refusal to consider the ad interim injunction, my lords, without assigning reasons. Lordships, page number 44.
44. What it says?
Lords, it says that principles of natural justice requires other side should be heard before passing the order.
The petitioner is before this court, questioning an order dated 2/3/26.
Please.
2/3/2026, whereby the court has failed to consider I number 1 and 2.
Please.
While seeking ad interim injunction, then a senior counsel, representing the counsel for the petitioner, submits that the court has issued summons and observed that it is 4/3/2026. Observe that before any passing any order on I number 1 and 2, the principles of national justice requires that the other side should be heard before passing any order. It is, and accordingly issued the emergent notice. When is it coming? Returnable by 6/4/2026.
Lords, after that, Lords will find that page number 45 and page 46. The summons is issued, the summons they are not taking it. And at annexure D, page 47, they are changing the nature of the property. The photographs are
We
produced.
submitted that the defendants are not, the defendants when are not, they're not accept.
They are avoiding
They
this
were
service of-
avoiding service of notice, and in turn, they're also proceeding with the construction
Lords, with the development of the property.
by developing the defendants are developing the property. It is submitted that when an application is filed seeking ad interim injunction, the reasoning given by the court that the principles of natural justice has to be followed is contrary to law. It is submitted that there may be direction to the trial court to expeditiously hear this matter, considering the submission of the senior counsel. This court is passing, then that he relied on a judgment of the coordinate bench of this court. In the light of the above discussion, this court is passing the following order. The trial court shall consider I number 1 and 2 within a period of 2 weeks from the date of the receipt of the copy of this order, notwithstanding the fact that the notices are served on the respondent.
Please, great,
Petitioner is at liberty to advance the matter.
great.
till number 30,
Same, my lords.
Pramod Reddy.
Please.
Just look at it, the IAS or the suit will change. Yes.
Till number 31, Ravichandra SN for petitioner.
For petitioners, my lordships, in this matter, to seeking a directions to dispose the commissioner's reports, my lordships. Dispose the commissioner's reports, my lordships.
Come to your prayer.
Press page number 7, my lordships.
No, why should we grant? This is, commissioner report is 15/5/2024.
Please.
After that, the matter was never listed.
It's got listed. Now matter is, I filed objections for the commissioner's report, my lordships. On that objections, supposed to, either they have to reject the application, commissioner's report on my objections, or they have to conduct an inquiry on that commissioner's report. Then now the matter is posted for the final judgment on the FDP proceedings without conducting a,
While passing the judgment, the court will not consider it.
my lordships, that inquiry has to conducted on the commissioner's report without considering my objections.
And counsel the petitioner. The petition is before this court, seeing the following prayer. It is submitted that a commissioner report was given on 15/5/2024 on that the petitioner has filed his objection. So far, the court has failed to pass any order. Hence, he has come before this court. Considering the submission of the learned counsel, the fact that the report is given as long as back on 15/5/2024, the petitioner has already filed his objection. This court is passed the following order. The trial court is directed to consider the case of the objections raised by the petitioner to the commissioner's report and pass orders in accordance with law within a period of 1 week from the date of receipt of the copy of the order, accordingly disposed of.
Much obliged.
Number 32,
No notice is required to the, this court is not proposing to issue notice as no adverse orders are passed. Yes.
32, Shankaragowda MB for petitioner.
Appearing for the petitioner, lordship, sixth time, lordship.
September. Next, list in the, at the request, list in the month of September. Yes, 33.
Cell number 33,
Much obliged.
Archana Murthy.
For the petitioner, I represent the respondent for.
My lord, suit for declaration and injunction, my lords, to declare the very sale deed executed, my lords.
What is the IA file?
Under, for injunction, my lords,
It
39(1) and
is
2, my lords. Trial court rejected, my lords. Against that, they preferred an appeal, my lords. In the appeal, it was allowed. And in fact, my lords, here what has happened.
You are the defendant in the suit.
Plaintiffs, my lords. This is plaintiff's petition.
Plaintiff is granted.
No, my lords. My lords, injunction order was for application was filed for injunction, both my lords, by the plaintiffs as well as defendants, my lords. Both IAs were rejected, my lords. Against that, my lords, they preferred appeal, my lords.
So they, in their case, injunction is granted, yours is dismissed.
Please, my lords.
Yes.
And in the, actually, my lords, for rejection of my application was rejected before the trial court, my lords. Against that, actually, I preferred cross appeal, my lords. In the cross objection, what they said, we have to challenge it in before the trial court itself. So now we have filed the MEM, my lords. That is still pending for consideration.
No, this we will decide.
Please, my lords.
Yes.
My lords, suit for declaration and injunction, my lords. Here, what has happened, my lords?
Come to the MA's order. We'll
Please,
read the
my
order
lords.
and we'll understand it.
Please.
Where is
My
it?
lords, before that, I would like to submit, my lords.
You can submit even after reading that also.
Please,
Yes.
my lords.
Order in MA, where is that? Page number.
114.
My lords, reasons, my lords, it starts from 123, in page 123, my lords. And relevant portions, my lords, I'll read it from para 12, my lords.
Yes.
The plaintiff in the plaint stated in para 3 that after due discussion, defendant agreed to purchase the suit item number 1 to 4 properties for total sale consideration of 5,16,000, and they executed a sale deed on 18/3/2008 and same was registered on 19/3/2008. But they received only 25,000, and for remaining sale consideration, defendant issued a check for a sum of 75,000 dated 25/2008. This is actually 7,25,000, my lords.
Yes.
But it is their contention that they have not delivered possession of the property to the defendant. Otherwise, defendant contending that he paid the entire sale consideration, got it registered in his favor. Insofar as check issued by him to the plaintiff is concerned, his contention is that plaintiff expressed their willingness to construct fence around the property and request the defendant to give said work to them, as plaintiff number 2 is a contractor. Believing the same, he paid 18 lakhs through DD. The DD number also stated in the written statement. He further states that he also agreed to purchase the land in survey number 58 from plaintiff, and to that effect also sale agreement executed. but the plaintiffs have not furnished the sketch before sub-register, hence the sale deed not executed in respect of said property. At the time of agreement to sell, the plaintiffs insisted. My lords, may I just read the relevant, my lords?
No, you can read,
Please,
so
my
that the
lords.
court will understand.
The plaintiff insisted the defendant to issue check for security purpose of further assurance with respect to performance of contract and agreement of sale. Hence he issued a check. It is relevant to note that plaintiffs also admitted in the plaint at para 5 that defendant has agreed to purchase another land in survey number 58/1 belongs to plaintiff for sale consideration of 2,34,000. Sketch in respect of said land could not be prepared. Hence execution of sale deed was postponed. In the case on hand, the plaintiffs admitted execution of sale deed dated 18/3/2008 and its registration on 19/3/2008. Now the disputed question is, sale consideration under the said sale deeds in respect of item number 1 to 4 has not been paid and possession not delivered. Hence appreciation of the said deed is also relevant. The said sale deeds are produced before the court by the plaintiffs and now same are ready marked before the court. The exhibit P6 is sale deed dated 18/3/8 in respect of item number 3. Exhibit P7 sale deed dated 18/3/8 in respect of item number 2. And exhibit P8 sale deed dated 18/3/8 in respect of item number 4. Exhibit P9 sale deed dated 18/3/8 in respect of item number 1. Have perused exhibit A, P6 to P9 sale deeds. These sale deeds are admitted by the plaintiffs that they executed the same. The deed shows that all exhibit P6 to P9 executed on 8/3/2008, but same was registered on 23/2008. In the sale deed, it's clearly stated that sale consideration under each sale deed has been paid by cash. It is also stated that vendors put the purchaser in vacant possession of the suit schedule property pursuant to the sale deed and the purchaser acknowledges the same as aforesaid. If exhibit P6 to P9 sale deeds are taken into consideration, there is no recital that sale consideration is pending and possession not delivered. Otherwise, it is stated possession of the property delivered to the purchaser and vendors plaintiff receipt sale consideration. If the contention of the plaintiffs that sale consideration not paid and they not put the defendant in possession of the property or taken into consideration, nothing prevented plaintiffs to state in the deed itself that sale consideration is not paid and in view of the pending sale consideration, check given to them and sale deed subject to realization of the consideration paid under check, and in the event of check is not honored, the plaintiffs are at liberty to get cancellation of the sale deed. In the absence of such recital, we cannot believe at this stage sale consideration not paid and possession not delivered. When registered document is produced before the court, we have to presume the contents in the said document. If contrary is pleaded, it is to the party who pleads contrary to prove the same. In the initial stage, when the deed is produced before the court, we have to presume the contents in the deed and not disputed fact. In the case on hand, defendant contending that he was put in possession of the property under the sale deed and he had paid the sale consideration, the plaintiff disputing the same. The registered sale deed shows that sale consideration paid and defendants put in possession of the property. Under these circumstances, recital that defendant put in possession of the property has to be believed and not disputed fact pleaded by the plaintiffs in the stage of deciding the prima facie case. According to the plaintiff, the defendant issued a check for a sum of 7,25,000. The said check issued in lieu of sale consideration. The said check produced before the court as exhibit P2. Check shows the same was
You can
issued
come
on
to page 22.
Pardon me, my lords.
You can come to page 22, internal page 22, 135 running page.
Please, my lords. The defendant in possession of the property. And they remanded in possession. The prima facie material shows the possession of defendant over the scheduled properties. There was sufficient material to say that plaintiffs have not retained possession over the scheduled property. The registered sale deed which is produced by the plaintiff shows that they put the defendant in possession of the property. Since execution of sale deed is admitted by the plaintiffs, they contending that receiving check they executed the sale deed. We have to believe that under the sale deed possession of the property was delivered to the defendant. My lords, before that, my lords, I would like to submit. Actually here,
Yes.
I submit, my lords.
Yes.
My lords, here what has happened, my lords, at the time of execution of the sale deed, my lords, they expressed, my lords, financial crisis and they entered into an agreement and they issued the check also, my lords.
You're on both I number with regard to the injunction and about.
IN number 7, my lords. IN number 7 was filed by the respondent, my lords, seeking injunction order, which was dismissed against that they preferred MA, my lords.
We are in MA. MA
Please,
is
my
only
lords.
pertaining to injunction.
Injunction.
Then point number 2 is under order 41 rule 27 something.
We have filed an application, my lords. the trial court has not considered.
Yes.
And in that, my lords, we have produced the Bajudar affidavit, license, my lords, building license, everything to show that we are in possession, my lords. Here, what has happened, my lords, at the time of registration, my lords, they expressed financial crisis, my lords, and at the time of executing the sale deed, my lords, they entered into an agreement, my lords, and they issued the post-dated check, my lords. So,
What about all that? We are now on the point of possession.
please, my lords,
You agree both the documents, registered documents.
please, my lords,
In that you say that you have given position to the defendant.
please, my
You
lords.
cannot deny it now. And if you say, though it is stated in that, but it is not, that will be decided in the trial. At this stage, looking at the documents which you have accepted, and there is an abamement with regard to delivery of possession, court has rightly
My
considered.
lords, court just by relying upon the sale deed has come to the conclusion that, my lords, they are in possession.
What else at this stage?
My lords, in fact, my lords, we are in possession. In order to prove the same, my lords,
That will be decided eventually, because
my lords, here, my
when
lords,
you're accepting a document, when you say that you have executed, you are relying, he is relying, then whatever that is contained in the document, you cannot deny.
my lords,
Titles you can't deny.
my lords, let us assume, my lords, even my lords, even then, my lords, in order to prove that we are in possession, my lords, we have produced the building license, electricity bill, tax paid receipts, and photos, my lords, and Bajudar affidavit, everything was produced, my lords. Same was not at all taken into
When was the
consideration.
suit filed?
Pardon me, my lords.
When was the suit filed?
Suit, my lords, after it's 2013, my lords.
2013 is the suit. When did you
Please.
file the IA seeking it?
IA, it was filed, my lords, their application, my lords.
Both your and their application.
Please, my lords. It was filed in the year 2017, my lords.
What was the injunction you sought?
Not to interfere with my peaceful possession, my lords.
Then when is the building permission?
Building permission, my lords, that is annexure. It's in the year 25, my lords, 26/9, annexure V, my lords. Have produced the document, but it's in Kannada, my lords, building license.
There is a question of building permission in the year 2025, and you say that he has interfered with your position in the year 2017.
My lords, to establish, even now we are in possession, my lords, we have produced all these documents, my lords.
What do you say about
Electricity
that?
bill, everything is there, my
What do you
lords.
say about those electricity bills and the building permission?
No, those,
Bajudar affidavit, all these applications were not at all considered, my lords.
those documents are created later on. Your lordship may kindly see, based on the registered sale deed, the Kata and other.
There's one aspect.
May
Who has granted the permission?
The
Property is situated where?
property situated in Mandya district, a rural agricultural land. Actually, they put in possession. Actually, what happened, that check is concerned, my lord. On the same day, we have entered into an agreement to the adjacent land is concerned, which belongs to them only. It has not been materialized due to the fact that the revenue sketch, 11E sketch has not been produced and it has not been registered.
When is the agreement?
On the same day when the sale deed has been,
Date?
that is 18/3/2008.
2008.
They filed the suit after lapse of 5 years in the year 2013. So that has not been materialized. Moreover,
The nature of the property as on.
agricultural land.
Then where is the question of permission to
No,
construct?
we don't know, my lord. That has been produced in the appellate stage before before a MA court. That has been rejected by the honorable court, saying that it has been produced, that too after filing of the suit during the pendency of suit in the year 2025. Suit is of the year 2013. They got those documents in the year 2025.
No,
Before that,
if the permission is granted in 2025, they can't produce it in 2013.
that is right. See, as on the date of the suit, they are not in possession of the property, and those documents are not with them. That those documents they obtained in the year 2025.
Then
We don't know how
electricity bill is in whose name?
that they have not furnished.
I have produced, my lords.
Court has granted injunction in your favor.
Please.
2008, the sale deed. You have
Yes.
been in possession of the property from 2008.
Yes.
What are the documents produced by you to show that you are retained possession
RTC and Kata extracts are produced before the trial court.
are in your name?
Yes, yes, that has been considered based on the sale deed. Those documents are in my favor. Those revenue
Is
entries
it
are
correct
made in.
that the revenue entries are
Yes,
in
yes,
his
it is
favor?
it is absolute.
Even my lords, here, my lords,
They
what has
themselves have
happened?
stated that.
Here, my lords, even Tahsildar has passed an order, my lords, directing to give protection, my lords. Against that, we preferred writ petition before this honorable court, and this honorable court directed to prefer an appeal before the assistant commissioner, my lords.
They prepared
Actually,
it has been-
assistant commissioner has set aside that order, my lords,
Order of what?
giving protection, police
Protection is a
protection.
different aspect.
It clearly establishes that we are in
RTC
possession.
extracts, it will not establish anything. RTC extracts are in his name even till now.
My lords, taking advantage of the sale deed, my lords, they got the kata entries in their
But
name. my lords.
what did you do from
We filed
2008?
objections, my lords, and
2008, where are we now? Please come.
my lords.
Agreed with the order.
One more submission
Notes.
regarding bouncing of check is concerned. They initiated a separate proceedings.
Anyhow, but I'm not going into all
Yes,
that.
yes, yes.
Agreed with the.
My request, my lords, actually, we are in possession, my
No,
lords.
no, that is not.
We are in possession, my lords.
What
We
to
have
do?
produced
We
all the
can't-
documents to
we are
show
only-
that,
we
my
are- We
lords.
are bound by the evidence on record. The present petition is filed. Agreed with the order dated 31/7/2025.
My request, my lords. My lords, actually, we are residing, my lords. Taking advantage of this order, my lords, they'll dispose us, my lords.
When is, from how, from 2017, we are in 2025. Two courts
Till
have.
today, we are in possession, my lords. Till today, we are in possession, my lords. My lords, even kindly look into the electricity bill, my lords. Electricity bill, everything is produced except.
I heard you. The petition is filed. Agreed with the orders passed. Miscellaneous number 17 of 2019 dated 31/7/2025. In I number, what is IA?
IN number 7, my lords.
7 is filed by the defendant, 1 is filed.
Forget about it. Orders passed in MA number 17 of 2019 by the senior civil judge Mathu dated 7/3/2019. The plaintiff is before this court. The plaintiff has filed a suit for
Declaration and injunction, my lords.
declaration and injunction. The suit is of the year 2013. Then in the year 2017, he has filed an I number.
1 filed by the plaintiff, 7
number 1 is filed by the plaintiff seeking injunction, and I number 7 is filed by the defendant seeking injunction. Both the applications came to be dismissed against that. The MA is filed. In the MA, the appellate court has allowed the IA number, the MA filed by the defendant and granted injunction, and dismissed the MA filed by the plaintiff, while allowing an application filed by the plaintiff, by the defendant. The court has observed that the defendant admits the facts that an agreement of sale is executed and registered in the year 2008. In the said agreement, there is a recital with regard to delivery of possession of the property to the defendant.
Sale deed, my lords. Agreement, not sale deed itself.
Sale
Registered
deed,
sale deed.
registered sale deed, wherein it mentions about the money of consideration as well as the delivery of possession to the defendant. The court has observed that when the plaintiff himself is relying on the document, and plaintiff, according to the plaintiff, when he has executed the documents, the court cannot, the case of the plaintiff that he is in possession of the property cannot be decided by the court at this stage, and basing on a prima facie material, the court has come to the conclusion that the defendant is in possession of the property and granted an injunction restraining the plaintiff from interfering with the defendant's peaceful possession and enjoyment of the property. Then counsel appearing for the petition of plaintiff submits that, in fact, before the appellate court, they filed an application under Order 41 Rule 27 And as placed before the court, the permission that is granted by the local authority for construction, and also the electricity bill to show that they are in possession of the property. Land council submits that they are in possession of the property and never the possession was delivered to the defendant. It is submitted that now, even till today, they are in possession of the property. If any order is passed by this court, they would be dispossessed from the land. It further submitted that with regard to the sale consideration and other things, they have taken a specifically that the post-dated checks which were given by the plaintiff were dishonored and they have not received any sale consideration.
Only 25,000 were, only 25,000 was
Only
received.
25,000 they have received, and all these aspects were not considered by the trial court as well as the appellate court. And the appellate court has granted injunction in favor of injunction against the plaintiff and in favor of the defendant. It is submitted that if the appellate court considered the considered the evidence that is placed by the plaintiff under order 41 rule 27, all these facts could have come to the notice of the court, and the court ought to have granted injunction as pleaded by the plaintiff. It is submitted that the order passed by the appellate court has to be set aside. Any other grounds?
Please, my lords, even my lords, Tahsildar order for protection was.
It is submitted that when the petitioner has filed an application, when the respondent has filed an application seeking police protection, when that was granted, the petitioners have come before the court, and this court has gave them the liberty to go before the appellate authority, and the appellate authority has set aside the order. It is submitted that also supports the case of the plaintiff.
And even, my lords, we have produced the complaint filed against the respondents, my lords. They tried to
They have
destroy
also
the two, my
produced
lords.
the complaint.
Both
It is
have
given
filed each other.
against the defendant, and the same was not considered. Next, Land counsel appearing for the respondent submits, the respondent defendant submits that the registered sale lease of the year 2008, ever since, and the deed clearly shows that the property possession was delivered, and ever since they have been in possession of the property, all the revenue records are mutated in their name, and the property is an agricultural land. This document of building permission of 2025 is 2025 is produced when the RTC extracts and all other revenue records that are in the name of the petitioner. There is no question of granting any building permission in favor of a person who is not the owner of the property. All these aspects were rightly considered by the court, and the court has granted injunction. It is submitted that there are no grounds to interfere. Anything else?
That's all.
Having heard the land counsel.
One more, regarding check bouncing is concerned, they have initiated a separate proceedings. And
With regard to the dishonor of the checks, they have already initiated the proceedings and the negotiable instruments.
Supreme Court says
and the
so,
same,
Supreme Court says once sale deed is
That is not,
executed. No, if
and
check
they-
is
they have
issued, they have
filed-
to go for recovery only, not
They
cancellation.
have filed a complaint under the Negotiable Instruments Act. The same is pending adjudication before the competent court.
Please.
In the light of the said complaint given by the petitioner, he cannot simultaneously pursue a civil suit. Next part, having heard the counsels on either side, produce a material on record. Undisputed facts in this case are a sale deed is executed and registered in the year 2008. As per the covenants of the said recitals of the said sale deed, the amount is paid, the consideration is paid by way of cash,
Cash on.
and the possession is delivered. According to the plaintiff, the possession is not delivered, the amount is not paid. They have given a post-dated checks and they were dishonored.
And they have executed an agreement, my lords, consent
They have-
agreement,
And they have
and
executed.
issued a post-dated check, my lords.
And they have executed an agreement and issued a post-dated checks. At this stage, at an interlocutory stage. When the suit is filed in the year 2013, 2017, the IA is filed. At an interlocutory stage, the court cannot conduct a mini trial. As far as the material that was placed before the court, the admitted agreement being the registered sale deed, admitted document being the registered sale deed, which speaks about delivery of possession. And also the fact that the revenue records right from 2008 till now stands in the name of the defendant. The court looked at the prima facie case and the material on record, and rightly, the appellate court has rightly granted injunction. It is a contention of the plaintiff that 2025, there was a permission granted to the plaintiff to construct the house. And also there are electricity, there are also receipts shows the name of the plaintiff. Admittedly, the property that is sold is an agriculture land. RTC extracts sale deed in favor of the defendant. In that case, how the permission is granted to the plaintiff to construct the house is which has to be gone into by the court while considering the suit, while considering during the course of trial. At this juncture, the material that is available on record is enough to come to a to decide an application seeking injunction, and the plaintiff and the defendant has rightly proved the prima facie case, balance of convenience and irreparable loss, and the court has rightly rightly granted injunction in favor of the defendant. In that view of the matter, this court do not find any reasons to interfere. Dismiss.
Till number
My
34.
request, my lords, at least for status quo, my lords.
No. 34, Narayan Swamy PM.
Yes.
Petitioner is
Ines Vishwanath for
one,
Kevita.
1 week time.
Huh?
1 week time. Sin is not.
This is matter in the month of September.
Till number 35. Jairaj DS for petitioner. P. Lokesh for Kevita.
The caveat, we have also informed them.
No,
Could
it is not necessary. How many are the respondents?
What? Only one.
Huh.
Come on,
Yes.
sign it here. Well, I'm just short, I won't take you. What happens is, I buy a property. Actually, I agreed to buy 2 acres, 24 guntas. There is an advance receipt for 24 guntas. For some reason, sale deed is executed for 2 acres. And very honestly, there is no document here. Government,
24 guntas is concerned.
it's only for 2 acres, but there is only one document. What happens is, before they file the suit, if your lordship comes to page number 266, I've given a translation to your lordship yesterday.
Yes.
This is given by the respondent to the police. Respondent's son to the police. Please see the translated copy, the 3rd paragraph. In order to have our land surveyed and officially demarcated, we submitted an application before the survey department. Pursuant to the said application on 7/2/2025 at about 10:15 a.m., I accompanied the survey officials to the property. During inspection, it was found that Nirman Shelters had included our 24 guntas of land within its layout and had already constructed residential houses. Then, please see over the page. The survey officials issued notice on 2 occasions directing the company to produce relevant title documents related to disputed land. However, the company's advocate so-and-so failed to produce any document and prevented the survey and demarcation from being carried out. Taking advantage of the situation and without our knowledge, the company unlawfully encroached upon our ancestral land, formed a layout, constructed houses.
This is part of the.
Yes, yes, part of the trial court records. Now what happens is, please come to the trial court order at page number 211, 213.
213.
Page 213 of the paper book, para 23.
Yes.
Further, as per the complaint averments, the plaintiff
Para
has
20?
sought advice to Nirman developers. Para 23, last para of that page.
Yes.
Further, as per the complaint averments, the son of the plaintiff has sought to advise Nirman developers of the company from interfering in the possession of the land. Further, these documents have not produced any document regarding the further status of the complaint. My lord, apart from this 6 lines, there is no consideration of this possession. My lord, with great respect, my lord, on the date of suit, he should have been in possession. He says he's not in possession. In fact,
We'll go to para 24, the last para.
admittedly, the ex parte temporary injunction is granted under court, but the registered sale deed executed by the mother-in-law and husband is of the year 2005, and advance sale receipt is 2004. Has placed record on RTC with the name of Ramaswamy to the extent that, well, we are not in a title suit at all. 127 is a suit filed by a purchaser. This has nothing to do with my property. One of the purchase, I produce even that 127, I have produced the sale deed, I mean the plaint, my lord. Page 157 is the one Mr. Manohara Chandrappa has filed a case against
Please come.
this Ramesh and others, the whole family.
The present petition is filed.
May I request your lordship to permit me one matter reaching.
No, what I am not able to understand
Yes,
is
my lord.
when an application is allowed, injunction is granted.
Yes.
And why you are before this court?
No, I'm a defendant, my lord.
After hearing both of you.
Yes, yes. That is why I am before this court.
Please. Agreed with the order. Past 9 number 1 and OS number 192 of 2025, dated 27th October 2025, by third edition civil judge and JMFC Anekal, whereby the court has granted injunction in favor of the plaintiff, restraining the defendant from interfering with the peaceful possession and enjoyment of the plaintiff. The defendant is before this court. The respondent herein has filed a suit for bare injunction, restraining in respect of 24 cents of land.
Yes.
In respect of 24 cents of land, and direction to the seeking a direction, restraining the defendants from interfering with the peaceful possession of the plaintiff as far as 24 guntas are cents.
24 guntas.
24 guntas of land.
0.24 guntas.
24.24 guntas of land. The 24 guntas of land. In that, he has filed an IA number 1 seeking injunction. The trial court, by order impugned, had granted injunction. While granting the injunction, the court has observed that as per the complaint averments, the son of the plaintiff has sought to advise Nirman developers and the company advocate from interfering with the possession of their land. Furthermore, the defendants have not produced any documents regarding the further steps of the complaint lodged by the son of the plaintiff. The court observed that admittedly, the ex parte temporary injunction is granted by the court in OS number 127, or what is that 127 of 2020?
That is the subsequent purchaser from the hands of the
127 of 2025. But the registered sale deed executed by the mother-in-law and husband of the plaintiff is of the year 2000, and the advance sale receipt much relied upon by the defendant number 1 is dated 13/12/2004. And moreover, the plaintiff has placed on record the RTC of survey number 144/1, wherein the name of Ramaswamy is entered to an extent of 34 guntas. Hence, on the basis of the registered sale deed, RTC survey documents, tax paid receipt, the plaintiff at this stage has made out a prima facie case. Further, the court observed that this view is only tentative without prejudice to both the parties. This is not enough for the plaintiff to make out the prima facie case. Further, the plaintiff has to show that the balance of convenience also lies in her favor, and the court is to consider to whom the more hardship and inconvenience would be caused if the temporary injunction is not granted, and ultimately, if the defendants interfere with the plaintiff's peaceful possession and enjoyment of the suit scheduled property, then the more hardship will cause the plaintiff than to the defendants. Hence, it appears that the balance of convenience lies in favor of the plaintiff, And also plaintiff would be put to irreparable loss and injury, which cannot be compensated in terms of the money. Hence, the court has allowed the IA restraining the defendants by way of temporary injunction, granted a temporary injunction restraining the defendants from interfering with the peaceful possession and enjoyment of the plaintiff in respect of the suit scheduled property till disposal of the suit. Then a senior counsel appearing representing the counsel for the petitioner submits that the suit is filed for bare injunction. It is an admitted fact that the suit scheduled property, that the plaintiff has, the defendant has purchased the property by way of a registered sale deed dated 14/12/1994. That is an extent of 2 acres of land in survey number 144/1. It is a case that in fact the agreement is in respect of 2 acre 24 guntas. However, in the sale deed, only 2 acres, an extent of 2 acres is reflected. Further, it is submitted that when a person files a suit for injunction, he has to prima facie prove that he is in possession of the property. Then the senior counsel has drawn the attention of this court to the complaint, which is referred by the court at paragraph number 23 of the order, which is given by the son of the plaintiff to the police inspector, Jigani Police Station, Anekal District, Anekal Taluk, wherein he has stated in the said complaint that in order to have our land survey within inverted commas, in order to have the, no, it is stated that not inverted commas, it is stated that in order to have their land surveyed and officially demarcated within brackets 4D, they filed, he has made an application before the survey department. Pursuant to the said application on 7/2/2025 at about 10:15 a.m., he accompanied the survey officials to the property. During the inspection, it was found that Nirman Shelters Company had included 24 guntas of land with its layout and had already constructed residential houses over it. The survey officials issued notices on 2 occasions, directing the company to produce the relevant title documents relating to the disputed land. However, the company's advocate, Mr. Patil, failed to produce any documents and prevented the survey and demarcation proceedings from being carried out. Taking advantage of the situation and without knowledge, the company unlawfully encroached upon the ancestral land and formed a layout and constructed houses, thereby causing serious interference with the lawful possession and enjoyment of the property. The senior counsel, basing on this, submits that the complaint given by the plaintiff's son clearly shows that the plaintiff is not in possession of the property. And according to them, it is already encroached by the defendants and they have made constructions. In those circumstances, question of granting injunction would not arise, and he has not made out a prima facie case. In fact, if an interim order is granted, interim injunction is granted, it would cause hardship to the defendant, and the balance of convenience is in their favor. This matter came up yesterday, and as in the cause list, it shows that a caveat is filed by one Mr. Lokesh, advocate, on behalf of the first respondent plaintiff. The matter was passed over, directing the petitioner to inform the counsel, as his name is also reflected in the cause list. He didn't appear either in the forenoon or in the afternoon. Then to give him an opportunity to appear and argue the matter is posted to today. And then counsel for the petitioner submits that they have informed the same to the Learned Counsel who has filed the caveat, and also they have filed a memo stating that they have intimated the caveator regarding the listing of the matter through email and WhatsApp, even before the matter came up. And when the matter is adjourned to 15/7/2026, The advocate for the petitioner has once again intimated the caveator about the adjourned hearing through email and WhatsApp. And they have placed the email and also the WhatsApp communication before this court. Considering the fact that enough opportunity is given to the respondent and which she has failed to avail, this court is proposing to pass the order on the merits of the matter. Next, having heard the learned counsel for the petitioner, peruse the entire material on record. The undisputed facts in this case are the plaintiff executed.
Please,
The plaintiff has executed.
plaintiff's mother-in-law and husband.
A mother-in-law and husband have executed a registered sale deed in favor of the defendant for an extent of 2 acres. It is 2 acres. It is according to the plaintiff, they have encroached another 24 guntas of land and made the construction. And according to the defendant, there was an agreement for 2 acre 24 guntas. However, in the sale deed, the extent is shown as 2 acres. When the sale deed shows that it is an extent of 2 acres, then the court can only consider what is there in the registered document, that is 2 acres. Then coming to the relief that is sought in the suit is a bare injunction in respect of 24 guntas. As rightly argued by the senior counsel appearing for the petitioner defendant, when the plaintiff files a suit seeking bare injunction, he has to prove that he is in possession of the property and the respondent defendant is interfering with his peaceful possession and enjoyment of the property. A close perusal of the complaint that is given by the son of the plaintiff clearly reveals that already the defendants have encroached the property and they have made constructions. In that case, the court can presume that the defendants are in possession of the property, but not the plaintiff. In those circumstances, the plaintiff respondent is not entitled for any injunction as he failed to prove his position in respect of the property, and the complaint that is given by him to the police shows that the defendant is in possession of the property. Hence, the plaintiff is not entitled for injunction. If basing on this observation of the court, this court has not expressed anything with regard to the plaintiff's entitlement to the property, or this court is not giving any finding with regard to the plaintiff's possession in respect of 24 guntas, whereas as per the sale deed, he has purchased only 2 acres. As far as the observations that are made by this court are as far as an application seeking injunction and what are the ingredients that are to be fulfilled for grant of injunction. Next, in the light of the above discussion, this court is of the considered opinion that the court has failed to consider the application. Therefore, the court has granted injunction without the plaintiff fulfilling the ingredients for grant of a temporary injunction. In that view of the matter, this court is passing the following order. The order dated so and so, passed by so and so is set aside, and writ petition is allowed.
Then 36. Balnikit for petitioner. Anupama Bododi, respondent.
This is a patently perverse order, my lords. The impugned order, patently perverse. We raise a challenge under Order 7, Rule 11. 2 grounds are raised before the learned trial court. Territorial jurisdiction, saying that neither the defendants nor the plaintiff fall within the territorial jurisdiction of this honorable court. The second ground is they do not fall within the definition of commercial dispute. What the learned trial court does is, it comes to the conclusion that they fall within the territorial jurisdiction of the Honorable Court, and hence it is a commercial dispute. Kindly see page number 22 of the petition, the impugned order, paragraph number 15, my lords. That is the sum and substance of the order, my lords. Paragraph number 15, my lords. The judgments relied by both the
We'll
parties.
go to para 11.
Sorry?
From para 11, we'll read.
Parallel, yes. Reason start from there.
Yes.
I have gone through the application, objections, plaint, and citations relied by both sides. In the plaint, the plaintiff has averred that the defendant number 2 was working with the plaintiff, and he has, I think,
What is the suit for?
well, this is a suit filed them for recovery of money. The allegation by them is we are both in competing business. They are a company, I am a company. We are both involved in selling of false ceilings, my lords, PVC false ceilings. They admittedly in the plaint they say that they are my competitor. Video has surfaced where a comparison of their PVC and my PVC has been made. They allege that we have created that video and it is distributed in the market.
They're seeking damages.
They're seeking damages, man. Suit for recovery of money, seeking damages. We have taken the contention is none of the defendants are in Bangalore, nor is the plaintiff in Bangalore.
Both the companies are situated where?
Outside in Bombay, my lords. Outside.
Both of you are in.
Yes, the plaint, may I show you?
Where is this surfaced? This videos?
According to them, my lords, they say that we sell some business here in Bangalore. But I'm not on that point.
No.
I'm on the point of it falling
as far
under.
as territorial jurisdiction is concerned.
That is not pleaded. It is not pleaded is my contention. During the course of oral arguments, they refer to certain documents in the plaint.
What they have stated so in the plaint is what is relevant.
Yes, for that I will draw your lordship's
Let
attention.
us read from paragraph number
Yes.
11.
I have gone through the application, objections, plaint, citations relied by both sides. In the plaint, the plaintiff has averred that the defendant number 2 was working with the plaintiff. He was resigned from the company on 6/1/2025 without serving the requisite notice period and sent email. He joined in the year 2020 and subsequently in 2024 was promoted to the position of general sales manager. After resigning, he was joined defendant company, para 12. The defendant number 2 was familiar with the company's products and their features. Upon joining the defendant company, defendant number 2 has engaged in a malicious.
You can come to para 14.
Yes, grateful. By these slanderous videos, the defendants proceeded to circulate it widely, targeting customers of the plaintiff, and the defendants were also approached the customers of the plaintiff, sending the private messages and videos to avoid legal scrutiny. They have made this mischief against the plaintiff. Therefore, the video circulated within the jurisdiction of this court. That, my lords, factually is wrong, but I'm just reading it. Along the plaintiff has produced the documents, also marketing accounts for the sale of his products worth rupees 14 crores 11 lakhs 60,876 to establish his business in Bengaluru. The mail and the documents annexed with the plaintiff are shown that the plaintiff is running a business. Here, my lords, the plaintiff is running a business, not the defendants. The plaintiff is running a business in the city of Bangalore, and the WhatsApp chats were shown that the defendants are sending private messages to the customers of the plaintiff. Therefore, which requires a detailed trial, and without trial, this court cannot come to the conclusion that the court is not having territorial jurisdiction. Furthermore, the documents produced along with the plaint clearly disclose that this court is having territorial jurisdiction to entertain this search.
The statement. Please, Malan.
Is it? It's
Look at it. Please, therefore, which requires a detailed trial, and without the trial, this court cannot come to the conclusion. The court is not having a territorial jurisdiction. Please, Malan. So, but ultimately, what is the finding? Furthermore,
Yes,
read that at
Yes.
page number 9, bottom.
Yes.
Furthermore, the documents produced along with the plaint clearly discloses that this court is having territorial jurisdiction.
Yes, my lords. My lords, I will demonstrate with the plaint. I order, my lords.
Forget about it.
Yes, my lords.
Court at one sentence before says,
Yes,
it will decide the territorial jurisdiction after a full-fledged trial.
If at all it is required. my lords.
Then it says court has got territorial jurisdiction.
Please, my lords.
No, there is no connection between both the sentences.
My lords, maybe.
So, this sentence has to be clarified.
It has to.
First, the court will decide.
Yes.
About the territorial
Yes.
jurisdiction. Then next.
Yes.
Then let us may continue reading paragraph 15. The judgments relied by both the parties, the videos were sending by the defendants and also through WhatsApp within the territorial jurisdiction of Bengaluru in respect of Vox panels and which causes the business of the plaintiff. Therefore, the alleged dispute between the parties are commercial in nature. But we have specifically stated the definition of commercial disputes is under section 2. It is an exhaustive definition.
Let us,
May I continue just reading before that? There's 3 lines.
I have completed.
Then we lordship has already.
Yes.
Under section 2(1), my lords, and this is pertinently, there is no pleading in the plaint saying this dispute is commercial in nature.
Let's.
Kindly, if your lordship may. Section 2(1) subclause C, my lords.
Yes.
Commercial disputes means a dispute arising out of ordinary transaction of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including the enforcement and interpretation of such documents. There is no transaction between this
Let's
one. We
go
are not.
further. We'll see which.
Yes.
Which, according to you will fall under which.
My lords, I am under 2(1) and 2(17).
17.
Yes, my lords. Intellectual property rights relate 2(1) and 2(17).
14, 17. Intellectual property rights.
Yes.
Relating to registered and unregistered trademarks.
Yes.
Copyright, patent, design, domain names, geographical. No, that is not your case.
My lords, arising out of.
None of those
My lords,
words are mentioned in the
My lords,
plaint.
may kindly see the word C. Commercial dispute means dispute arising out of.
We'll read
Yes.
and continue
Yes.
along with this.
Yes.
Commercial dispute means a dispute arising out of
Out of.
intellectual property rights.
Yes, ma'am. Also, my lords, ordinary transaction of merchants, bankers, financial traders, such as those relating to mercantile documents, including enforcement and interpret.
When are you reading this?
My
We are
lords,
at
1 also. 1 C1 arising out of is the important, my lords, that has been interpreted by the judgments of the Honorable Delhi High Court, which I will rely upon, my lords. Similar.
Here, there is absolutely no transaction between you and him.
With
the plaintiff and the defendant, there is no any other formal business transaction is not.
he
there.
was our
It's
employee.
only your case that
He was our employee, my lord.
he was your employee,
Yes,
whatever.
madam.
No, he has floated some WhatsApp chats, and because of that,
He
your
has
business is affected.
Yes, my lords. He has put 2 panels. He has put in one. He has put plaintiff's model, and in another he has put his model.
He tried to show that his whatever the
Comparison.
other one is.
Yes, my
better
lords.
than
He
yours.
named my product. He shows my product. Put a material on that product. Tries to remove it and shows that if you put this material in this particular plaintiff's product, it will get damaged. It's a very
judgment you're relying upon.
Please, my lords.
Please pass on.
That's in fact, we are relying on certain judgment says this is an exhaustive definition. It
Let's
cannot
see.
be widened.
First, you give that.
That's my file it.
Take that also, Anita.
Our-
Yes.
In fact, these judgments, we have produced them before the learned trial court also. my
Yes,
lords,
my lords. That has
which
been
requires-
considered, my lords.
Yes, please.
Not the first judgment, my lords, in the memo of citations, Meena Vora, it's a Delhi High Court judgment, my lords.
In which case?
Meena Vora versus Master Host, my
Which
lords.
para you're relying on?
Page number 9, para 23, my lords.
Para 23.
Encircled page number 9, my lords, paragraph 23. What the Delhi High Court does it extracts, in the previous page, my lord may say, it extracts that whole section, para 23, my lords. This provision sets forth an exhaustive enumeration comprising of 22 specific categories of disputes that qualify as commercial disputes. By providing this exhaustive list, the legislature has unequivocally articulated the scope and extent of the matters falling within the definition of commercial dispute, thereby ensuring clarity, precision, and predictability in its application. The exhaustive nature of the enumeration underscores the legislative intent to prevent ambiguity and arbitrariness by way of overbreadth or underreach, thereby facilitating a clear demarcation of the jurisdictional boundaries of the commercial code. Consequently, disputes falling squarely within these stipulated categories can readily be identified and addressed under the special mechanisms as envisaged in the Act of so and so, thereby streamlining. My lords, in that same judgment, my lords, para 16 also, my lords, page number
16.
Yes, my lords, para 16, page number 49, my lords.
60.
I'm sorry, my lords. I'm so sorry, my lords.
It
if-
only contains 54 paras.
Yes, I'm sorry, it's a different, this one. My lords, if we may go to a Supreme Court judgment on this by Honorable Justice Bopana, serial number 5, my lords, Ambalal Sarabhai Enterprises versus
Which
case.
para you're relying on?
Para 14, page number 83, my lords. Page, encircle page number 83, my lords.
Yes.
Just
Yes,
para 14, my lords.
yes.
My lords, after para 14, few lines of para 13 I'll read why this is necessitated, how it will clog the system. Para 14, in that view, it is also necessary to carefully examine and entertain only disputes which actually answers the definition of commercial disputes
When are you
as,
reading at para 13?
sorry, my lords, para 14, my lords, para 14.
That view is also necessary. No, you said you want to read some from para
Yes,
13.
my lords, para 13, my lords, in that same page, from the top 1, 2, 3, 4, 5, 6, 8th line, my lords, having taken note of the submissions. Having taken note of the submissions, we feel that the very purpose for which CC is the Commercial Codes Act of 2015 has been enacted would be defeated if every other suit merely because it is filed before the commercial court is entertained. This is for the reason that the suits which are not actually relating to commercial dispute but being filed merely because of high value and with the intention of seeking early disposal would only clog the system and block way for genuine commercial disputes which may have to be entertained by the commercial court as intended by the lawmakers. In commercial disputes as defined, a special procedure is provided for a class of litigation and a strict procedure will have to be followed to entertain only that class of litigation in that jurisdiction. If the same is strictly interpreted, it is not as if those excluded will be non-suited without a remedy. The excluded class of litigation will in any event be entertained in the ordinary civil court wherein the remedy has always existed. Para 14, my lords. In that view, it is also necessary to carefully examine and entertain only disputes which actually answers the definition of commercial disputes as provided under the Act. In the instant case, as already taken note, neither the agreement between the parties refers to nature of immovable property being exclusively used for trade or commerce as on the date of agreement, nor is there any pleading to that effect. In this case, my lord, there is no pleading that this is a commercial suit. So, my lords, relying on this examination has not been done by the learned trial court. My lords, the lords may see that impugned order, paragraph 15. One he says because territorial jurisdiction is there, it is commercial in nature. If I may just read that the remaining portion, he says, therefore, the alleged dispute between the parties are commercial in nature, though directly the act alleging.
Sir, two options are available to you.
Please, Anand.
One is you want me to consider and pass orders on the merits is one. Number two is with regard to the commercial nature of the
Yes, ma'am.
suit.
Yes, ma'am.
There is no finding.
Yes.
If you want me to remand the matter, I'll remand. Or else you want this court to consider, I'll consider. Either way.
My lords, may kindly have it tomorrow. I will be able, he has given me certain judgments. I will think about it and I'll come before my lords.
Tomorrow I'll take up.
The matter
Tomorrow
is
in the
actually
first.
listed today.
It's okay.
Before the
My
trial
lords, this is
court.
for 39-1 and 2, my
Or
lords.
it's on
Hearing
39, 1 and 2.
39
They have
Tomorrow I'll hear.
Yes, ma'am. They have an ex parte interim order.
Don't
my
proceed with tomorrow.
lords. We'll have
No,
it.
my lord, 39-1 and 2 only. That is a.
Tomorrow, this is matter tomorrow in the first place. And basing on what I can pass orders.
Yes,
on-
my lords, I will make submissions on that.
They must not, they already have an ex parte interim order. They must not, they are
Injunction,
pursuing
injunction
39, 1
rest,
and 2.
injunction rest, my.
At least till tomorrow,
My
today they
lords,
must not.
Tomorrow
do.
what they will do.
Yes.
If she, orally she said there's
No,
more
no,
than-
not that, my
Oh.
lords. It is,
Yes.
by the
Great,
time,
sir.
my lords, I finish it, that 39-1 and 2 arguments also must have been over.
Great, sir.
My lords, instead of tomorrow, day after 16, I have a matter. I have a matter before Kalburgi.
Great.
We make one submission, my lord. List number 2, my lord.
No submissions at 1:30. If you have anything.
No, my
write it
lord,
on- write
to
it
take
on-
up the matter at
That's
2:30.
what, morning I said, morning I have given option to everyone to mention 2:30 matter if you want anything. But everybody, nobody is understanding it. Everybody wants to make some submissions or the other. what is happening? Neither I'm able to complete the rest. And morning that mentioning phase is going on for 1 hour, 1.5 hour. So anything, give it to the court officer. I will look at it and consider.
Please,
Not today, tomorrow morning.
please,
you
madam,
will
please,
do
madam,
that.
please, madam.
Send those memos to the chamber.
ಸರ್ ಒಂದು ಮೆಮೊ ಬಂದೇ ಇಲ್ಲ
ಮೇಡಮ್ ಸರ್ ಒಂದು ಗ್ರೀನ್ ಚೆಕ್ ಕೊಡಿ
ಏನಂದ್ರು 2:30ಗೆ 2:30ಗೆ
ರೀಚ್ ಆಗಲ್ವಲ್ಲ ಮೆನ್ಷನ್ ಮಾಡಿಬಿಟ್ಟು ಕೊಡಿ ಅದು
Court officer, am I audible? Court officer?
ಹೇಳಿ ಸರ್. ಸರ್ ಹೇಳಿ ಶ್ರೀನಿವಾಸ್ ಸರ್. ನೀವು ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ.
ಇಲ್ಲ ಕೇಳಿಸ್ತಾ ಇದೆಯೋ ಇಲ್ವೋ ಅಂತ ನೋಡಕ್ ಮಾಡಿದ್ದೆ ಮೇಡಮ್.
ಇವಾಗ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಅಯ್ಯೇ ಬೇಡ, ಯಾಕೆ ಇವಾಗ ಸಿಕ್ಕಿದ್ರು ನನಗೆ ಸರ್ ಮಾಮೂಲಿ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಬನ್ನಿ, ನೀವು ಯಾಕೆ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಅದೇ ಏನು ಮಾಡಿದ ನಾಳೆಗೆ ನನಗೆ ವಾಪಸ್ ಕೊಟ್ಬಿಡೋದು ಇದು ಸ್ವಲ್ಪ ರ್ಯಾಪರ್ಸ್ ಎತ್ಕೊಂಬ ಸ್ಟೇಷನರಿನಲ್ಲಿ ಒಂದು 4 ರ್ಯಾಪರ್ ನೆನ್ನೆ ಬರ್ಸ್ಕೊಳ್ಳಿಲ್ಲ ನೀವು ಮರ್ತ್ಬಿಟ್ಟೆ ಹೇಳಿ ಲಿಸ್ಟ್ ಒಂದಲ್ಲ ಲಿಸ್ಟ್ 2ನ ಸರ್ ಈಗ ಕಾರ್ ಲಿಸ್ಟಲ್ಲಿ ಎಷ್ಟಿದೆ ಅದು ಲಿಸ್ಟ್ ಒಂದಲ್ಲ ಲಿಸ್ಟಲ್ಲಿ ಇಲ್ವಾ ಲಿಸ್ಟ್ ಹಾಕಿಲ್ವಾ ಅನಿಲ್ ಆಚೆ Just continue. Serial number 37.
Malad, and pass over matter, Malad, may seek to be taken, Malad.
Oh, that electricity matter is there, that you please.
Yes.
That pass over electricity, that matter.
Serial number, list number 1, 230 pass over matters. Serial number 7.
Yes.
Malad,
What are your
I appear
instructions?
disconnected, Malad.
Take that.
It is disconnected on 13/7, but they say it is disconnected on 2/7, my lord. I'm seeking restoration of the connection, my lord.
No, ultimately, what are your instructions?
Ultimately,
It is below
cabinet-
2,400.
cabinet-
It is below 2,400. So he is entitled for that, first of all.
Now, according to this notification order, they are required to file fresh application within 31 from the date of this order. Within 15 days from the date of this order, they have to file application. Now there is a delay. Your lordship may, with appropriate order,
No.
permit them to
No,
file
no.
application.
They will file application. What about the power supply?
It will
Restore it till further orders are passed. The same thing in all three matters?
Yes, sir.
My lord, in last matter, there is no disconnection, my lord. It is only a threat of disconnection. Bholanath case, my lord, last matter, my lord, there is.
No, 1 minute.
I'm
No,
sorry,
in this,
That,
come to serial number.
374.
Now, serial number 7 and 88 already disconnected.
Yes, my lord. Yes, my lord.
9, so what I'll do is in 7 and 8, I'll pass a common order.
Please.
Yes.
Please, my lord. Please, my lord.
Writ petition is filed. WP number 21370 of 2026 and WP number 21374 of 2026. The writ petitions are filed seeking the following prayer. Land counsel for the petitioner submits that the entire extent is less than 2,400 square feet in both the
my lord.
cases.
No, my lord. No, my lord. I'm sorry, my lord. In the first case, it's not the case, my lord. Only in the second case, in only Avinash case, it is 2,000 less than 2,400. In one case, it is more than 2,400, my lord. For that is why in the first petition 370, I have not quoted that circular, my lord. I have not quoted that circular in the first writ petition.
Then what
And-
about 21370?
My lord,
370.
BBMP, my lord, BBMP have not taken any action so far as against the building, my lord.
Yes,
Just they have directed.
The other judgment will apply.
Yes, my lord. His Lordship Justice Suraj Govindra's judgment will apply in full force, my lord.
Independent orders. 21370 of 2026. The writ petition is filed seeking the following prayer. Is a case of the petitioner that the petitioner is absolute owner of the property bearing site number 60 Hamlet layout measuring east 78.46 feet, west 62.08 and north 43.24 feet, south 40 feet, totally measuring 2,812 square feet. Situated at Chennasandra village.
That 375, the lordship may pass the order not to precipitate. Take proper instruction itself.
So you don't want, no, but in the light of this order.
But the thing is, whether
Then I'll do
how
one
much
thing.
flow
No,
goes
I'll
in-
record this judgment, this order, and I'll ask her to forthwith restore the power supply and I'll keep the writ petition pending.
Yes.
The so-and-so. Chennasandra village, Bidarhalli, Hobli. It is stated that the petitioner has constructed the building. It is on the verge of completion. The third respondent has suddenly disconnected the electricity connection, power supply to the building on 13/7/2026 without issuing any notice. And when the same was inquired, they have issued one antedated notice dated 27/5/2025 stating that the BBMP has directed to disconnect the power supply immediately. it is submitted that the BBMP has nothing to do, basing on the letter issued by the BBMP, the BESCOM cannot disconnect the power supply. He has relied on a order passed by a coordinate bench in WP number 17679 of 2024, clubbed with WP number 26870 of 2023, dated 26 February 2026, and submits that the disconnection is bad. Next para. Learned Council appearing for the respondent 1 and 2.
One and two.
Respondent 2 and 1, AGA takes notice. Respondents 2 and 3. Huh?
2 and 3.
2 and 3 submits that he'll get instructions, and he'll file his objections. Next para. Considering the submission of the Land Council for the petitioner and the judgment of the coordinate bench of this court and WP number 17679 of 2024 and clubbed with so referred supra, the respondents are directed to forthwith restore the power supply, subject to petitioner paying the and also not subject to, the petitioner shall continue to pay the consumption charges. This is matter on September 9th for filing objections. Yes, next matter.
That is less than 2004.
Less than 2,400 square.
This is WP 21374 of 2026, serial number 8. The writ petition is filed, seeking the following prayer. The facts of the case are that the petitioner is the absolute owner of the property, bearing site bearing number 120 in Hamlet layout, measuring 2,000 square feet, carved out of survey number 143 and survey number 154, both situated at Chennasandra village, Bidarhalli, Hoppi, Bangalore, East Taluk. It is a case that petitioner has purchased a property by way of a registered sale deed dated 10/10/2022.
Construction is completed and permanent electricity meter is also issued, my lord.
He has been given permanent electricity connection on 8/7/2024. Land Council for the petitioner submits that as per GOMS number, as per, what is this? GOMS number? Where did you mention about this GO in your
writ petition, my lord? My lord, I have referred you it, and my lord, it is in page number, my lord, annexure D, my lord, annexure D.
No whisper in the petition.
My lord, paragraph number 5, my lord, paragraph number 5.
What did you say?
It is relevant to mention here that the respondent number 2 and 3 have furnished, it should have been published a circular that stating that the persons exempted.
By the government dated 22/6/2026, wherein the properties, the property which is less than 2,400 square feet is exempted from furnishing the occupancy certificate. It is submitted that the petitioner has constructed the building long back and also obtained necessary electricity and water connection to the building. It is submitted that the notice the respondents have issued a notice dated 27/5/2025, threatening to disconnect the electricity on the ground that the GBA had directed to disconnect power supply immediately on the ground that it is an illegal construction. And on 2/7/2026, they have disconnected the power supply. It is submitted that in the light of the said notification issued by the government dated 26/6/2026, the action of the respondent is arbitrary And basing on the said communication issued by the GBP, they cannot disconnect the power supply. Land Council appearing for the respondent 1, 2 and 2 and 3 has placed before the court the GO, the notification that is issued by the government dated 22/6/2026, stating that the concern, the parties who are claiming the benefit have to submit the application within 15 days from the date of, from 22/6/2026.
Well, since I was having a permanent electricity connection, I have not made such application, my lord. I was having it as on the date of
He's having
GO
a
also.
fetch connection. He's having a permanent connection.
Permanent connection, my lord. That was never insisted upon.
It shows having permanent connection on or before 30. Three classifications are made. First classification connection having as on 31/5/2020.
Petitioner, seeking the said exemption, within 15 days from the order, they have to make an application. It is submitted that if the application is filed, they'll consider the same in accordance with law. Next para. Having heard the counsels on either side, there's a material on record. The respondents, basing on a communication given by the BBMP, have disconnected the power supply without even issuing any, without following the principles of natural justice. According to the petitioner, after the show cause the notice
Annexure E.
Annexure E, my lord.
No, in this case, you have received the notice.
He has received the.
My lord, in fact, it was.
Antedated.
It was also antedated when it was served, my lord. It was
You
received.
didn't say so in your this writ petition. In a hurried manner, just like that, you filed the writ petition without proper pleadings. Court has to look here and there to dictate the order.
No, my lord. I'm sorry for that, my lord, because it was disconnected.
No, don't say that principles of natural justice. It is submitted that as a petitioner is entitled for the benefit under the notification issued by the government, it is submitted that there may be a direction to the respondents to forthwith restore the power supply, and the petitioner will make necessary application before the authorities considering the submission on behalf of the petitioner and also submission of the land council respondent. This court is passing the following order. The writ petition is disposed of, directing the respondents to forthwith restore the power supply. Number 2, the petitioner shall make an application as per the fresh application as per the notification dated 22/6/2026 within a period of 1 month from today, accordingly disposed of.
Number 9.
Yes, 9.
My lord, in this
What
power
about
is
this?
not disconnected, my lord. It was
What
only a
about
threat
this?
of My lord, this is
What
less
is
than
the extent?
2,400, less than 2,400, my lord.
Land counsel for the petitioner submits that. I'll keep this writ petition pending.
Yes,
Land
my lord.
counsel for the petitioner submits that the property of the petitioner is less than 2,400, and in the light of the circular dated same in the earlier circular, in the light of the notification issued by the government dated so and so, they're exempted from furnishing the occupancy certificate. Despite of the same, the BBMP has they have disconnected the power supply.
No, they are not
It is
disconnected, my lord. They have given
They
notice only.
have issued the notice. It is submitted that as per the same, within 15 days from the date of order, they can make the fresh application. In that view of the matter, this court is passing the following order. I'll keep it pending. Land counsel for the respondent so and so submits that he'll file his objections. Number 2, the respondent shall not take any coercive steps. Number 2, the petitioner shall make an application within 15 days from today. And on that, the respondent shall consider the same as per the notification dated so and so. Yes,
Much obliged.
all the matters AGR. Yes.
Much obliged.
Caller.
Urgency mentioned matter in list number 2, serial number 26. List 2, serial number 26. Yes.
Here for the
Varalakshmi P. Yes, Jeevan Kumar.
Lordship. We have filed this petition. We are the absolute owners of the scheduled properties.
What is the order of the trial court?
Trial court has ordered that first initially injunction order was granted, my lordship, on the application 1 and 2, my lordship. One application for injunction and the second application for the police protection, directing the DCP and the police to protect us, my lordship. But later on, when the respondents, sorry, my lordship.
What has happened here is, there is a status quo order granted by the trial court. This was in 2024. And after the status quo is granted, they have not started vacating of the status quo. It has continued as such. Now, my lord, in the meantime, we asked the trial court to direct the police to give protection. Because the reason was that they were getting very aggressive in trying to take possession from us. The IA, my lord, if your lordship were to see, the IA is at page
185.
185. This IA was filed before the court. The order sheet is at page 126.
Yes.
126 is the order sheet. This was numbered as IA 1 of 25. At page 125, counsel for plaintiff filed. Yes. 126, blood. 126, sorry. Order sheet dated 28/10/25. Case advance, counsel for plaintiff filed IA 1 of 25 and 151 of CPC seeking direction to concerned police to implement order dated 12/1/24, which was the status quo order. Copy of the application served on counsel for defendant. Then for objection 4/11/25 or objection on IA 1 of 25. Then for 14/11/25 heard the counsel for plaintiff on IA 1 of 25. Counsel for defendant present and praise time for time granted to hear on behalf of IA defendant on IA 1 of 25. Then Lord defendant.
So this is all pending from that time.
It is pending from that time. Now Lord, what is?
Well, I'll direct the court to
No,
discuss.
just within a week's time.
Just one.
Because what my submission is, within a week's time. Because then he said that we have not sought for challenging that, my lord, it's an order of status quo. We are running institutions there.
No.
So, my lord, within a week's time, your lordship may ask us to appear on a particular day. And that day we will conclude the argument and let the trial court pass orders on that IA within 3 days or 4 days.
No, Lord. I'll just one.
What they're seeking for prayer, he is the same prayer sought there in the trial court. That status quo, my lord, they're seeking for police protection, my lord.
No, Lord. Kindly see this, Lord. Ladies are inside the property. And when ladies are there, hundreds of people have come and they have tried to throw out these ladies. Ladies and others who are there inside the property.
What is the suit schedule property?
Suit schedule property, my lord, is
Before it was closed, it is closed.
it is we are inside the school. It's a school premises partially.
Done by the trust.
No, school
that
premises
they're not
partially.
disputing. We are running the institution.
School premises partially and partially properties which are other than the school premises. And I am there in possession. All that I am asking the police is to implement the status quo. Whatever is the thing. They did not challenge the status quo.
Police implement status quo order.
Status quo says
Just
whoever is in
give
possession
protection.
remains in possession.
Give protection.
No, let us see the status quo order. What did the
Yes,
court
but that
say?
is pursuant to the High Court order.
Let's see that order.
Yes, that is at page 178. 170. No, the present status quo that is there, Lord, is at page, is impugned, is
20.
annexure A, page 20, page
24.
16.
page 16, 19,
Page?
19. Orders on IA 1 of 2023 and IA 2 of 2023, 5 of 22 under 39 rule 18.
Hmm.
Now, Lord, in this, kindly see the court answers at the point number, page 21, point 1 to 4, para 4, whether the plaintiff has made out a prima facie case for grant of temporary injunction. I am the plaintiff. Then
No, what
plaintiff
is
has
the
filed.
finding of the court?
Yes, the finding of the court is at para 12, para 12,
Para?
para 11.
Hmm.
Then it counsels made,
Hmm.
then counsels made reciprocal allegations against each other. The documents of their counterpart are fabricated, cooked up, concocted. Both parties have voluminous documents. The defendant filed tons of documents which runs more than 800 pages. The plaintiff also, spot behind, he has also filed voluminous documents. Apart from that, this is not the first round of litigation. Rather, the subject matter of this suit has been seen the floor of the court in several formats. And also there is an order by the Honorable High Court in WP 17443 of 22, wherein the Honorable High Court has granted an order of status quo. Apart from that, the suit in was so and so, so and so.
High Court has granted status quo in a writ petition.
In a writ petition.
That was followed by this court.
That writ petition, yes. That writ petition arose out of a miscellaneous. They challenged an order, intra-family, we had made a compromise. They challenged that in a miscellaneous. That miscellaneous, they could not secure an interim order. They came before this Honorable Court. This Honorable Court said, no, all of you maintain status quo because.
Even that order also is not made on the merits.
That also is not made subject matter of appeal.
No, it is not. It is not made on the merits of the matter.
No, it was made on the merits.
No, the court has simply said, no, let's go to.
That order.
That order, where is that?
Kindly see para 12, Lord. Para 12.
The order of status quo is very dangerous.
Yes. Kindly see
Number?
para.
My lord, there if your lordship turns to page 9, that is the order of the High Court has been extracted.
The whole order.
Page 9, page 24.
They extract the entire order at page 25, Lord. Below para 12. There they say, after obtaining a compromise decree, this is at internal page 8. Learned counsel for the petitioner, that paramount, has today filed an affidavit stating the response have filed PCR and therefore in a disparate attempt, the petitioner in OS so and so to was protect advised the school to file children teaching and not teaching. He has undertaken that he would not press the application for interim injunction and so and so. Petitioner who claims right, title and interest in the properties that were subject matter of so and so and who is aggrieved by the compromise petition therein had filed miscellaneous petition to set aside the compromise petition. Trial court must have considered the seriousness of the situation inasmuch as the petitioner claimed that a school was being run by it in the building constructed over a portion of it. The trial court must have therefore directed the maintenance of status quo property until consideration of the application. Not doing so has only resulted in the petitioner and the respondents approaching the jurisdictional police seeking intervention. In the fitness of this court considers it appropriate to direct trial court to consider and dispose of the application for stay filed in miscellaneous petition 979 of 22 as expeditiously as possible, having regard to the peculiar facts and circumstances of the case. At the same time, the court cannot ignore the conduct of the petitioner who, having failed in his attempt to secure an ex parte order of ad interim injunction in OS 26322 of 22, has swiftly moved this court on the very same day without disclosing the filing of OS 26322 of 22 and has obtained an order of stay. Thus, what the petitioner could not achieve through the process in OS 26322 of 22, it managed to accomplish it by filing the present writ petition. This is nothing short of forum shopping, and courts have persistently held that such practice should be discouraged, lest the stream of justice would be polluted. Petitioner claims to be running an education institution, thus it would be presumed that it is managed by some individuals. This court has seen a surge in such mischievous litigation, and in all such cases, the persons litigating would be either affluent or powerful, who use the process of court to gain one-upmanship over the contesting party. It is this attitude that needs to be covered by the imposing. Yes.
For the first time, this is a suit is of which year?
Suit is of the year 23, where I sought.
Sort of which order?
What happened, Lord, was they have fabricated 2 hibas of my father and they tried to gain possession. At that point of time, they filed a suit for a declaration saying that the hibas give them title, oral hibas, unregistered hibas of the year 1999, which are all concocted, do not contain my father's signature. In the meantime, what happened, since I was in possession of this property, what they did, they instituted the suit, tried to get an ex parte order. They could not get an ex parte order. In between what had happened, we had arrived at a compromise between brothers and sisters. The compromise schedules are set out in the suit. In pursuance of the compromise, the same said compromise was registered before the court, before the sub-registrar. In the meantime, what they did, they challenged the compromise in a miscellaneous petition, saying that they have an interest in the property.
Who, the plaintiff in the suit.
The
educational
respondent,
Who does
defendants
file
in
the
this,
miscellaneous?
defendants in this suit. That miscellaneous, they tried to obtain a stay, could not grant stay. Then they came here challenging the same in WP. In WP, they said that kindly grant us injunction because the suit where they sought declaration of IBA and their title, they could not get injunction there. So they came here in WPCPC arising out of the miscellaneous. Here, this honorable court said, considering overall circumstances, that let there be status quo with respect to
Status quo has been ordered by the High Court.
suit schedule
In that
property.
matter.
They were the petitioners before this.
They were the petitioners. Then
Status quo is granted in their favor.
Yes.
inures to both benefits because the reason is,
It's a whole difficulty. That is what I'm trying to understand.
yes, the reason is after I got status quo in 24 in this suit, which I now, where the judge says 800.
Respect of the very same property.
Yes.
He has a status quo in miscellaneous, she has a status quo
In the suit, in the suit.
Yeah,
In- and
my lord,
ours
now in the
is-
present suit, this, my lord, this is the order by the trial court, which, my lord, now they're seeking to implement. Here,
They
if
have-
your lordship
my lord,
sees
this
subsequently
property
that
is about,
order has
let me
been
just
passed,
clarify.
the High Court,
This
my lord,
property
said
is about
status quo.
5.
So the trial court says since the High
This
Court has
property is
granted
about
an
5
interim order-
acres. This property is about 5 acres. So 5 acres, 18 guntas of the total extent. This honorable court said that status quo is granted over the entire scheduled property in my suit, insofar as my suit is concerned. And
What I'm saying, what is the
insofar as,
finding of the
insofar
court?
as their suit is
It is
concerned.
like this, unless and until the court gives a finding and say that as for the evidence on record, so-and-so is in possession of the property, let there be a status quo is one aspect. Without saying anything, if the court says status quo, then how that order can be implemented?
But what
In
has
fact,
happened in the
trial court
meantime?
only on the basis of the High
Not-
Court
not
order. Your
their
lordship may
order.
just come down a little, my lord, on the same page.
No.
Your lordship may kindly see the page
What the
next.
trial court did, my lord, was, since High Court had granted status quo with respect to the school portion only, High Court had granted status quo in their favor. The High Court said, the trial court,
Suit is only pertaining to school.
the pertaining to school.
No, the entire,
That is all.
my lord, we are running the entire school, mother, everything is being run there. In fact, my lord,
What is the subject, suit scheduled property in your suit?
my lord, 5 acres of land.
But court said status quo is confined to the school
Where
portion.
do you get that?
That, not
From
page
that order.
129,
One?
29.
No, his order is at
Ah.
27.
No, that is my suit order, my lord, 27.
No. It is the extraction of the High Court.
Yes.
But
that order,
subsequently, the trial court, basing
No,
on the
page-
order of the High Court, my lord, your lordship may just turn
178.
to
No, I'll come to that.
178,
Page
178, 178. The WP 1744.
170?
Ah,
8.
Yes, 178. Writ petition is disposed of, para 9, Lord, with the trial court to dispose of IA number 1 filed in miscellaneous number 979 of 22 within a period of 2 months from the date of receipt of certified copy of this order until disposal of IA number 1 in miscellaneous petition 979 of 22. The parties are directed to maintain status quo in respect of school, which is established on a portion of the properties which are subject to matter of OS 4910 of 21. Then this is our subject to payment of 5 lakh costs. So to so and so, it is made clear, if cost is not paid, petitioner shall not be entitled to benefit of the order. This shall however not be construed as affecting the right of the respondents in respect of other portions of the properties.
Both the parties are directed not to approach the police regarding
Any issue concerning.
That's
Now,
a
my lord,
subject matter of the
this
proceeding.
miscellaneous was dismissed. This miscellaneous ultimately, which was this order which was kept pending till the miscellaneous, now it does not survive because miscellaneous was dismissed against them. They were the miscellaneous petitioners, so it got dismissed. So they did not file any appeal also as against that. Now, Lord, what we are concerned about is the contumacious attempt by them to steal possession at this stage, where when I have a status quo in my favor, which they have not challenged, but they accepted in 24 when I got January 24.
Right from Jan till 2026, it is continuing.
It is continuing in my favor.
No police protection is granted. So that is why the trial court will be in a better position to understand.
Actually, my lord, police protection was granted. Police protection was granted in 24. Kindly see that order, my lord.
Where is that?
IA number 1 and
Page number?
page 19.
19.
19, 19. We are changing. Page 16, sorry. Order on IA 1 and 2, my lord. In that, plaintiff has filed 2 IAs. 39 under order 39 1 and 2 and 151 and sought for a temporary injunction. Sorry, page 16 annexure. Plaintiff has filed 2 IAs. Order 39 1 and 2 and section 151 CPC and sought for an order of injunction restraining defendants or any other person from interfering with the plaintiff's peaceful possession and enjoyment until disposal of suit in the interest of justice. Plaintiff also filed, next page, under section application under section 151 to direct the DC of Deputy Commissioner of Police and Station House Office to give protection.
Ultimately, this order is status quo.
This order, no. Both IAs are allowed.
No, look at it. At
Yes,
page
yes.
29 is the operative portion of the order.
IA 1 and 2 of 23 filed by the plaintiff under 39 1 and 2 read with 151 application filed under 151 are allowed in part.
In part.
Why allowed in part, Lord, was because perhaps court did not grant injunction. It granted status quo, but it allowed both IAs. So the Deputy Commissioner was directed to give protection.
No.
That order is in subsistence.
At least in the discussion part, we should see that how it is, forget about the operative portion. Where is the discussion that
But
it has
court allowed
granted?
both the IAs, Lord.
Look, police protection has not been given.
That is what, we have to at least
Learned senior
understand.
is saying police
One
protection.
minute.
Yes.
From the order, please refer to the order at a discussion. Where did the court at least refer to the police protection?
151 CPC.
And their case before the lordship is that IA is not being considered by the trial court. That's why they come up here. So their prayer
Lord,
is
in any
direct
case.
the trial court to dispose of those IAs. That is their prayer in
Lord,
this case.
Lord, my difficulty is this. Today, they are coming forcefully with huge number of men and material to come and dispossess me. Now,
So even for the trial court also to grant
Yes.
police protection. Now, the court has to conduct a mini trial for this. Who is in possession of the property, who is interfering? Because this order of status quo is granted without a finding.
yes, Lord, normally what the courts would
No,
do
no,
here,
until pending
what the
disposal
courts would do here, Lord, is direct the police that whoever is in possession to be protected. That is what the courts would do here.
No.
And also say that nobody should be dispossessed. For giving protection to possession does not mean putting another person into possession. This qualified order the court could make.
My lord, the police
So
will
that
go
to
there and my lord, will they put them in possession or take me out of possession? My lord, how will the police decide?
No, it
Which
will
the
only
court
protect the
itself did
person
not.
in
My lord,
possession.
The court said allowed in part, did not grant an injunction in their favor. If an injunction was granted in their favor, I can understand. My lord, their prayer, your lordship can see the prayer in the writ petition also. My lord. All that, as your lordship in the initial stage said, my lord, we have to also file our objection. My lord, if now it is
No,
they are
they have
saying
completed
police
their
protection.
arguments.
Their IAs are pending before the trial court, the very same IA. Lord, that matter, like on 25th, 26th, 27th, any date it may be listed. We will argue the matter. Your lordship may direct the trial court within 4 days to dispose of that IA itself. That itself can be done.
Lord, what would
So
happen
how
is
will
this?
the
What would
police
happen
will
is
not now
this?
maintain,
Lord,
let
him
implement
undertake.
status quo order, my lord, they will do whatever they want.
Lord, if such is the case, my lord, let us, both of us undertake that we will not do anything to change the possession there. That is all that I am saying. Because let it come with a qualified undertaking by both of us.
That is what is
Fairly,
ordered.
will remain in
Fairly.
possession of, that's all it's the thing.
Yes.
Those who are in fact, my lord, they went to seek for.
No, there must be CCTV cameras to the school and all.
Yes. That
Yes,
can be.
Mr. Subbareddy.
Yeah, please, no?
The
Cameras
school,
are there.
school and all, they must be having cameras.
Yes.
The court will look into that.
Yes,
yes.
While considering the
Yes, ma'am.
application.
Yes.
I'll direct the court to look at it. So
Yes,
that,
No, Lord, only thing I am asking is, in the interim, 4 to 5 days, because we are seeing
That's what I'm
they are
saying,
coming
that-
and
that-
resorting
That
to.
will create
No,
even more
let me
things
just
in the next
complete.
4-5 days.
Lord, in the
Because
meantime,
police will come
no,
and
no.
try to give them possession for which they are not
They are
authorized to do.
resorting to brutal violence in the meantime. And the police are just looking at it as mute spectators, saying that until the court says something. This is volume. Can you see, Lord, they are bringing huge number of men and people. They should not
How the
use this.
schools, my lord, are running.
They should
My lord,
not
the
use, they
institution,
should,
Lord, is a trust. My lord,
they should
get a
not use
compromise
this,
degree amongst
they should
themselves.
not use this as an attempt to, in 4 days, to take possession from me. That
No,
is all that I am
where will
fairly
you take,
asking.
my lord?
This
Status quo is there.
is the, what I
How
am
will
fairly
we take,
asking.
my lord?
no,
We will not-
I'll record his submission that they are maintaining status quo as per the order of the
Yes,
court.
that's all. Both
And
of
any
us-
untoward, that's what, any untoward incident, what is happening, you please bring it, I'll say, while considering the application for police protection, the court should consider the CCTV footage and all.
Yes.
You can
And,
place before.
and the camera, the video
Everything,
recording.
whatever evidence that is placed, the court, let the court
Look
look
into
at
it.
it, whether there was any violation of the status quo
Yes,
order
and
and all.
either parties must refrain from changing the status quo. That's all, Lord, that I'm asking.
It is like, I'm again
Reiterating the status
reiterating the
quo.
order what is already granted.
Again, my lord,
Reiterating the
qualifying it,
status
again
quo.
requalifying it.
So that,
4-5
Lord,
days, my lord, we
Lord,
are ready,
so that,
23rd, 24th,
Lord,
itself, let them
they are coming
finish
with
it
huge
off.
number of marine material. I don't have such amount of marine
That
material.
allegations are by us,
And
my lord.
it
I
is
didn't
there,
want to say that.
it is there.
How they are doing it,
I'm
what
showing
is
it through the
education?
videos.
Get all the evidence that will be viewed by the court very seriously.
Yes.
I'll ask the court to look
In
into all
4
that.
days, Lord.
So,
4 days.
yes.
4 days.
4 days.
So, the suit is for,
Suit is for injunction.
Injunction.
please come. The petition is before this court. Agreed with the order of the court, agreed by the continuous adjournments granted by the court without considering IA number. What is the IA number? Police protection?
IA 1 of 25.
IA 1 of?
25. 2000.
IA 1 of 2025. It is submitted that this application came to be filed on
28/10/25.
28/10.
2025.
28/10/2025, and from there on, it underwent several adjournments. It is submitted several adjournments. It is a contention of the senior counsel, representing the counsel for the petitioner, that the respondents are contrary to the order of status quo, or interfering with the petitioner's peaceful possession and enjoyment of the property, and they are high-handedly trying to dispossess the petitioner. In that regard, when they gave a private police complaint as the matter is sub judice, they are not taking any action. In those circumstances, they have come before this court. And also along in this, they have filed an IA. What is that IA? For injunction.
Yes.
What is the injunction?
Police.
Not to interfere and directing the police to protect us.
They have filed an IA here, seeking a direction to the respondents not to interfere, and also a direction to the police to provide the police protection.
Yes.
Next paragraph. It is in the same paragraph. It is submitted with the senior counsel that in the earlier miscellaneous filed by the respondent herein, the High Court has granted against an order passed in miscellaneous where a writ petition is filed. This court has granted status quo as far as the school premises is concerned, whereas in the suit, in the present suit, in the IA that is filed by the plaintiff seeking injunction, the court has granted status quo in respect of the entire 5 acres.
5 acres, 19 guntas.
5 acres, 19 guntas. It is submitted that unless and until the police protection is granted, it would be difficult for the plaintiff to, it is very difficult for the plaintiff to retain the possession. Next,
But in
senior
the
counsel.
earlier proceeding, only the school portion status quo.
School, that's what I said. School portion, now it is,
Here, that's it.
I said school portion. Then the senior counsel representing the counsel for the respondent submits that. In fact, in the entire 5 acres of land, they are in possession of the property, and they are running a school, and they have not violated the.
The lordships are noting my contentions. She's thinking a lot.
That's what I'm saying.
That's what I'm telling them. It's contentions. Keep quiet.
The senior counsel submits that they're in possession, they're in occupation of the entire 5 acres of land. And they have never violated the order of status quo. It is submitted that if it is a grievance of the petitioner that the IA is not disposed of, this court may direct the trial court to dispose of the IA. They will also file their objections, and at an earliest point of time, the court may be directed to dispose of the same within a period of 1 week, and they have no objection for the same. Next part. Having heard the senior counsels on either side, produce the material on record. This court has perused the order passed in miscellaneous, arising out of a writ petition from the miscellaneous, and also the order passed by the court in the present suit granting status quo. In both the matter, in both the cases, there is no finding about who is in occupation of the property and what exactly is the status quo that is granted. In those circumstances, this court, while exercising the jurisdiction 227, cannot go into all these facts and consider the IA that is filed by the petitioner. Then coming to the application that is filed, considering the kind of dispute between the parties, when an IA is filed seeking police protection in the year 2025, the court ought to have dealt with the same at the earliest so that further litigations could have been avoided. In those circumstances, this court is of the view that directing the trial court to dispose of the pending IA seeking police protection would be appropriate and in the interest of both the parties. In that view of the matter, this court is passing the following order. The writ petition is disposed of, directing the trial court to dispose of IA number 1 of 26 within a period of 25, within a period of within 1 week from the date of receipt of the copy of the order. The respondent shall file their objections immediately. And number 2, both the parties, in the light of the submissions made, that very aggressively the respondents are interfering, the petitioner is at liberty. Petitioner and the respondents both are at liberty to file to place before the court the evidence in that regard, and the court shall consider the same in accordance with law.
CCTV evidence and videos, and videos, that word.
Videos, both the parties are at liberty to place the videos pertaining to any interference as submitted before this court.
Obliged.
AGA accept notice for 2 and 3.
Within 1 week.
1 week.
But one,
This,
but
1 week
none
I
of,
said.
yes, none of
Huh?
us will, in the meantime, none of us will
Both
interfere.
the council submits that they will strictly maintain, the parties will maintain.
Please.
Senior counsels on instruction submits that. Both the parties will strictly maintain status quo.
Please, oblige.
Like validating the.
Reiterating. Please, oblige.
Call that.
230 mood matter, Vandana appeal for petitioner. 230 mood matter.
Yes, let it be there in the list.
Continuation of the list, serial number 37. List number 1, serial number 37.
Yes.
Vinita PC for petitioner, 37.
No representation in the month of September. Yes, 38.
17, yeah, 38, serial number 38. Yeah, Madhusudan Rao.
Yes.
Written petition is by defendant number 4, challenging the order passed by the court below, dismissing the application for rejection of claim. Dismissing the application for rejection of claim.
What is the suit for?
Suit is for partition, filed by respondent number 1, who is a minor daughter of defendant number 1, and defendant number 1 is the son of defendant number 2. So both defendant number 1 and defendant number 2, father and grandfather, are still alive. And at the time when both of them are alive, this minor daughter, through her mother, who is a divorced wife of defendant number 1,
Come to the
this
order.
suit is filed.
Come to the order. Where is the order?
Kindly, your lordship may kindly go to ink page 60 minutes, 60, relevant portion. Lordship gets it.
60.
Para 29 minutes. I would like
Para
to read
29.
29. Here, the main ground on which the defendants are praying for rejection of the plaintiff is that the suit is filed on behalf of the plaintiff number 1, who is a minor daughter of defendant number 1. And the contention is that during the lifetime of defendant number 1 and defendant number 2, plaintiff cannot claim any share in the suit scheduled property, as defendant number 2 has acquired said property by virtue of section 8 of the Hindu Succession Act. And during his lifetime, plaintiff, being the granddaughter, cannot claim any share, and that the suit is premature and not maintainable at this stage. This is the contention that was taken. This was only considered by the court in page 30, para 30, saying that it's well settled principles of law that at the time of the considering the application of order 711, CPC only the plain governments and
No,
documents.
is it not the very same contention by the plaintiff also?
Yes, madam.
Or whatever the fact that you are stating.
Yes, madam. What the plaintiff says is, Your Lordship may kindly see the relevant portion of the manner in which the plaintiff claims title. Kindly go to the plaint itself. Internal page, ink page 28, internal page 12 of the plaint.
Running page?
Running page 28, 28, para 17. The plaintiff submits that as per the amended section of Section 6 of Hindu Succession Act 2005, as soon as the grandfather P.R. Ravindranath died, a notional partition is envisaged. Accordingly, Ravindranath Gupta would be entitled to.
So now it is your case that as per Section 8 of the Hindu Succession.
And one more thing is, I am relying upon the judgment in Uttam's case of the Honorable Supreme Court. Here is a case where what the Honorable Supreme Court has dealt with is, if a succession, yes,
in the teeth of this para 17,
yes,
the suit is maintainable or not?
According to me, it is not, because by
No, in the same as per para 17.
as per para 6 only.
17
only, because they are also claiming under a notional partition. That is why I am trying to rely upon this paragraph. There, the plaintiff also is claiming on the basis of a notional partition. Admittedly, what has happened is, Ravindranath may pass on the genealogical tree for a moment.
Take that.
Kindly see the genealogical tree.
Yes.
Obbatti Ramachandraya Shetty is the propositus, of course. He had about 5 sons and 6 sons were there. And we are not concerned with other sons. Only Venkatratnam is this person, under whom the entire succession starts. Venkatratnam dies in 2005, on 3/2/2005, great this month. And that is prior to the commencement of the Hindu Succession Amendment Act 2005. Then subsequently, Ravindranath Gupta, he dies in 1994. That is prior to his father. Unfortunately, what has happened in the plaint as well as in the genealogical tree, respondent number 1 has given the date as 22/11/2014, which is found to be fault with, which can be easily found to be an erroneous statement by virtue of the documents filed by the plaintiff itself along with the plaint, wherein in an earlier suit filed by the sister of Ravindranath Gupta, it was specifically referred that this person died earlier in 1994.
Correct. But
What I am submitting is,
that is what the plaintiff said.
Plaintiff, what I am submitting is,
No.
if the plaintiff,
According to you, somebody died in 94. According to them, that person died in 20.
No, what I am saying is, if I can demonstrate before your lordship that the statement made in the plaint is contrary to the documents produced by the plaintiff herself along with the plaint.
Where did she produced a document to show the when the person died?
Yes. There is that's what I am submitting, documents. But your lordship may kindly see these documents.
Take that.
3 of the documents I am filing, which were filed along with the plaint. The first one is the suit in OS number 2954 of 2010. Of course, it was subsequently renumbered. It was a renumbered number.
From where you will get this?
Yes, Miller. In this, Miller, kindly go to the 3rd page of the plaint. This page number 38. Para 7. Last line. The said Ravindranath Gupta has died on 22/11/1994. This is one document.
Yes,
in addition to
that is sufficient. Yes, next.
Now, in this background, my submission is, if Ravindranath Gupta, who is the father of defendant number 2, and kindly see genealogical tree, Ravindranath Gupta had a wife by name Nagamani. She is defendant number 5 before the trial court. He has 3 sons, defendant number 2 Prashant, defendant number 3 Anand, and Chandan, defendant number 4. And this Prashant's son is Sucharit. Prashant's son is Sucharit, down below, defendant number 1. His wife is Ratana, who is a divorced wife. And their daughter is Chanavi Shetty, who is the plaintiff. So, as on the date of filing of this suit, if the property has gone by succession, this girl cannot be said to be a heir, because only a daughter or a granddaughter of a predeceased son or a predeceased son can be a heir under Section 8, read with Schedule 1 to the Hindu Succession. So in this particular situation, my lord, was considered by the Supreme Court in Uttam's case.
Please come. Then counsel for the petitioner submits that. The then the respondent herein has filed a suit for partition who is a minor during the lifetime of the grandfather and great grandfather.
Father and grandfather.
Huh?
Father and grandfather.
Father and the grandfather, they have taken a specific plea stating that is contrary to the law laid down by the apex court, and the suit for partition is not maintainable. The same was not considered by the court, and the court it is submitted that basing on the plain governments itself, they are demonstrating that the suit is not maintainable, but the same was not appreciated by the court. Considering the same, they shall be stay of all further proceedings. Notice, hand summons, memo shall be filed by 29th of July, or else the stay granted by this court stands vacated. Yes.
Your status stay order.
Stay.
So far as respondents 2 to 9 are concerned, your lordship may dispense with notice.
Memo is filed, second dispensation of notice to 2 to 9, dispense with only this, the hand summons only to 1.
Yes, please. Much.
Yes. Next.
Number 39. Mohana Chandra, Chief Petitioner.
Yes.
While a suit is one for partition separate position, I have filed the application under Order 7 Rule 11A of CPC for rejection of plaint, depend number 3. The trial court will dismiss my IA. The fact of the case of plaintiff is that.
What is the ground?
Ground, there is no cause of action. Contents of plaintiff is that the father of plaintiff sold the ancestral property on 18 to 2006. Out of the proceeds of the ancestral property, the depend number 2 purchased the same on 4 to 2006. So therefore it is a joint family property, contents of the plaintiff. So there is,
you are saying that sale is on 18 to 2006.
Yes.
Then the next date you are giving is 4 to 2006.
Yes, prior to the selling of the ancestral property, depend number 2 has purchased the property. Your lordship kindly see the reason assigned by the trial court. Total page number 16, para 16.
Page number
16, internal. As per the depend number 3, he has purchased the suit schedule property under registered sale deed from depend number 2 for valuable consideration. Suit schedule property was purchased by depend number under registered sale deed dated 4 to 2006 from Srimati N.S. Pankaja. Suit schedule property was the exclusive property depend number 2, who sold the same in favor of depend number 3 for valuable consideration. It is not in dispute that plaintiff and dependent who are children of depend number 1. As per the case of plaintiff, his father Lakshman Reddy sold his ancestral property and he invested said amount in purchase suit schedule property in the name of depend number 2. Copy of sale deed dated 18 to 2006 is produced before the court, wherein Lakshman Reddy sold his property in favor of H. Senior for consideration for rupees so. As per plaintiff and dependent 1 and 2, suit schedule property is purchased in the name of dependent 2 on 4 to 2006 for consideration rupees 6 lakh. Suit schedule property is purchased much prior to the sale of ancestral property by Lakshman Reddy. Hence, it cannot be believed that out of sale process, sale of ancestral property, suit schedule property is purchased in the name of dependent number 2. Para 17, as per depend number 1, rupees 4 lakh was obtained from the purchase of ancestral property as advance. But on perusal of sale deed dated 18 to 2006, it is stated that on the date of execution sale deed itself considered has been paid. Hence, the contents of depend number 1 is unbelievable. Depend on further content that is he paid rupees 2 lakh by selling her gold ornaments, but no documents are produced before the court to that effect. Thus, on perusal of pleadings of plaintiff and defendant number 1 and 2, document produced before court, they do not.
Where is the consideration of Order 7 Rule 11?
Because there is no, it is my self-accord property.
I'm saying where is the consideration by the court?
Court
has considered something else,
yes,
as if like it is a injunction suit, injunction IA. Please come. The petitioner has filed an IA under Order 7 Rule A to seek rejection of the plaint. It is the case with the petitioner defendant that there is no cause of action, and counsel for the petitioner submits that when an application is filed by the petitioner under Order 7, Rule 11, the court has to consider the same on the merits of it and pass a reasoned order. He has drawn the attention of the court to the order impugned and submits that no reasons are forthcoming. In that view of the matter, there shall be stay of considering the submission of the learned counsel. There shall be stay of all further proceedings pursuant to so and so, so and so. Same hand summons, notice hand summons by 29th or else the stay granted by this court.
So number 40, Chandrahasa G for petitioner.
Yes.
Present the petition of please, Your Honor. The application filed by me before the trial court came to be rejected, Your Honor. The application was for seeking rejection of plaint, please, Your Honor.
What is the suit for?
Suit for partition, please, Your Honor.
On what ground you have filed this?
The application came to be rejected by the trial court on the ground that the section 6 of Hindu Section Act is not applicable to the facts of this case. The court has not looked into the para 18 of the plaint, please, Your Honor. I would like to.
What is your case?
Please, Your Honor.
What is your case?
The suit is not beatable because of the.
Because of section 6 of the.
6 of the Akidasumi. That was the application. The court had to have looked into the entire pleadings. Not only the court cannot confine only to the affidavit filed by the defendant. The para 18.
Court will look at the affidavit because that is the basis for which you have filed the application.
Apart from the affidavit, court has to look into the entire pleading itself. That is not done by the court.
Court will look at the plaint, but the court has to look at what is your case from your affidavit.
Of course, I have not taken this contention.
Without taking a contention, how do you expect the court to decide it?
It is duty of the court, trial court, to examine the entire contents of the plaintiff itself. Only when the application is made by the party.
Order 7, Rule 11, you have filed.
That is what I would.
When you file the app. When you take certain grounds, the court will look at the pleadings.
I have mentioned
and will decide.
I will mention the provision section 11A and B, D and A. Both
Let us see your affidavit. What did you say?
Come
to the affidavit.
Of course, I did only section 6 of the Antana.
When you have not said, the court will not. That is not the duty of the court.
That is why I am come before the court. Section trial court has not taken into consideration the averment.
Please come to the. Forget about the averment. What is your case? On what basis you have filed Order 7, Rule 11?
I made an application stating that the sentence was.
Let's see. Let us see the. Let us see your affidavit. Please come to page 40.
Of course, I do admit that I have made an application stating
Then
that.
please admit it and I'll discuss it.
I submit that as per the plaint averments at para 9 and 9 of the plaint, item of 1 of 2 properties are sold on 18/10/2004 in favor of defendant of 15. Similarly, some of the properties are sold by the defendant on 9/11/2004. That is my contention, Your Honor. And also, I have taken that the amended in this section act is not applicable to the facts of this case.
Yes.
I would like to draw your attention that I would like to make a with your permission.
When you're filing an application on Order 7.
Of course, I am not denying it, Your Honor. Of course, I am not denying it. Court, it is the duty of the trial court to consider the para 8 of the plaintiff, which is admission made by the plaintiff, telling that there was a decree in OS number 244 of 99. And that decree remained unchallenged.
Able to understand what is your submission. You have raised certain grounds. That grounds will be considered by the court.
No.
You say without me raising any grounds.
No, apart from that, it was not the duty of the court to look into the entire pleading of the plaintiff. There is an admission made by the plaintiff itself stating that there was a decree in OS number 244 of 99. That decree remained unchallenged. Section 31.
First of all, I am not convinced with this submission. You say you filed an IA seeking rejection 1, 2, 3. Basing on this 1, 2, 3 grounds, the court will look at the pleadings whether it's a case for rejection or not. Now your submission is I have not taken any ground, but the court should look at the pleadings and do something. Why the court should do? What is the purpose in that case? No application under Order 7, Rule 11 is required. Court, whatever the court feels, court will read and pass an order.
Of course, regarding maintenance of the suit, it was the duty of the court to look into the plate.
That I am not accepting. That I am not accepting. That contention is not acceptable. Come to the order. What did the court do?
The court has held that the section 6 of the Hindu Section Act is not applicable to the facts of this case, Your Honor.
Let's read it.
Para 7 of the internal running page 15, please, Your Honor. In the middle of the para 7, the plaintiff has nowhere stated that the suit properties are the ancestral property which has flown from the 4th generation. Section 6 of the Hindu Section Act has no application to the case on hand. This is the observation made by the trial judge. Whereas in the same impugned order at para 3, at internal page 13. Therefore, the plaintiff is not a party to the alleged transaction pertaining to the suit property. Therefore, as per the Hindu Section Act 1856 and Amendment Act 2005, the plaintiff is a co-person and rightly entitled to share in the scheduled property. And therefore, the plaintiff has sought for necessary relief. This was the observation made by the trial court. Section 31 of the Specific Relief Act bars this suit, Your Honor.
Notice is the respondent.
Then number 41. Patil Dayanand Subraya Gaud, petitioner.
For the petitioner, my lords. Pray for a week's time, my lords.
This is the month of September.
Seeking permission to make defendant number 5 to 15 as parties to, seeking permission to make defendant number 5 to 15.
Whatever you want to do list in the month of September. Yes,
Then number
42.
42. Ramesh B. Bhatt for petitioner. Suresh S. for the creditor.
Appearing for petitioner.
Yes.
Kindly pass over the matter, my lord. Kindly pass over the matter, my lord.
No
Senior-
passport.
No, Lord. The Lord, miscellaneous petition, Lord, suit for declaration and injunction is decreed in favor of the respondent. Lord. Against that, my lord, the defendant herein filed miscellaneous petition under Order 9 Rule 13 on the ground that notice is not served on them. The only document that is produced before the court is that, my lord, the postal acknowledgement which was produced before the court that has the endorsement saying the refuse. Against which, my lord, no evidence is led, only on statement of oath, my lord, the miscellaneous petitioner, my lord, says before the court, stating that, my lord, that she has not received the notice. But in cross-examination, we...
What is IA?
But
What is impugned order?
impugned order is that miscellaneous petition is allowed.
Go to the miscellaneous petition, please.
My lord, miscellaneous petition, my lord, the relevant portion of the
Come to the
order, page number 25.
Yes.
Para number 23.
23.
Please, my lord.
23
In
that-
25 and 26 is the reasoning portion.
Hmm.
It is pertinent to note. If I may, Lord.
Pertinent to notice para
Please,
25.
note. Para number 25, page number 25. It is pertinent to note that during the cross-examination of PW1, she has categorically admitted that the address mentioned in Exhibit P7 is a proper address of the petitioner, and in the normal courts, notice sent to the said address reaches to the petitioner. The documentary evidence, though, indicate that the suit summons issued to the petitioner respondent in OS number 1595 of 2017 has been returned as refused by the addressee. However, it is well settled principle of law that the presumption of service of notice refused endorsement is a rebuttable presumption of fact, not a conclusive proof of law. The petitioner has entered the witness box as PW1 and stated under oath she has never had knowledge of the suit, nor did she refuse suit summons. By doing so, the initial burden shifted back to the
What is
respondent.
this finding?
My lord, there are 4 judgments of the Supreme
What is
Court.
this
my lord,
finding of
and-
the court?
No, my
How
lord.
can the court give such a
He
finding?
came
Burden
to-
lies on you. So just you come to the, you enter the witness box and say no, then the burden shifts on them. How can it be?
That's what, my lord, I need
That,
some time. I will file my statement of
that finding
objection.
itself is wrong.
Maybe, my lord, I need some. In Because, my fact- lord, after the restoration.
What is the delay?
Lord,
Delay, madam, because
75
it is
days
the
delay was
condition that
there.
it was served on the 2018.
75 days delay was there, my lord. Can you take page number 13?
There was 30
Page
days
number
delay,
30,
my
my
lord.
lord.
Delay was condoned.
5 judgments and 3 presumption under 3 different enactments are there, which I pointed to the court.
No, not about that. Now, the miscellaneous petition filed under ordinance and so is a subject to payment of cost of, this is a, suit is of the year,
Suit is of the year 2017.
2017.
when it was decreed?
Decree in the 2023. madam.
23.
Hmm. When he was set ex parte?
As per the
No,
record,
20.
2028.
20.
And this is filed?
In the year
Into
2023, 8/6/2023. madam.
Why there is no, why is there is no delay?
No, delay is there, my lord.
No, my lord. After
Can it
decree,
be?
my lord, what happened, my lord, after the decree, he goes before the revenue authorities, their revenue authorities inform
So according to you, from your notice, the delay, the time starts, so there is no delay.
No, my lord, there is no delay. Only when I have received the information from the revenue authorities that an application was moved for revenue entries, then, my lord, I come to know
Court
that.
cannot very casually can't deal with the application like this. Notice is served. As per the postal endorsement, it says refuse. That's for you to say that that is wrong, not for them.
That's what, my lord, I praised time to let it be listed on Monday. My lord, I file my statement of objections and on that date.
No objections are required. We are not dealing with a fresh matter where objections are required. We are only dealing with whether the order passed in miscellaneous is right or wrong. Whatever is the material there, that we will look into.
No, my lord, already case is restored. What happened, my lord? He was not a original defendant before neither a party before the trial court. During the pendency of the
This
miscellaneous petition,
reasoning
he
given
purchased
by
the
the court
property.
is wrong first. So this order has to be set aside.
Let it be taken up on Monday, my lord. I will convince my lord. I have to.
You cannot convince. List this matter as first case on Monday.
Wait. Interim stay.
Monday.
Please.
43 for orders, Naveen GS. For petitioner.
Yes.
Permitted to appear for respondent number 1, madam.
Await service of notice.
They are
For
appearing.
respondent number 1.
You appear for all the respondents?
For respondent number 1.
How many respondents are
There
there?
are 2 respondents, madam.
Who is
Respondent
the
num-
second respondent?
Second respondent is defendant number 1 before the trial court.
You are two.
I'm respondent number 1. I am the plaintiff.
Is the contesting respondent, my lords.
No notice to the next respondent.
No, my lords.
Then file a memo.
Kindly, my lords, I'll file them.
A memo is filed seeking dispensation of notice to respondent number
Two, my lords.
Who is defendant number?
2.
Memo is taken on record and
Sorry, my
notice
lords,
to
defend number 1.
defendant number 1. Memo is taken on record and notice to defendant number 1. Respondent defendant number 1 is dispensed with. Yes.
Notes, it's an application and order 7, rule 11D. Notes, therein,
Finally we have to hear it. We'll hear it some other day.
that in any date.
Matter on 11th of August. Huh? Mr. So-and-so submits that he has instructions to file wakalat on behalf of respondent number 2. 1. And so the other one is respondent number 2, defendant number 1 before the trial. Yes.
For admission, my lords, on 11.
For admission on 11th.
Cell number 44.
Appear for
This
the,
is the one that came up the other day.
yes, my lord. See, your lordship, it is a very interesting case. The whether CRP lies or appeal lies. Section 17 of the Small Cases Code only very limited. Section 35A. Section 95. Section 35A says where regarding cost. Section 95 says illegal detentions. So here your lordship will see section 19 has given the vast power to this honorable court. Any decree or order and subject is satisfaction of this honorable court. This honorable court is at liberty. So your lordship will see that Small Cases Court, I filed CRP. Your lordship is aware that I, being a widow, my husband died. It was the duty of the landlady, as he is collecting the rent from me. My son is not with me.
One question. Are you filing this CRP because court has got vast powers according to you under 227?
Section 18 power.
1 minute. And also earlier your CRP is entertained by this court. Are you filing on these 2 grounds? Or
Yes, these 2
according to
grounds.
you, what is in a normal course, what is the remedy available to the party?
Remedy available, Small Cases Court, your lordship will see. Small Cases Court, only remedy is available to me is to approach this honorable under section 18 of the Small Cases Court, 1961. No, any wrong has been done. Your lordship can call. No, I was informed that appeal, there is an amendment, notifications. All the jurisdiction has been taken away. The only city civil court, any order passed by the city civil court, that will be challenged before this honorable court in appeal when judgment and decrees pass. And single bench and division bench, that was a notification.
I will pass order. The detailed order on Monday.
Yeah, your lordship will do one thing. Monday I am not here. I am going to
But you
Pune.
won't.
24th, your lordship. Your lordship may kindly call it on 24th.
Anita, 24, this matter, no, send it to the chair. 24th for orders on IA,
Earlier.
on IA, on maintainability. Yes, next.
Cell number 45, Kevin Narasimhan, for petitioner.
For petitioner minutes, please for short date minutes, short accommodation.
Ability.
Please minutes.
Why,
Short
why
date
you
minutes.
want short date for the, on that? What is this order?
Minutes is it's in the execution petition minutes. It has been held that it is a premature execution petition filed by us minutes. That is the order we are challenging before Milord's minutes. Annexure A is the order minutes.
Page number?
Page number 13 minutes.
Page number?
13 minutes, 1-3. There was a compromise between the parties, millets. And there was a compromise
Authority
decree.
is reserved to the decree holder. Yes. The
A short date millets.
the aspect with regard to the maintainability is kept open. The petition shall comply with the office objections within a week. Notice to the respondents. Yes.
Oblige
Cell
millets.
number 46. Cell number 46.
As per the postal share,
Petitioner, Your Honor.
notice to R1 and
Kindly
R2.
extend the interim order.
I'm the plaintiff and R1 in this case, Your Honor. I received a hand summons through the council and I'll present the matter myself, Your Honor.
Then you have to appear before the committee. You have to appear before the committee. Okay. Then after they give you the thing, then only you can appear.
In the trial court, I am appearing myself.
No, here also, High Court, you have to appear here. The party in person plaintiff appear before the court and submits that he wants to appear in person. He shall appear before the party in person committee. List this matter on 29th of
Your
July.
Honor, little early or because I'm going out of
You have to go to, you have to go before the committee. There is the procedure is there.
20th to 30th, some inconveniences there.
You want it in August.
Oh, okay.
And he has urgency. Interim order has to be, for interim order I have to hear him.
Interim order.
What is the application?
See, this is actually a case for.
It's for him to say. Yes.
I'll briefly explain, Your Honor.
He'll explain. He's the petitioner.
Okay.
Suit for specific performance.
What is IA?
IA no.
Huh?
ABJ.
ABC.
That is, that is rejected or ordered?
Yeah, that is granted, Your Honor.
That is ordered.
Oh, yeah, granted, and that has been challenged by the appeal. And so the whole proceedings in the trial court has been
There is
stayed.
an interim order in this.
No, actually, the entire proceedings have stopped now.
Entire proceedings has stopped, ma'am. We need,
This is matter on 3rd of August by the time.
Fourth.
This is matter on 10th of August by the time the party, he shall, the respondent plaintiff shall appear before the party in person committee.
Cell number 47, DL Suresh.
Interim order granted earlier, it's extended. Yes.
Well,
Non-compliance of office objections, council
My lord,
submission.
I filed two applications, my lord. Both the applications were rejected.
What are the applications?
My lord, I filed an application to permit the power of attorney to appear and conduct the case. Another application to file return statement, my lord.
The two independent applications.
Yes.
Office objections,
same
sustained, the
models.
petitioner shall comply, still, petition shall file shall comply with office objections. Office objections upheld.
Case number 48, B. Prabhakar.
Petitioner. In this case, my lord, K-waiter filed a party in person K-wait before the Salon court. Then execution is pending before the court hall number 8. Then in execution petition, he engaged an advocate. They are not going to take writ petition copies. And also he has furnished in a writ, in K-wait, the address. We have sent by EMS
Any
speed
email,
post.
email is not,
EMS speed post we have sent. And also we have, the party has gone to his native place twice. He is avoiding to receive.
he has any email address. Any email address is provided.
He is
with
not
the cable.
available, he is a party in person. And
Phone number?
Huh?
Phone number is provided.
For phone number we have, for number of times we have phoned, he is not receiving.
Then have you sent a message?
Huh?
Message.
I will send, I will send a message.
Sir, the court has to tell you that you should send a
The
message.
problem is,
No problem, do it first. The petitioner shall communicate with shall send the entire, the writ petition copy by way of WhatsApp and shall file a memo with, memo. And once the memo is filed, is the matter. Yes, next.
Case number 49,
and also, I will send immediately, date may be fixed.
Less if the
Date may
memo,
be fixed.
if the memo is filed, this is matter on 23rd. Yes.
case number 50, 49, case number 49, Uday Kumar M.
Suit for partition, my lord.
What are the two IAs?
Order 18, rule 17, my lord.
Common
Reopen
order,
and recall.
Recall and it's common.
Office
Reopen and
objection
recall.
with
It is
regard
common,
to-
my lord.
It's common.
Office objection with regard to maintainability is overruled. Yes.
Suit for partition, my lord.
Mm.
The petitioners are plaintiff before the trial court, my lord. They have filed IA order 18, rule
Forfeiture?
17.
Suit is
Madam?
for picture.
Plaintiffs are
Suit is of which year?
Because there are five
17,
suits.
my lord.
2017.
There are 5 suits
2017,
clubbed
my lord.
together.
Huh?
I'll just point out what has happened. Here, we are dealing with 5 suits clubbed together.
2 minutes, my lord. My submission after.
All right. There are 5 suits clubbed
Submission.
together. So possibly not, one suit is of the year 2017. That has been treated to be as the main suit. And attached to it, there are 3 suits of the year 2018. 2 partition suits, again, 1 injunction suit, and 1 suit of the year 2021, which is again for a relief of partition. So all these 5 suits have been clubbed together, brought on the table of a single court. Now, let's say common trial is being led. Now, obviously, here in the current case, subject to corrections, there are 6 wills. And there is a question of about proof of a party.
When was evidence closed?
No, it's going on an ongoing day-to-day trial basis. It's still we are at the stage of cross-examination of DW2.
Then what is this IA to reopen whose evidence?
They
Only
So
rejected
let
my
him,
application.
let him
Yes,
argue.
yes,
Yes, where are you? Where is the order?
130, my lord.
Page
In
130.
page number 130, page, para number 2, my lord. That is the production of evidence and IS normally required to be allowed. The plaintiffs have not filed said document before commencement of evidence. After completion of cross-examination by several defendants, the IA 5 to 8 are filed. Honorable High Court of Karnataka has directed to dispose the matter within 16/8/2026. 5 suits have been clubbed. The
Your
suits
defendant
involved.
number 3 and 4.
My lord?
Your defendant number 3 and 4.
No, my lord. I am plaintiff before the trial court, my lord. The suits involved bulky files. If IA number 5 to 8 are allowed, it will open to the floodgate for delay and drag the proceedings. Though some of the defendants have submitted no objection, I am of the opinion that in view of the order of the Honorable High Court of Karnataka, it is not fixed stage to allow the IA 5 to 8. Hence, the reasons urged in IS and the contention of the learned counsel for the plaintiffs are not acceptable. Only on this ground, my IAs are rejected, my lord.
Yes.
And similar
I would have no
identical.
objection.
What about the other?
He would have.
How many are the respondents? Please come to the cause title here before the High Court.
R1 to R3, he will
Page
appear.
number.
Page number 6, my lord. Petition.
So R2, R1 to R3.
He appear for whom?
I'm R2 and on behalf of the advocate, R2 and
R2, 2 and 3. You appear for?
Look, I will be appearing for Srimati Jayashree R8.
R8. Then what about the other respondents?
They will.
Other respondent, they have filed wakalat, my lord.
Or all are served?
I might take notice for the day to Srimati Karchayani, that is R9 also. R8 and R9 minutes I could possibly appear.
Then what about notice to the other respondents?
We'll have to take hand summons or something like that and they can.
You take, we will,
Yes, my lord. We will serve the copy to the
So-
trial court
so in-
advocates, my lord.
Mr.
We'll
Already
serve the-
wakalat is filed on behalf of 2, 3 and also 6. Then council,
6.
She-
6,
she-
my
you are
lord.
yet to file.
I'll file it by the end of the day. I'll file my wakalat by
It
the
is submitted that so and so has instructions to file wakalat on behalf of 8 and 9. Petition is permitted to take out hand summons on R1, 4, 5, 6, 7, 10, 11, 12, 13 and 14 on the council appearing before the trial court and shall file a memo to that effect by 27th of July. If the memo is filed, is this matter on 28th?
Till that time, further proceedings has
No,
to be
further,
stayed.
what will happen?
Only this ground, my lord, High
I'll
Court
tell
order
what
is
is
there.
happening.
High Court direction, only my application is rejected, only on this ground, my lord. There is a direction for disposal.
Let the court go on. Once the order is passed again. Yes, next.
Till that time, further
can we
proceedings
request
has to
one
be
thing,
stayed, my
Can we
lord.
request one thing? Could the matter be on Friday? Attempt will be made not to ensure all of them are present.
Friday.
This Friday, that
Friday.
is day after.
This Friday.
Take out notices.
We'll serve
Yes, my
the trial court advocates. I think that should be enough.
Yes, my lord. Till
Friday.
that time, further proceedings
MOU.
may be stayed, my lord.
Then I'll post it in the month of September and I'll not grant any order. You're not understanding. This is matter on Monday. By the time.
Friday minutes we'll do.
How is it possible? Today is Wednesday.
We'll serve it. Even today the matter is before the trial court.
Friday I will list. If you're not able to serve, I'll
We'll
dismiss
serve
it.
minutes. We'll ensure it is served.
Or
We'll
I'll
ensure.
allow his petition.
Minutes, I am all right with allowing.
This is
also.
matter on Monday. By the time the petition shall file the memo. Yes.
Yes, ma'am.
Just call the next matter.
Then number 50,
I appear for the,
R.S. Ramesh.
in spite of service to the council before the trial court. Yeah,
Where is
not-
the memo?
Memo, I filed it before the court today. It is with me.
Registry is is directed to put up the memo filed by the petitioner. This is matter day after tomorrow.
Interim
Yes.
order may be extended.
Interim order is there.
Because
Interim order earlier granted is extended. This is matter on 19th of August. Yes, 15?
Then number 51,
Yes.
Mohan Chandra, please.
My lord, I am for the prisoner. In this case, my lord, respond number 1.
What is the objection with regard to maintainability?
Because the officer raised objection stating that the trial executing court has passed order under 21 rule 97. So writ petition is not maintainable.
What is the order under our 21 rule 97?
Because I in order object third party object has filed the application under order 21 rule 97 CPC. Thereafter object has filed memo stating that considering the said IA under order 21 rule 58 CPC. Same was noted in the also order sheet, but the trial go executing court has not at the time of passing the order, passed an order under order 21 rule 97 CPC. But no inquiry under order 21 rule 58 CPC.
So what you're supposed to, you have to supposed to seek the clarification of the order.
And I have submitted my submission also.
You're not your submissions. Order says under order 21 rule 97.
Because I have filed a memo to convert it under order 21 rule 58 CPC.
You're not supposed to seek that clarification from the court. There is a mistake in the order.
Yes.
And without doing that, you say that take my submission.
Even I submitted before the court at the time, inquiry is mandatory.
Not necessary. File an IA, necessary IA and get it rectified.
Now, once again, trial court has issued warrant also.
The objection with regard to the maintainability is kept open. The petition is directed to serve notice on the counsel appearing for the respondent and shall file a memo to that effect. And in the meantime, the petitioner shall get the clarification of the order from the trial court. This is matter on 11th of August.
Then number 52,
My lord, the warrant is also issued once again,
Vasantappa.
trial court.
What warrant?
Attachment of movable, because the property belongs exclusively to the.
Then how can that application be not under?
I am not a
21?
judgment debtor. I am not a judgment debtor.
That's why order 21 rule 97 you are. That's why the court said your objection is rejected. That is an appealable order.
My memo is not at all considered.
Just because you have to file an appeal against that, you can't change the sections.
No. Memo, in the memo also, same is noted in the order sheet also. I have clearly mentioned due to mistakes also. It was mentioned the order 21 rule 9 is.
Then number 52, Vasantappa for petitioner.
Yes.
Better to withdraw, my lord. It's an appealable order, my lord.
Memo is filed.
Certified copies may be returned and liberty to file appeal.
Memo is filed seeking to withdraw the petition with the liberty. File the appropriate petition. Memo is taken on record and dismissed as withdrawn with the liberty. Same, all the documents shall be returned by keeping the xerox. Yes. Within 2 weeks from the date of receipt of the copy of the order. Yes, 53.
Then number 53,
Time spent
Karthik.
before this honorable court.
Oh, that's why when I said 2 weeks from today, that means the
Correct.
court has.
Correct.
Yes, 53.
Bring on behalf of petitioner. It's only direction, seeking direction, my lords, to consider my application and dispose of the.
When did you file the application?
My lords, 24/3, my lords. Kindly see, my lords, page number 47 is the application.
No, date of the application is?
4/3/2026, my lord. Without considering the same, my lords, the court is proceeding further, my lords. That's why I.
Show me the order sheet.
Please, my
What
lords.
did the court do from 4/3/2026?
Kindly see, my lords, page number 38, my lords.
30?
38 is the. In meantime, my lords, so one of the advocate, my lords, for the party, my lords, has filed a wakalat without obtaining.
Let us see, when did you file your IA?
4/3/2026.
19 to 4/3/26.
Please. Operative portion at 44, my lord.
So far notices are not served on all the parties.
Please, my lords.
Hmm.
No notice has been issued, my lords, on that application, my lords.
For everything, everybody starts rushing to the High Court. I think only a court will be dealing with this. What is the urgency now for you? Any injunction operating against you?
No, my lords. One thing is that, my lords, the plaintiff, my lords, after filing the suit, my lords, have executed a GPA in my favor, my lords, registered GPA and also, my lords, agreement of sale, my lords. In the GPA, my lords, they have, my lords, given a right to, my lords, the petitioner, my lords, to conduct the proceedings, my lords. After that, my lords, they have came before the court and, my lords, have filed the memo for dismissal, my lords. And also, my lords, seeking declaration saying that we have no rights over the property and saying that, my lords, defendant number 1 is the.
When did they file that IA?
They have filed, my lords, memo, my lords, at, my lords, page number 62, my lords. 61, my lords, sorry. Subsequent to the, my lords, application filed by me, my lords, they have filed the memo for dismissal.
Please come. The petition is before this court, seeking the following prayer. When counsel for the petitioner submits that in the suit he has filed an IA seeking to implead himself. The plaintiff in the suit has executed an agreement of executed it?
Irrevocable GPA, my lords, registered GPA.
Has executed GPA, irrevocable GPA, and
Sale agreement.
as per the same, he has to pursue the litigation. However, on 2/5/2026, a memo is filed stating that the suit may be dismissed.
Dismissal with a declaration to saying that defendant number.
Want to withdraw the suit. with the liberty to file a suit for declaration. It is submitted that the IA that's filed by the petitioner in the month of March is still pending. And in the meantime, if this memo is considered, it would cause a lot of hardship to the petitioner. Hence, he has come before the court seeking a mandamus lex para, having heard the counsel for the petitioner. There is the material non-record, considering the fact that this application is filed in the month of March, and in the light of the fact that in the month of May, the plaintiff wants to withdraw the suit with the liberty to file a fresh suit, and according to the plaintiff, according to the implead applicants, his rights will be affected. This court is passing the following order: the writ petition is disposed of, directing the trial court to dispose of I number
5, my lords.
5 of 2026 within a period of as expeditiously as possible.
Right.
Yes. Complete the list.
Cell number, hearing on interlocutory applications, cell number 54.
My Lord, I appear for petitioner's counsel with leave of the court. My Lord, we have filed an LR application for the petitioner himself, which is delayed considerably. The LR application to bring the application to bring LRs of the petitioner on record is delayed considerably.
What is the delay?
My Lord, it's
CRP of 2015, it is still pending here.
My Lord, the reason was the
Proceedings are stayed.
no.
And then why don't you go before the trial court and do this?
My Lord, we didn't get notice in the original suit. We got notice in the execution. We appeared, we filed a miscellaneous, which was rejected. The miscellaneous appeal was rejected.
How much is the delay?
It's about 800 odd days, my Lord. The reason being that after the petitioner died, his children were not aware of these proceedings. The counsel in the trial court also had passed away. So when they went for legal advice,
this CRP is arising out of?
my Lord, the miscellaneous was rejected. We were placed ex parte and it was rejected. The trial court
No
holding.
interim order, nothing
No,
after, after 10, 11 long years.
May I put it this way, my Lord? In all probability, the matter will be settled. Therefore, if the application were to be allowed, I mean, I have no definite information, but they have been speaking to each other.
Where is the counsel for the respondent, Mr. Muhammad Shafiqullah?
Shafiullah.
We'll give him one more chance. No representation on behalf of the counsel for this matter. The respondent.
55. Notice.
Manoj, this is
56.
okay. Manoj, there is IA for continuation of delay also that I have filed. Delay may be condoned. The registry has raised an objection that there is 249 days.
Which matter?
55.
Huh?
55 was called.
Without notice to the other side, how the delay will be condoned?
My lords, because my entire contention is that I was placed ex parte, but the summons was not even served to me.
Yes, notice to the respondent.
Cell number 56. Cell number 56, party in person.
I'm petitioner.
Go before the committee.
Finished, madam.
Huh?
Finished.
What finished?
I've gone to the committee and it's clear.
Where is that? Who are you?
I'm petitioner 2.
Petitioner number?
2.
Why will you appear on behalf of petitioner number 1?
She's old enough. She cannot.
That
come,
cannot be the
madam.
reason. You are not an advocate, nor a GPA holder.
In the lower court, the GPA thing is there attested.
Is that?
GPA is there. In
You are appearing in the trial court also?
yes. Yes.
You have passed for an order in this regard. What is impugned order? What is impugned order?
Impugned order is dismissed.
Hmm?
Plaintiff is dismissed, but I have a few points to.
Dismissed? Your IA for under order 7 rule 11 is rejected.
Yes.
Huh?
Yes. But the trial court has not considered the correspondence between the respondent and the consultant, KIA consultant.
The order, what is this order now? The suit of the plaintiff is hereby dismissed. Notice to the respondent.
Cell number 57.
Notice.
Cell number
57. IA 1/2026 permission to prefer CRP. Who are you?
Urban Development Authority,
Hmm.
which acquired the property for formation of residential sites.
Hmm.
Then there was a consent award passed in 2006.
Hmm.
After receiving the compensation, after 1.5 years later, an application is filed before the learned civil judge seeking for a direction to the land acquisition officer to make a reference.
Hmm.
The court rejected the application, dismissed the application, but at the same time passed an order directing the land acquisition officer to make interest on solatium. No solatium is determined because entire compensation is lump sum determined by consent of parties. It was paid.
Hmm.
So therefore, the contention that was taken before the court was the
The
application.
beneficiary was not a party.
Pardon me?
You are the beneficiary.
Yes, I was the beneficiary.
Not a
but-
party.
Yes, exactly. Then I filed miscellaneous appeal, then a revision petition before this honorable court converted as miscellaneous second appeal, then once again converted as CRP. Ultimately at page 61, the honorable court said land acquisition officer cannot prefer the challenge the award, the award passed by the trial court. The remedy is by the acquiring body, that is the beneficiary. Therefore, liberty was reserved for preferring appropriate petition before the honorable court.
2026 is for seeking permission to prefer the CRP. When counsel for the petitioner submits that the petitioner is a beneficiary for whom for the purpose of the petitioner, the land was acquired. And after a delay of
Delay of 1.5 years,
1.5 years,
application under
Sought
section
for reference.
18(3)(b).
and the same was dismissed, however, that was rejected. However, the court has granted solatium, and by the time they have paid the entire lump sum compensation long back,
Solatium.
it is submitted that. Hence, the petitioner beneficiary is before this court, and seeking leave of the court accordingly. Considering the submissions made, I number 1/2026 is allowed, permitting the petitioner to prefer this revision. Notice on I number 4.
Cell number 58. RS Rajesh. Cell number 58, Rajesh.
This is regarding challenging the alienation
Yes,
domain
notice.
by the father. There is some delay.
9 notice.
Cell number 59.
Yes, 60.
Cell number 60.
Lord, I have asked for stay to day
How
after
can there be a stay in a
tomorrow.
dilemma?
Day after tomorrow is posted for evidence.
But we can't help it. Delay is 394. Yes.
Cell number 60. Leela.
For the petition, Manas.
60 appeal for the respondent. Appeals not that there's an
Manas, we filed
application.
for a continuation of delay applications. There's a delay of 6 days of delay in the.
Well, condone the
It can be
delay.
condoned.
Yes.
I number 2/26 is filed to condone the delay of delay in filing the petition. Considering the reasons stated, the delay is condoned. Yes.
Lord, insofar as that application for stay, my lord, I have not been served with the copy. My lord,
I'll be sure.
You are a KBA, sir.
I'll be serving Manas.
Serve the papers.
Please, Manas.
Anytime next week.
This is matter on 22nd,
Great.
Cell number 61.
in the first list only. Yes,
Yes, for
61.
the petitioners, my lord. There's a delay of,
Notice.
Cell
please,
number
my lords,
62.
one submission, my lords. I may be permitted to serve the advocate for the respondent number 1 in the
You're
trial.
permitted to serve the
Also, I'm
hands-
filing a memo for dispensation in respect of R2 to R39, my lords. They are formal parties. They are the defendants before the
Memo
trial.
is filed seeking dispensation on notice to 2 to 39. dispense with at the risk of appellant, then you have to take notice only on one.
Please, my lords, I'll serve the trial court
Is
advocate also.
permitted to take out hand summons on respondent number one, at the council and file a memo to that effect.
Chair number
Once memo is filed, is the matter. Yes.
number 62.
Much obliged, my lord.
Gaurav GK.
Notice.
Lords, I may be permitted to take out notice on trial
Yes,
court.
this also same. 63,
Chair number 63.
same is
Satish Chandra.
hand summons, not on 63.
63.
Notice,
Chair number 64.
notice.
Chair number 65.
Yes.
The petitioner lords had filed an application was seeking for framing of an preliminary issue.
Where is the respondent who filed the vacate stay? No representation on behalf of the vacate petitioner. List is marked in the month of September. Interim order earlier granted is extended till the.
Chair number 66. Sampath A.
For the respondent, my lord, I have filed an IA for vacating the stay that has been granted, my lords. It's a suit for the petition. If I may open, my lord, or I'll leave it to the. Because this is an impugned order is regarding the clubbing of the suit, my lord. The Honorable Trial Court has refused clubbing of the suit on simple basis that the entire cause of action is different, parties are different, subject matter of suit is also.
Let's see the impugned order.
Please, my lords. Kindly, my lords, may come to Annexure A. The Annexure A to the writ petition starts from page 15. The reasoning starts from page 18 onwards, my lords. Kindly, my lords.
Page number 15.
Page number 15. The reasoning starts from page number
Please
18
tell them
onwards.
before we go to the other particulars. OS number 477 is filed.
OS 477, the plaint may be seen at page 42, my
You
lord.
can tell the court what is the suit for.
Lord, that is a suit for partition that he has filed, seeking 33%.
Who is the plaintiff in that suit?
The plaintiff in the suit is the present petitioner, my lords.
Yes.
It is the.
You are arrayed as?
I am arrayed therein as defendant number 1, my lords. I have made a comparative chart for the for both the suit. I have made this chart.
Yes.
Yes, I am. Kindly, my lords, I made two tables, my lord, for easy comparison for this honorable court, my lords. Kindly, my lords, may see OS 477. The plaintiff is the petitioner. I have written in the bracket the petitioner. The respondent number 1 is the defendant in that case, my lord, defendant number 1. Whereas in OS 488 of 2019, in that suit, my lord, respondent number 1, I am the plaintiff, and the respondent number contesting petition is defendant number 1, my lord. Kindly see the nature of relief at serial number, page number 2 that I have made, my lords. I have also included the references as well. I have filed the suit under 2017 suit, my lords, is for seeking partition to the extent of 33% share. Whereas the suit that I have filed is for recovery of suit, my lords. Moreover, the third part.
I think the synopsis on the table is more complicated.
No, my lords. Because I'll take my lords.
It's not necessary. You please tell me what.
Please.
The way I understand it.
Please.
So voice number 477 of 2017 is for partition.
It's for
He's
partition.
the plaintiff, you are the defendant.
Absolutely, my lords.
And what is your suit?
My lords, my suit is 488 of 2019.
488 of
2019.
Seeking?
Recovery of money, my lords. It's a money suit.
What is the relationship between you and the plaintiff?
We are not related by blood, my lords. My case is that the petitioner was engaged by me as a broker for purpose of purchase of a property. The case that the petitioner has set up before the court in the 2017
partition suit. Why are you arrayed as a party?
The relation that he sets up is that on basis of an agreement of 3/5/2005, he has taken me as a benami, and on that basis, the contribution that he has made is what he's trying to seek his relief in the party. They're not family members, my lord. It is not a case of this. It's a commercial transaction that he says, in which he says that I have bought the property under fiduciary capacity. That fiduciary capacity that he has bought is what he's trying to recover, my lords, in respect of completely independent property. That is,
So in respect of the very same transaction between you, you sought for recovery of money.
not so, my lords. Because kindly, that's one of the the reasons that the honorable trial court has also given. The suit for partition, my lord, is respect of Belangumba property for 2 acres of land. Whereas, and that is of the dated, my lords, is 3/5/2016, my lords. Whereas the suit that I have filed for recovery of money is in respect of another property given to him, that is Honehali, in which I have paid him in December 2016, my lords, after 6 months. And in respect of a completely different property, I have lent him the money. Now the defense that is ought to be made is, since the main contesting parties are saying they have filed.
Please come to the order now.
Kindly,
to
my
the
lords,
order.
may come to the impugned order.
Yes.
Reasonings straight away, my lords, may kindly come to page number 19, para 8, my lords. Now, the next aspect that needs to be taken into account is whether the subject matter of these suits are also the same. As I said earlier, the subject matter of the present suit is money. That is sum of 2,17,440. This memo, my lords, is finding the 2019 where I am the plaintiff, in that he has filed the memo. Whereas as could be seen from the judgment passed in RSA so and so, the subject matter of suit in OS 477 2017 are landed properties bearing survey number 11/2F bearing survey so and so respectively. Thus, it is as clear as crystal that the subject matter of both the suits are not identical. Not only that, even the relief claimed in both the suits are different. This is one thing which has to be countenanced. Apart from the above, it is worthy to be noted that having set aside the judgment and decree in OS so and so, the Honorable High Court of Karnataka has remanded the matter for fresh disposal from the stage where it was before passing the impugned order, and has directed this court to dispose it of within outer limit of an year from the date of receipt of the certified copy of the judgment. And such being the case.
My lords, only on the ground saying that the matter has to be disposed earlier, my lords, if the intention was to,
Right from 2024, you are having a stay.
please, my lords. My lords, just because, my lords, in the interest to finish it off early, my lords, the matters
Not
will
the
be.
case. Why this two suits should be clubbed together? What is the relief in the first suit? What is the relief in the second suit? What is the connection between the two?
My lords, there is no doubt the relief sought are different in both.
But still it has to be clubbed.
My lords, because, my lords, in the evidence, my lords, all the parties will be put to the
The one
witness box.
suit is disposed against that, RSA is filed, again remanded. And that has to be clubbed with this. Please come. The agreed with the order passed on memo dated, what is the date of this order?
No, the impugned order is dated 31/7/2024.
31/7/2024. The plaintiff and OS number 477 of 2017 is before this court. The memo is filed to club OS number 477 of 2017 and OS number 488 of 2019. No, with your suit, we want his suit to be, the present memo is filed in OS number 488 of 2019 by the respondent therein to club OS number 477 of 2017. OS number 477 of 2017 is filed seeking partition in respect of the property situated at,
Bellam Gumba property, my lords.
where do you get that?
The schedule can kindly be seen, my lords, at page number 49 of the plate.
Sorry to interrupt, my lords. Just say, my colleague has started. Lords, the file is in the same court, my lord. The parties are same. Lord, the relief is different because for his case, he's filed recovery. Lords, my relief was also same on the same property.
No, that is what he's saying.
No,
It's not
same
the
property. It's the same property, my lords.
That is why I also read from the
Let's
court.
see, let's look at the plate. It
Please,
will
ma'am.
make it clear.
Please.
Now, 42 is 477 2017.
It's my suit, my lords.
What it say? To declare what is the property?
Lords, to declare, my lord.
Page 49, my lord, Bellam Gumba property, schedule.
Bangalore, Kasaba, hopefully. It's at Tumkur.
Please, my lord.
Then what about the other
Kindly
suit?
my part may be seen, my lord. It's a recovery suit. There's no schedule, but kindly come to page number 5, para number 7, the way I have pleaded, my lords.
Where is your plane?
My plaint, my lords, may kindly be seen page 22, annexure B.
22.
Please. Therein, my lords, the prayer can be seen at page 28 and the specific portion where I allege the cause of action and the reason why it has arisen.
Plaintiff says the cause of action for the suit arose. Defendant realized the funds issued by the plaintiff and thereafter failed to accomplish the agreed project.
And at para 7, I have specifically stated why this money was paid, my lords. The plaintiff states the defendant have realized the above money, the 1.44 principal.
It is when the dates are 12/12/2016.
Please.
And the money that these basis on which the suit that the petitioner has been filed can kindly see in cause of action is 3/5/2016.
It's para 4, my lords. There.
2016. That, my lords, may kindly, the entire basis on an alleged agreement. So almost there's a 6 months gap between the two, my lords. That is the reason I say the suit are different. And
That's the para 4, the properties, my lord. The case is that, my lord, his name, properties are purchased in his name. My lords may recollect, one matter is argued before your lordship that is resolved by law based on the stamp duty, my lord. That Article 20 will not applicable, that's the case. The same party, my lord, there's the same case. No, it is my case that, my lord, we all 4 friends are contributed, purchase a property in his name. My lord, he executed a MOU saying that we all contribute, we all develop, we'll sell the sites. Lord, that has not been done by him. That is why my case, my lord, seeking declare that as per the agreement, I have some share. Lord, he comes and says, my lord, he has made some investment to me that has to be repaid. The issue is, my lord, starts from the very project. My lord. At the para 4, my lords may kindly see the properties.
After you filed the suit when?
My lord, I filed the suit in that.
For you, the cause of action arose in the month of February 2016.
Please, my lords, because
and for him,
please,
it is on 12/12/2016.
My lords, because only when I filed, my lord, because he filed the suit. Because for this reason, my lords, in my suit, I said, my lord, the property as per the agreement, my lords, I need the share of this property. Only then he comes and says, my lord, that the property, the amount he has given to me for development of the property, that's a recovery.
But the property is not one and the same.
Same, my lords, the para 4 will kindly be
submitting that.
Lords, that
the
is wrong, my
property is in some other village.
No, my lords, para 4 may kindly see, my lord, his own plaint.
Para
4, my lord, of his page 24. Para 4, my lord. Plaintiff states that. Plaintiff state defendants introduced one Dansing and his family members who owned 1 acre 2 gunta.
Elagumba village.
Please, my lord. The same property I sought partition, my lord, because I am entitled in the MOU as per this agreement.
So come to your plaint.
Please, my lord.
That is not your.
My lord,
that is not
page
the property.
49, my lords, is my schedule. Page
let's
49.
See.
Page 14, third line, my lord, Belgumbe Grama. Same property, my lords.
What is extent?
Let's extent, my lords, 1 acre 2 guntas.
Oh,
1 acre 2
1
guntas.
minute. Let me just look at it. 1 acre 2 guntas of land in survey number 11/2/F1.
Please, ma'am. Same, my lords.
You are saying that it is different.
No, that is where I was. The para that my learned friend.
Oh, you have said some different name
kindly
also.
see para number 7, my lords, because I have introduced the prior relationship, how the parties have met. That is the portion which my learned friend reads to mislead, to say that that is the same property, my lord. That is exactly what I have pleaded. Then I say from para 6 onwards, my lord, why the money were actually given. I have now established the relationship between the plaintiff and the defendant and what basis is lent him further money in the month of December. That is the basis on which the cause of action can be pleaded, my lord. Kindly see para 5 and para 6, my lord. The plaintiff states that the real estate proficiency on the part of the defendants, one thing, inclined the plaintiff to deal with them for other projects, even though there were certain differences at the time of settlement of the brokerage fee in respect of Belanguma project. That is the earlier transaction of May, my lord. Then I say specifically why I have lent this specific money. Para 6, I'm reading at page 25, my lords. The plaintiff states that the real estate proficiency on the part of the defendants 1, 3, 5, 6, and 7 inclined the plaintiff to deal with them for other projects, even though there were certain differences at the time of settlement through brokerage fees on the date of registration of the sale deed with respect to Belanguma property. In the process, the defendants produced documents in which they were involved in real estate development and requested the plaintiff financial support or take over the entire project. Due to the rapport that developed between the plaintiff and the defendant number 1, so and so, plaintiff was inclined to render financial assistance to their project, and the defendant requested plaintiff to pay an amount of 1.44 crore, which is paid in the following manner. Kindly see para 7, for which I have paid is my specific plea for all entire money recovery. The plaintiffs and defendants have realized the above amount which was tendered by the plaintiff financial support with an intention of joining with them for the purpose of real estate development with respect to the properties at Honnehalli, which are subject of the agreement by the owners in favor of defendant 1, 3, and 6. And that is the basis on which I have paid the pay. The para which my learned friend points out is the earlier relationship, why I have got the trust on them to give the money.
But the issue is same. It is my case. The amount he paid is a contribution for the development. But he says that has to be recovered.
Clearly states about a particular village, particular land, the agreements, and the money that was taken that you have given in the month of December 2016. By the time you have already filed your suit, your cause of action is something else.
I filed a suit in the 2017. Based on the MOU, my lord, for that, my lord, the MOU, after that MOU, he also contributed, we also contributed. My lord, based on all our money, my lord, the lands were developed.
Properties are not the same.
But he comes up with different story because he wants to overcome my suit, my lord, because my suit is 2017. After 2 years, he moved this suit, my lord. He comes up with say the amount paid is not for this project, for the other project, but issue is same, my lord. But he did not say in my suit that, my lord, the property of MO, he did not say so in my suit, my lord. Same issue, my lord. The case is before the same presiding officer, same parties.
The written statement filed by him in your suit.
My lord, he has not. He stated, my lord, the properties, all the joint, my lord, joint.
No, in your suit, he said it as defendant.
One of the defendant, please.
So he must have filed his written statement.
Written, he has filed it.
What did he say in that?
My lord, he said, my lord, there in my case, my lord, there in our case is only simple, my lord. It was joint contribution. Land was purchased in his name. He says, my lord, it is out of my own money. I got the properties, and no share can be given to any of the parties. That is his case, my
No.
lord.
When did you file the written statement?
I have filed the written statement.
On 18/10 to 6/7/2008.
I have filed. It is filed page 51. I have filed on 18/10/2019.
Sorry,
in the 2017 suit.
No, 6/7/2018, not 19.
What did you say
18,
in that?
I'm sorry, 16/2018.
6/7/2018 is the
What
written.
did you say?
My lord, there my defense was that the entire basis.
I'll take this
kindly,
matter on some other day. Does this matter?
My lord, if I may just start on one small part, my lord.
1 minute.
Please.
Does this matter on 27th as first matter?
Please.
Please.
Interim order.
Interim order early
Great.
granted. Yes.
Cell number 67. Cell number 67.
67 may kindly be taken up next week, my lord. 67, I am appearing for the respondent. May kindly be taken next week, my lord.
Get that. There is an interim order.
But there is no interim order, my lord. The execution
There
is,
is no
my
interim
lord,
order.
they have filed execution against me, my lord. Susi Pepper suit is filed against 8 years old.
24 writ petition. No
Correct,
interim
my lord.
order.
They are
No.
pursuing the execution, my lord.
Who is the petitioner?
I am the petitioner.
And who has to seek the interim
So many
order?
times it came.
What
it
were you
not-
doing from
Well,
2024?
it is not reaching all this.
2024.
That from that time only it is not reaching.
No, today it has reached.
Yeah, reached.
So it must have been, it must have reached earlier also.
No, it is not reached.
It is not reached.
List this matter on 23rd. Yes, in the first list.
Much.
Cell number
68.
68.
I appear for the
Look around,
petitioner's
Sanjeev.
counsel. What has happened is that I filed a section 9 petition prior to the arbitration. Arbitration proceeded with, I had an interim order saying they should not alienate their assets. Arbitration proceeded, I succeeded. I think my learned friend is logged in, I'm not sure if he's appearing. Can I make one submission? My petition, my learned friend is appearing. But the difficulty is now this. I succeed in the arbitration. I asked for prior to arbitration protection to the extent of 7 odd crores that they should deposit. That was my claim. I succeeded to an extent of about 5.5 odd crores. They file a 34, they've not deposited a rupee. So that protection is necessary for me because otherwise I have no means of recovering my money. I point out to the court that there is a judgment of the Supreme Court that says that though you may have filed prior, even afterwards, the arbitration, you can continue your section 9.
Yes. List this matter
No,
on.
no, can I just make one submission? I require an interim order because the trial court has now said it will pass an order on maintainability, though my writ is pending.
24th, first matter. 24th on top of the list.
I'm great.
Grateful.
Yes.
Cell
69.
number 69. Panchamadi.
I beg leave to appear along with the counsel for the petition.
P. Devaraju.
Yes.
I think-
Raju, what are your instructions?
Now, my lords.
He is connected with that.
Yes, and
Another
it is also
petition.
covered, not the same, it is it is about laying these electricity poles in the land. Now, a coordinate bench of this court found that there is more than 60-degree violation in one of the connected landowners matter.
Why are we looking at all that? You have to go before the deputy commissioner.
Correct, my lords. Now, deputy commissioner has passed an order, my lords, without making me as a party. That's the point. And
Notice is issued.
no notice is issued. I am the landowner. My son is made as a party. There are 5 owners in that.
Ultimately,
Yes.
whatever you submit, I'll hear him.
Yes, yes.
That the filing of the petition, that removal of obstruction 16(1) arises wherever whoever obstruct is concerned. That none other than the son that who has obstructed initially filed a petition. That order was passed. That has been challenged before this honorable court. That my lord has passed an order during pendence of the writ petition, reconsider that. That has been reconsidered and the order has been passed. Now, my lords, that suppressing that, the mother setup has filed this writ petition, challenging the previous order. The very writ petition is pending 23 months that it is in
May I just point out-
23/7.
Let's take that also tomorrow.
23.
Please, tomorrow is all right.
List along
And
with that.
your lordship may also take this on record minutes because this is
But
with
that is
respect.
nothing to do with so far as this location
One
is
moment,
concerned.
same same service.
I will look into it when
Yes.
the matter is heard by this court.
Yes, yes.
List along with so and so. Tomorrow in the first list. Yes, call the Passover matter.
Mention matter 21. Vandana PA.
My lord, when the matter was called out, I was on my leg. My lord, and a short question.
Yes.
Sees, my lord, an application was filed, my lord, by us. My lords may kindly have page number 201. An application was filed under order 3 rule 2, saying that this execution petition, there is no board resolution.
200
My lord, page number 201. Only in 2 minutes, my lord, I'll complete it.
is appearing.
My lord, they're in caveat.
Oh.
They're in caveat. I'll not take more than another 1 minute. 201, my lord, is my application. Under order 3 rule 2.
Order is not, the detailed order is not passed.
It's not, my lord. It's
There's
not,
no
my lord. The
reasoned
Supreme
order.
Court says.
There is no reasoned order passed. I concede in that.
And my lord, in the open court, they say it is dismissed. There is no reason. The Honorable Supreme Court came down heavily on this practice.
No, that
For that
we
Supreme Court
concede.
judgment is not at all required.
Yes, my lord. My lord, this is incorrect. My lord, now, my lord, this practice has to be put to an end, my lord. Your lordship sees, in the open court, the learned judge says that the order is passed. If the orders are not ready and it is made later, kindly, my lord, appreciate one situation. The court becomes, my lord, functus officio because on that point, the order is already pronounced. Thereon, the court makes an effort to write an order. My lord, then the court is committing a serious error, my lord, with great responsibility.
No, please come to that order.
Your lordship sees, my lord, page number, the order in the order sheet, and I'm so happy, my lord, my learned friend is very fairly conceding. Page number 194, your lordship sees.
Yes.
194. This is the order. The application of judgment that are filed under order 3 rule 2 read with 47 section 151 of CPC is dismissed. My lord, there is no detailed order. And my lord, I have online, my lord, till before, my lord, I could
Happening now.
My lord.
What is happening now?
tomorrow, my lord, tomorrow the execution petition is once again kept for issuance of warrants.
What will they, no, I'll call for a report why this is happening, number one. Number two, don't do anything because they have every right to question that order. Without that, no further steps can be taken.
My lord, my only problem here is this is a 2005 execution.
I concede all that. I concede all that.
21 years delay, my lord. There was enforceability where they had challenged.
I'll list this matter on Monday. This is matter.
Will not
on-
take any steps
No.
until then.
I'll take up this matter on Monday and I'll also pass a direction that the order copy shall be made available to the party by Saturday. Let them come up before the court on Monday. Let
And my lords will take a serious note, my lord, after this order. Later on, my lord, if an order is dictated, my lord, it is in no order in the eyes of law. The Honorable Supreme Court says Cassiavalt orders, my lord, as well the CAV orders. My lord, our Honorable High Court, my lord, that is the reason came out with a specific notification. My lord, our Honorable High Court was the first Honorable High Court, my lord, to take note of this. If an order is being dictated in the open court, my lord, no, nothing is necessary. If an order is, my lord, reserved and dictated later, my lord, the parties will wait till then. My lord, here is a case, an order is dictated in the, pronounced in the open court. Then, my lord, later, my lord, I'll only say this, my lord, with great humbleness. If your lordship should direct, it be made available. Some non-existent order which is said to have been pronounced on a particular day, my lord, would take place now.
No, I don't think so. No, what will happen? The trial court, generally, they will say, allowed, dismissed, detailed order. shall
I
follow."
understand that.
That's how it
If
comes.
it
That's
was
how
said
it
so,
comes.
my lord, detailed order to follow later. I have absolutely no issues, my lord. My lord, we have been seeing that practice. Detailed orders sometimes, my lord, in matters of bail, etc. Your lordship should simply say dismissed. And my lord, detailed order. My lord, if that is the case, we have no issues. But my lord, the appealable orders, it is said it is dismissed. And the next course is, my lord, furtherance of execution petition. The detailed order is not even there.
Please come. Can the senior counsel representing the counsel of the petitioner submits that they have filed an application before the trial court under order 3 rule 2 read the section 47 and 51 CPC that came to be dismissed by order dated
Well, it is by an order dated 1/7/2026.
7/2026. It is the grievance that so far the order copy is not the order copy is not uploaded. And the court is proceeding with the matter. Land counsel appearing for the caveator also does not dispute the fact that the order copy is not so far uploaded. Then we'll do one thing. I'll post it on Monday. In the meantime, I'll call for a report.
Greatly obliged. My lord should call for a report. My lord. It is my humble request, my lord. If your lordship should make this observation in one of the cases, my lord, at least, my lord, it would be, my lord, it would be a directory for the other cases. Otherwise, my lord, this will continue.
My humble submission is, let there not be any stay. I will not take any further steps.
No,
my
I'll
lord.
record you, sir.
Yes.
Well, learned friend is
may be
fair on
called.
that, my lord.
I have no.
The registrar judicial is directed to call for a report from the concerned court with regard to the submission that's made by the learned senior counsel. Call for a report from the city civil and session judge, Mohali, Bangalore, in respect of execution case number 15180 of 2005, IA number under
14.
IA filed under order 3 rule 2 redress section 47 CPC dated 1/7/2026. Next para. Land counsel appearing for the respondent submits that this is a execution of the year 2005. On one pretext or the other, the proceedings are dragged on, and it is submitted that till the matter is pending before this court, or till
Monday,
till the report is placed before the court from the concerned court, they will not precipitate the execution.
Yes, my lord.
Greatly obliged. Greatly obliged.
This is matter on Monday, listed on the top of the list.
I'm sorry, my lord, I did not mean to cast aspersions on the system, my lord.
No.
But, my lord, what's happening is, my lord, sometimes, but even the lawyers are being questioned, my lord. Why you have not filed appeal, etc., my lord. Even the lawyers are being put to some kind of a distress. I'm so greatly obliged.
In this month, this is the third case I'm coming across.
I'm greatly obliged.
Obliged. One submission, my lord.
All court officer, I instructed her, please.
Court officer, hello. Interim orders.
Sir, wherever interim orders are there in list number 2, it will be extended and date is assigned in the month of August. ನಿಮ್ದೊಂದು ನಾಳೆಗೆ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ ಸರ್. ನೀವು ಬೆಳಗ್ಗೆ 10:00ವರೆಗೆ ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ. I will repeat it tomorrow.
ಇದು ಡೇಟ್ ಆಟೋಮೆಟಿಕ್ ಬರುತ್ತಾ?
Sir?
ಡೇಟ್ ಆಟೋಮೆಟಿಕ್ ಬರುತ್ತಾ?
Dates in the month of August.
Madam.
Madam, I assigned the dates.
16 ನಮ್ದು.
Madam.
Serial number 1 to 4. Sir?
List number 2,
ಆಯ್ತು, ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿವಿ, ಬೆಳಗ್ಗೆ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ. ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಆಗಿದೆಯಾ? ಒಂದ್ ನಿಮಿಷ ನಾನು ಡೇಟ್ಸ್ ಹೇಳ್ಬಿಡ್ತೀನಿ, ಆಮೇಲೆ ನೀವು ಸ್ಪೆಷಲ್ ಸಬ್ಮಿಷನ್ಸ್ ಇದ್ರೆ ಆಮೇಲೆ ಒಂದ್ ನಿಮಿಷ. ಯಾವ್ದು ಸರ್? ಅಲ್ಲ, ಆರ್ಡರ್ ಆಗೋಯ್ತದು. ಅಲ್ಲಿ ಬಂದಾಗ ಹೇಳಿ ಬಿಡಿ. ಒಂದು ಕೊಟ್ರ 2 ನಾವೇನ್ ಮಾಡಬೇಕು?
Court officer, list number 2. Serial number 36.
ಹಲೋ ಹಲೋ ಸರ್ ಯಾರಿಲ್ಲ ಯಾಕಂದ್ರೆ ಆಮೇಲೆ ವಿ ಸಿ ಆಫ್ ಮಾಡೋದ್ರಿಂದ ಅದೊಂದು